Senate will come to order. Before we get started today, we have a brief procedural matter, understanding that this will be the third legislative day of this special session. The first day was in November, the impeachment trial or impeachment hearing in the House, and then in April, for a couple different reasons, that day was not adjourned. So the first thing we'll do today is adjourn from Legislative Day 2. So don't get up and leave. That's just so that we can start this third legislative day. Madam Secretary.
Senator Kamak moves that the Senate Court of Impeachment do now adjourn the second legislative day.
All those in favor of that motion will say aye. Aye. Opposed, nay. Motion carries. I'll give an appropriate pause. Senate will come to order for the third legislative day on the Court of Impeachment. The prayer today will be offered by Reverend Craig Wexler, and then I will lead in the pledge.
The Lord be with you. We begin with these words from the prophet Micah. And he has told you, O man, what is good. And what does the Lord require of you? But to do justice, to love kindness, and to walk humbly with your God. Gracious God, we come before you today. We are here to do work we've never done before. So with that, Lord, we ask you to give us the gift of patience. Lord, we also, as we come to gather in the name of justice, Lord, we do pray for the family of Joseph Beaver, as today is another reminder, once again, in the untimely loss of a family member. But we also pray for the Roundsburg family and all of them in their time, Lord, as we navigate these decisions and the situation. Lord, we pray for kindness. Every single one of us has had moments in our life where we have been broken and accused. Help us to kindly practice our actions, our words carefully, Lord, and give us humility. Each and every one of us is a broken human being, Lord, and I just pray that you bless your countenance upon us as we take our constitutional duties seriously and as we do it with professionalism and appropriate kindness. In your name we pray. Amen.
I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Secretary will call the roll.
Senator Bolin, Breitling, Kamak, Castleberry, Crabtree, Kurd, Diedrich, Duhamel, Duvall, Foster, Reimüller, Greenfield, Heinert, Hunoff, Johns, Johnson, Klum, Kolbeck, Maher, Neseba, Norstrup, Otten, Roll, Rush, Schoenbeck, Shanefish, Smith, Stalzer, Steinhauer, Sutton, Simmons, Tobin, Wheeler, Wick, Sickman. Mr. President, we have a quorum.
Thank you. Approval of the journal.
Mr. President, the Committee on Legislative Procedure respectfully reports that the Secretary of the Senate has had under consideration the Senate Journal of the second day, All errors, typographical or otherwise, are duly marked in the temporary journal for correction, and we hereby move the adoption of the report.
Comments on that motion? Hearing none, all in favor say aye. Aye. Opposed, nay. Motion carries.
A transcript of the Court of Impeachment proceedings will be attached to the permanent record of the Senate Journal before its certification and serve as the full and correct record.
The Secretary will now administer my oath of office.
Raise your right hand and repeat after me. I solemnly swear
I solemnly swear
to act fairly
to act fairly
as presiding officer of the Senate,
as presiding officer of the Senate,
sitting as a court of impeachment,
sitting at the Court of Impeachment
to the best of my ability.
to the best of my abilities. Now the Secretary will administer the oath to the senators. Would you all please stand?
Raise your right hands and repeat after me. I solemnly swear, that in all things, pertaining to the impeachment trial, of Attorney General Jason Ravnsborg, I will do justice, according to law and evidence. Thank you.
Ladies and gentlemen, I'll get us started with some opening comments. This Court of Impeachment was convened on April 26, 2022 by the adoption of Senate Resolution 701. The authority for this trial is South Dakota Constitution, Article 16, Section 2, which provides that all impeachments shall be tried by the Senate. When sitting for that purpose, the senators shall be under oath or affirmation to do justice according to law and evidence. No person shall be convicted without concurrence of 2/3 of the members elected. It is noted that the senators have taken their oath. Additionally, the rules for the trial of impeachment have been adopted in Senate Resolution 702 on April 26, 2022. These rules have been made publicly available on the legislative website since the date of their adoption. In accordance with the rules in Senate Resolution 702, the following is noted. First, the Counsel for Attorney General Ravnsborg has filed a written answer to the articles of impeachment on May 31st, 2022, denying the allegations contained in Article 1 and Article 2 of House Resolution 7002. In accordance with Rule 3-1, the entire impeachment file of the House of Representatives has been made available for senators to review. Each party to the trial of impeachment has provided the documents that each party intends to submit to the Senate pursuant to Rule 3-1 Sub 2. Those documents have been made available for senators to review. Pursuant to Rule 3-2 Sub 2, a party may submit additional documents to the presiding officer during the trial. Senators were given the opportunity to present questions to both parties before the beginning of the trial pursuant to Rule 3-1 Sub 3. Those questions have been organized and submitted to each party. Senators may submit additional questions to the presiding officer for any witness or party at the conclusion of each party's case presentation pursuant to Rule 4-3 Sub 8. Prosecution witnesses' subpoenas have been issued in the names of the Senate pursuant to Rule 3-3. Counsel for the respondents did not request any witness subpoenas. All documents submitted pursuant to Rule 3-1 Sub 2 are admitted into evidence. The rules allow for each counsel to have first 1 hour for an opening statement, Then 4 hours to present witness testimony, to present exhibits, and to cross-examine witnesses. And finally, 1 hour for a closing statement. There are official timekeepers located in the Senate chambers, and they will provide intermittent updates during the trial to the respective parties and the presiding officer. All witnesses will be sworn and put under oath and will appear and testify at the lower podium. For those ladies of you who are in the gallery, this is a trial, and obviously decorum must comply with the solemn occasion. It is my job as presiding officer to ensure order and that proper respect in our environment is maintained. Accordingly, I would ask you to please place your cell phones on silent or on vibrate. Please do not remove your cell phones from your pockets or your purses while we're in session. And I'd ask you to not leave your seats, if at all possible, during the trial. We'll have a number of breaks, and I would also ask you to be silent while the trial is going on. That means no talking, no outbursts of any kind, no applause. And I would also remind you all that if you become uncomfortable in the gallery, just around through those doors and to the left, rooms 412, 413, and 414, where they have closed circuit television, so you can watch the trial from there if you so wish. For the senators, I know you all know by the virtue of your oath and your service to the state that this is an awesome duty that you're undertaking today. I ask that you provide your full attention to the people involved in the process. I also ask that you remain silent during the trial, and we'll have a number of breaks through the trial when appropriate. I'd also remind you that both lobbies on the north and south side of the Senate chamber are closed, except that parties, senators, and legislative staff have access to these two lobbies. Also a reminder, I will not be granting personal privileges during this impeachment trial. So with that, thank you all very much. We shall now proceed with the trial impeachment. And also a reminder, we have a doctor of the day in the house. Just don't know if she's here yet. Teresa Borman, are you in the gallery? Okay, we will have a doctor of the day. I think she's on her way. Teresa Borman will be our doctor of the day. With that, Mr. Vargo, you have the floor for your opening statement. 1 hour. As you were, this is not Mark Vargo, this is Alexis Tracy.
Mr. President, Council, Senators, there are times when an ordinary day filled with mundane choices, tasks, and routines will be struck with tragedy, altering life as we know it. A direct result of one of those otherwise uneventful choices, tasks, and decisions. How one responds to those life-altering moments and the ones that follow, the seconds, minutes, hours, days, weeks, and beyond, define a person. Because in the aftermath, a person is generally presented a number of occasions to do the right thing. When, why, and how a person makes that choice is telling and can have a rippling effect. The night of September 12, 2020 was an otherwise ordinary day, filled with mundane moments that through a series of tasks and choices ended in tragedy. it was a response to those moments and the ones that followed, those failed opportunities to do the right thing by Attorney General Jason Ravnsborg, that bring us here today. To understand this process, we must understand the events, the moments that led us here, and are the subject of count 1 of the articles of impeachment. At approximately 9:15 p.m. on September 20th, 2020, Jason Ravnsborg, South Dakota Attorney General, left a political function in Redfield, South Dakota, to make the roughly hour and 50-minute trip home to Pierre. His departure time was corroborated by interviews of other guests from the event that identified him leaving between 9 and 9:30 p.m., and by the GPS data on his cellular telephone that placed his departure at 9:19 p.m. For the drive back, Jason Ravnsborg activated the On My Way app on his personal cell phone to earn perks and rewards for not using that cell phone on the drive. He then set that personal cell phone aside. Thereafter, Attorney General Ravnsborg, for the trip home, picked up his work cell phone, placed calls to his father, accessed email and web browsers, perused articles on the internet, all documented in the contents of that phone. About an hour into the trip, he approached the small town of Highmore. Slowing down as he passed through town, he began to accelerate as he exited the community. He passed the 65-mile-per-hour sign, passed the sign noting 48 miles to Pierre, and then looked down as he began to accelerate, likely resuming cruise control, looked over at the speedometer, fiddled with his phone, and in the midst of distraction, veered all 4 wheels of the vehicle of his car over the fog line and the rumble strip. In the midst of these distractions, wham, like a thunderbolt, he would later describe, the feeling of his car impacting something, as he would say to the 911 dispatcher. As we know, something was someone. Joseph Beaver. Joseph Beaver, who was leading his own ordinary day, full of mundane tasks. His own pickup struck a hay bale after he was reaching over for cigarettes, and he received a ride back to town, only to return back on foot to his vehicle, for reasons that today remain a mystery. Joseph Beaver, a man who eyewitnesses, other passing motorists, described seeing walking the shoulder in the night. A night that by all accounts, including the Attorney General's, was described as a very dark night. Joseph Beaver was seen walking nearly in the grass, witnesses would tell, headed west out of Highmore before coming back east on the north side of the road, presumably headed home. He was carrying a light, as described by other motorists, that shone like a beacon, as described by the North Dakota BCI investigator who recreated the events. Joseph Beaver was struck by Attorney General Jason Ravnsborg as he accelerated out of Highmore, traveling over that fog line at approximately 68 miles per hour upon impact via the South Dakota Highway Patrol Crash Reconstruction Report, which is consistent with that GPS data from the Attorney General's work phone, putting him at 67.6 miles per hour at 10:23:36, the time of impact, and 67.1 miles per hour in the 2 seconds after. Mr. Beaver died upon impact. The Ramsey County Medical Examiner noted cause of death was multiple traumatic injuries, both internal and external. The impact of the crash stopping his heart, lacerating internal organs, and created trauma to the front of his body so severe that his right leg was severed from the body upon impact and projected out into the north ditch, while the rest of his body flew up onto the front of the vehicle and his face crashed through the passenger side window. Mr. Beaver's glasses crashed with his face through the window and became a part of the debris that was projected into the interior of the car, where they would later be recovered. A partial frame in the back seat and the remaining frame and lens
on the floorboard of the front passenger seat. The body traveled with the vehicle for the 2 seconds it took for that vehicle to begin to slow. At 10:23:39, GPS phone data shows a speed of 62.4 miles per hour. So we went from that 67 to 62 in those 2 seconds afterwards. And at 10:23:40, just a second after that, the phone data shows a speed of 56.8 miles per hour. It was then, as the body is traveling with the vehicle at the heightened speed and the vehicle begins to slow, that Joe Beaver's body came off the vehicle, where the exposed bone from his leg scraped the shoulder of the road. And the entirety of his body came to rest barely in the north side ditch, just beyond a piece of vehicle debris that was dislodged and had come to rest on the shoulder of the road. Attorney General Ravnsborg was distracted, looked down at the phone next to him, the speedometer, potentially the radio, resumed cruise control, consistent with that GPS data that showed acceleration after the speed signs. Whatever drew his attention, we can say with certainty, and he cannot deny that he was distracted. And in the midst of that distraction, his tires veered over the shoulder of the road, and he struck Mr. Beaver, who the Attorney General never saw until impact. In his own words, he didn't know what he hit until the impact. It's 14 minutes and 44 seconds into that first interview. Meaning, of course, that he absolutely saw the man that he struck in the moments after. As the thunderbolt shook his vehicle and glass came crashing into the passenger side, the moments that transpired within the Attorney General's vehicle are told by his accounts as well as the physical evidence. The physical jolt of the crash, glass shattered upon the passenger seat where his personal cell phone had sat and was thrown into that front wheel well from the force of the impact. But his work phone did not. It was maintained in his possession. Attorney General Jason Ravnsborg, startled, looked up to see Mr. Beaver as he came through that front windshield. The Attorney General went into tunnel vision, as he would describe it, at 1:47:04 in the second interview. And though he couldn't bring himself to ever, in the 2-minute 911 call or the 3 hours worth of 2 separate interviews, actually say that he hit and killed a man, he knew this fact to be true. He knew it in his refusal to provide the painstaking details of those seconds that transpired after. He volunteered a litany of details, down to the verbatim conversations of the mundane, both before and after. The conversations with his father, the Twins game on the radio, how he acquired his insurance, physically removing the car keys from his vehicle to hand them to the sheriff. But the details of the most important moments in the aftermath of killing a man, he glossed over, left out, cut short. In his own words, we get glimmers of the truth of what he was thinking at that time. As he would later tell investigators, no. And I would not expect a man to be out on the side of the road in the dark like it was. 1:19:39 in the second interview. Why would a man be walking down the road? 2:04 in the second interview. Wishing and hoping that the horror of those moments weren't true, but knowing at the same time they were. And wham, my life changes, he says at 2:04:04 in the second interview. An unequivocal statement that is true not only for the Attorney General, but more so for the Beaver family. These tragic events have the potential to either be mitigated by doing the right things or aggravated by the decisions that follow. It is the Attorney General's response that we find count 2 malfeasance, wrongdoing by the Attorney General following the death of Joseph Beaver. In the seconds in the aftermath are explained not only by the no, what would a man be doing on the side of the road? but are also demonstrated in the investigation that shows via the GPS locator information on the Attorney General's work cell phone that he began braking at 67.1 miles per hour mark. And for the next 7 seconds, he slows down to just 11.9 miles per hour, braking moderately. It took another 7 seconds for him to slow from the 11.9 down to 8 miles per hour. More of a coast. 2 more seconds to go from the 8 miles an hour to a complete stop at 10:23:54 p.m. This was not a screeching halt, even though that's how the Attorney General described it in his first interview with law enforcement just days later. I immediately jumped out of my car and dialed 911. He slowed to a stop and gathered his thoughts about what to do next. At 10:24:22, the Attorney General initiated the 2-minute 911 call, where instead of leading with, "I'm south of Highmore and I've been in a crash," he leads with, "Well, Allie, this is the Attorney General." Senators, this is not the first time, but you can assure it will be the last time that he uses his title in an attempt to set the tone and gain influence. As seen in the evidence submitted to you today for the proceedings of other occasions of traffic stops, as well as the interviews from this case, it is routine for him to use that title, and it's one of his first go-to lines. He continues to use that title throughout his interviews in the investigation. You have it in your evidence, but we'll show it to you here today.
Allie, Allie, I'm the Attorney General.
Being a statewide official, I had pictures taken with people, and I have pictures of me on the stage.
Is there any reason why you're traveling that fast? I'm going to drill and I'm commander.
I regularly tell Tim and Dave where I'm at.
Okay.
As Attorney General.
Are you law enforcement involved with this?
Okay, state car. Okay. Actually, the Attorney General.
And then just that I am the Attorney General. Availability. I call and I said, "I am the Attorney General." "Who is this?" is the response I get. I am still the Attorney General. You're Attorney General, you're always running. Something to the effect of, "Hello, 911, this is the Attorney General."
Okay, so my other thing is, I'm also the Attorney General in South Dakota.
He reminds the North Dakota BCI that he is the Attorney General when they want to conduct an investigation on his phone. Senators, any new prosecutor out there knows that that phone is evidence and needs to be reviewed. Going back to the 911 call with dispatch and the statements that followed, Jason Raunsberg advises that he hit something. Doesn't say he hit a man. And the dispatcher specifically asks him if he thought it was a deer. The Attorney General responds, it's still fresh on his mind at this time, "I have no idea. Yeah, it could be. And it was right in the roadway." 2 statements that are completely disproven by the evidence. He doesn't volunteer anything like, "It sure looked like it might have been a man," or an attempt to provide additional information. As a child, my mother used to call those lies by omission. Other noteworthy statements by the Attorney General's response: dispatcher, "Are you injured at all, Jason?" Attorney General, "I am not, but my car sure as hell is." And then he doubled down on the middle of the road statement with, "I'm out of the roadway. I was able to get over. It sure hit me, smashed my windshield." The dispatcher advised that she'd be sending the sheriff, and the call ended at 10:26:44 per data from the Attorney General's phone, corroborating and consistent with the 911 recording. Following that call, the Attorney General was alone on the side of the road in the pitch black night. And he turned his phone light on to scan the ditches, as he would later say. The phone corroborated the use of that flashlight at 10:26:59 p.m. to 10:33:15 p.m. 6 minutes, alone, in the dark, roadside, scanning the ditches. left to process. Time to walk up to the large piece of debris that is located past Joe Beaver's lifeless, mangled body, meaning to get to that piece of debris, he would have had to walk on the shoulder 3 feet away from his body. And he turned around and passed it again as he scanned the ditches with his phone. 6 minutes before the Attorney General returns to the front of his vehicle, as shown by his phone data, 10:33:15, the phone light goes off. 10:33:22, he takes the photo that is saved to his phone of his vehicle, and 10:33:25, his GPS location data is confirming him in the vicinity of the front of that vehicle. At 10:34 p.m., his phone registered a call from that work phone of his to the personal phone that had remained in the vehicle but slid to the floorboard during the crash. Would have been nestled amongst the broken glass from the windshield and the frames of the glasses. Sheriff Volek arrives. Believing that the Attorney General hit a deer and not a man, the sheriff conducts a mediocre investigation at best, gathered the Attorney General's information for formalities, registration, and insurance, and subsequently sent the Attorney General home in the sheriff's personal vehicle. The Attorney General was once again headed back to Pierre by 10:54 p.m. And at that time, while driving, he sends a photograph, text message of his vehicle's damage from that work cell phone to his Chief of Staff, Tim Borman, and the Division of Criminal Investigation, DCI Director David Natvig, roughly a half hour after the crash, back on his phone. The next morning, Sunday, September 13th, 2020, Attorney General Jason Raunsberg traveled back east to Highmore to return the Sheriff Volek's vehicle. Tim Borman, the Attorney General's Chief of Staff, followed. After filling up in Highmore, Jason Raunsberg travels the same path out of Highmore that he had traveled just the night before. And he decides to stop by the large piece of debris from his vehicle that remained on the shoulder. 23:33 into the first interview, he says, "That's where I knew approximately to look." Jason Raunsberg gave the North Dakota BCI investigators varying reasons for why he stopped. To check and see if this deer made it or what happened by checking on the other south side of the road. 22:43 into the first interview, though he stops on the north instead of the south side of the road. He went back because the debris was still there. 1:37:58, second interview, but he didn't clean up the debris. Went back because he was curious how it all played out. 1:38:26, second interview, but he knew how it all played out. The Attorney General sent his Chief of Staff to the right, east, away from the car debris and Joe Beaver's body, and Jason Raunsberg himself headed to the left, west of that debris, where he virtually immediately saw Joe Beaver's remains. He articulated to officers in those moments that he thought he saw a fawn or deer in the ditch. 23:50, first interview. Out of respect for the victim's family, we are not going to publish those photos to the public. But in order to evaluate the integrity of that statement, Senators, we would encourage you to look at those photos of Mr. Beaver's body when provided. And then Attorney General Raunsberg, instead of calling 911 again, like he did the night before when he thought he hit something, he and his Chief of Staff left the crime scene, abandoned Joe Beaver, and returned the sheriff's vehicle, brought the sheriff back personally. We have no recording of that conversation the way we would with a 911 call. We only have the Attorney General's account and the sheriff's report. The sheriff returned with the Attorney General and his Chief of Staff. They pointed out Joe Beaver's lifeless body, and they left the crime scene per the sheriff's direction and headed back to Pierre, while the sheriff began contacting other agencies to investigate. The Highway Patrol responded to conduct their crash reconstruction investigation. Evidence was preserved, documented, and estimations made. The North Dakota Bureau of Criminal Investigation, BCI, the counterpart to our DCI, agreed to be the conflict agency to send agents down to conduct the criminal investigation. Witnesses were interviewed, surveillance footage tracked down, scene processed, evidence collected, photographed, drone photographs were provided for aerial view. The Attorney General's car was processed for evidence. Inside and out, an autopsy was conducted. The Attorney General was interviewed on 2 separate occasions by BCI agent Joe Ahrens and supervisory agent Arnie Rummel. The first time occurred on Monday, September 14th at approximately 1:30 p.m., 2 days after the crash. Keep in mind that the Attorney General unequivocally knows at that time that he killed a man. It's interesting to reflect on that and watch that interview. The second interview is just over 2 weeks later on September 30th, 2020, at approximately 2 o'clock p.m. He knows they processed his cell phones by then, and everyone is now aware that he hit and killed a man, not a deer. I wish we had time to play for you the entirety of those 2 interviews. The first is approximately an hour long, the second is 2 hours long, and we simply don't have the time to do that today. But I would encourage you all, if you haven't done so already, I know it'd be a late night, but these are important proceedings. I would encourage you to spend the 3 hours really watching those interviews and listening to the statements that are made. Because everything you need to know about count 2, coupled with the physical evidence, is contained in those interviews. Among the misleading statements and outright lies, the Attorney General tells law enforcement officers who interview him that he maintained in both interviews that he was in the middle of the roadway, not consistent with the crash investigation, the physical evidence, not consistent with other eyewitness accounts, not consistent with the lane driving conviction that is now on his record, maintained he was never on his phone. The phone itself says otherwise. And even after being confronted by the BCI in the second interview, he attempted to deny and minimize that fact. It's not consistent with the operating motor vehicle while using mobile electronic device conviction that is also now on his record. He maintained he thought he hit a deer. He advised that while he was on his phone with dispatch, he went all the way back to the piece of car debris to check the Highmore sign. That fact came afterwards, if at all. Maintained that he never saw Joe Beaver's body, even though he would have walked right past it to get to the debris, and afterwards as he's scanning the ditches with his phone. He maintained to the public in the aftermath that he attempted to reach out to Joseph Beaver's family to apologize immediately afterward. But he told another story to investigators. As if attempting to utilize his title and the lies weren't enough for malfeasance, while the investigation was pending, Attorney General Raunsberg continued to use his position as Attorney General during the criminal investigation to have his chief of staff line up a blood draw for him, to bide time before turning his cell work phone over, one the taxpayers pay for. Because in his words, I am still the Attorney General. He turned over his personal cell phone first. To question his employee, an employee of the state of South Dakota, ICAC Director Brent Gromer, about what BCI investigators will find on his phones. And use DCI Director David Natvig to question another employee of the state of South Dakota, employee Tyler Newharth, polygraph examiner, about what the results of a polygraph might reveal. As you consider all of the evidence in this case about the facts and circumstances surrounding the death of Joe Beaver caused by the Attorney General, and the Attorney General's multiple opportunities to do the right thing, the evidence will show that wrongdoing by the Attorney General is even more significant than malfeasance by other public officials. It is a crime for any person to lie to law enforcement. SDCL 2211-9 sub 3 defines false reporting as any person who makes a report or intentionally causes the transmission of a report to law enforcement authorities which furnishes information relating to an offense or other incident within their official control, knowing that such information is false. There's a constitutional right to remain silent. It is a crime to lie to law enforcement. Telling a lie to a federal official would have been a felony under 18 U.S.C.A. 1001 sub A. Beyond any person lying to law enforcement, an attorney is required by statute, pursuant to SDCL 1616-2, to possess, quote, good moral character. The in-rate discipline of Torno case from 2013 in paragraph 36 underscores that attorneys admitted to the practice of law have a continual and ongoing obligation to meet these requirements on a daily basis. Further codified in South Dakota law, chapter 1618, appendix, provides South Dakota rules of professional conduct for attorneys in this state to follow. Rule 8.4 defines, it is professional misconduct for a lawyer to, B, commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Subsection C, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. D, engage in conduct that is prejudicial to the administration of justice. E, state or imply that an ability to influence improperly a government agency or official, or to achieve results by a means that violate the rules of professional conduct or other law. Not all lawyers are elected officials, naturally, but this one is. And a prosecuting attorney is held to an even higher standard. In the first comment of Rule 3.8, special responsibilities of prosecutors, a prosecutor has the responsibility of a minister of justice and not simply an advocate. By statute, the Attorney General is the state's top attorney and chief prosecutor pursuant to 111.1. The Attorney General serves also as the state's chief law enforcement officer, with statute directing that it is the Attorney General who oversees the Law Enforcement Standards and Trainings Commission for all law enforcement officers in this state, pursuant to SCCL 23.328, 23.328.1. He shapes the standards of conduct for all other law enforcement officers by this statute. The standards set for the Attorney General are and should be higher standards than the average person. His role is one of the most powerful in the state. And to quote Uncle Ben, with great power comes great responsibility. Senators, the conduct of the Attorney General in the aftermath of the death of Joe Beaver had the potential to mitigate tragedy, and instead it aggravated those offenses. A man lost his life due to the Attorney General's distracted driving in these seconds, minutes, hours, days, weeks, and beyond that has transpired. The Attorney General has had countless occasions to do the right thing, and at virtually every opportunity, he has chosen not to. He's used his title in an attempt to gain influence, lied, misled, and misdirected law enforcement officers, committed crimes of dishonesty, utilized resources within the Attorney General's office for his own personal gain in this criminal investigation. And at the conclusion of these proceedings, after you spent the last number of weeks poring over the evidence, spending the next 8 hours plus reviewing key portions again, the prosecution will ask you, senators, to sustain the articles of impeachment against the Attorney General, both as to count 1, the misdemeanor offenses that led to Joe Beaver's death, including lane driving and careless driving offenses, but perhaps more important as to these specific proceedings, the countless occasions of malfeasance of office that followed and are the subject of count 2 that should be sustained. Thank you.
Mr. Garber, you have 1 hour for opening statement.
Good morning. My name is Ross Garber. I practice law in Washington, D.C. and Connecticut, and I'm here assisting Mike Butler in the defense of the Attorney General. I also teach impeachment and political investigations law at Tulane Law School and have represented over the past 20 years 5 governor's offices in connection with formal impeachment proceedings. So what I'd like to start by doing is spending some time talking about why we're all here today. And that is not a criminal case, it's not a civil case, it's not a traffic matter. This is an impeachment and removal proceeding. And make no mistake, members of the Senate, what you are here for is incredibly rare in the American experience. As you know, no elected official in South Dakota has been removed through the impeachment process in the entire history of this state. You may also know that not a single federal executive branch official in the entire history of the United States has been removed through the impeachment process. In the entire history of our country, in all of the states, in fact, only 8 governors have been removed. All the states, the entire history. In the modern era, which I define as since 1929, only two governors in all of the states have been removed through the impeachment process, and only 5 other state officials have been removed through the impeachment and removal process. You think about how many governors, how many state officials have been elected. This is incredibly rare, what's being contemplated here. I have found no record of any attorney general, certainly in the modern era, any place in the country being impeached and removed. And I have found no situation in the modern era, certainly, where an official, an elected official, has been removed for conduct not integral to the performance of their office. And so let's think about some examples. What gets an elected official, somebody who voters go to the polls and elect for a term of office, what gets somebody removed by a legislative body? I'll give you just a few examples, and there aren't very many throughout history. For example, 1941, the Massachusetts Governor's Council, Daniel Coakley, was removed for selling pardons. That's the kind of thing that gets an elected official chosen by the voters removed from office. In 1988, Arizona Governor Evan Meacham was removed from office for loaning $80,000 of state money to a business that he and his wife owned. That's the kind of thing that gets an official removed. In 1994, Missouri Secretary of State Judith Moriarty was removed for using her office to help her son in an election. In 2005, the University of Nebraska Regent David Hergert was removed for misconduct in his campaign for office. In 2009, Illinois Governor Rod Blagojevich was removed for trying to sell a United States Senate seat. That's the kind of thing that gets you removed from office. And notably in that case, the Senate in that case was unanimous. It was not a close call. The Senate acted unanimously because it is quite a thing to reverse the will of the voters. And the Senate in Illinois acted unanimously in doing that. Here's a situation that didn't warrant impeachment and removal, and that was a formal impeachment investigation of the governor of South Carolina, Mark Sanford. In that situation, there was a formal process because the governor of that state left the state, didn't tell anybody where he was going, ditched his security detail to carry on an affair in South Carolina. I represented the governor's office in that case, and the legislature made the decision that that conduct was not good. It was not acceptable. It was not appropriate. But it did not rise to the level of impeachment, and Governor Sanford was not removed from office. He was censured but not removed. And here's why. Here's why it makes sense that these things are so rare, that the standard is so high. And that's because of the Constitution. The Constitution of South Dakota is much like the Constitution of the other states, is much like the Constitution of the federal government. And there are three principles in play here. It's not just the impeachment clause. We're going to talk about that in a second. We have separation of powers, separation and balance of powers principles. We have the principles in the Constitution regarding elections in terms of office. And we have the constitutional provisions related to impeachment. So let's start with separation of powers. Under the separation and balance of powers in the Constitution, it's one of the geniuses of the American constitutions, we have co-equal branches of government. The executive branch is co-equal to the legislative branch. The executive branch doesn't dominate the legislative branch. The legislative branch doesn't dominate the executive branch. And so, for example, this is not a parliamentary system of government. This is not a system of government. We see it sometimes in parliamentary systems like England, where the legislative branch holds a vote of no confidence in the prime minister. We don't have that here. And that's because the legislative branch and the executive branch are co-equal. The legislative branch doesn't oversee in that way the executive branch. And the framers of the US Constitution were actually very concerned in structuring the federal Constitution about creating a system where the legislative branch would have dominance over the executive branch. And keep in mind, what you do over the next couple of days could have implications for government in South Dakota, for the history of South Dakota, for the interplay between the branches of government in South Dakota. And so I'd ask you to please keep in mind those separation of powers principles. The second notion, constitutional notion I mentioned, was elections. Again, genius of the American system. In South Dakota, as you know, you elect your attorney general. Voters go to the polls every 4 years. It's built into the Constitution. Voters go to the polls every 4 years and they vote. And they voted, in this case, for this attorney general. And also in your Constitution, there's a fixed term of office. It's in the Constitution. It's 4 years. The legislature doesn't have the ability to cut that term short. It's in the Constitution. It's a 4-year term. And the reason for that, and your framers, just like the federal framers, took a lot of these things into account, is that you trust the voters to make decisions. The voters get to choose their attorney general, just like they get to choose their governor. And every 4 years, a short period of time in history, every 4 years, the voters get to go back and choose their attorney general, choose their governor again. And if they don't think the attorney general is doing a good job, if they think there's a reason why the attorney general shouldn't continue to serve, then they don't reelect the attorney general. Or if the attorney general thinks that he can't get reelected, then he doesn't run. But the system trusts the voters. It trusts the political process to make these decisions. It doesn't put the legislature in a position of making these decisions. So let's look closely at the third provision of the Constitution that I mentioned, and that is the impeachment and removal provision. That provides that the governor and other state and judicial officers shall be liable to impeachment for drunkenness, crimes, corrupt conduct, or malfeasance or misdemeanor in office. In office. Now, the committee of the House that investigated this and the Nebraska Supreme Court, in the only case I could find of an impeachment proceeding involving an attorney general, noted that an act or omission for which an attorney general may be impeached and removed from office must relate to the duties of that office. Now, As the House committee noted, there is some linguistic trick you can do to read the in-office part only with respect to malfeasance or misdemeanor. But number one, I'll note that the Attorney General here is accused of malfeasance, so unquestionably, the in-office part applies there. But I'd submit it also applies to the rest of the article. I don't think it could fairly be argued that drunkenness by any executive branch or judicial branch official would warrant removal from office, or that any crime, you think of the vastness of the criminal code, that any crime at all would warrant removal of a governor or an attorney general or a member of the judicial branch from office. No, it's got to relate to the office and be integral to that office. Now, the Attorney General is accused of malfeasance. Again, in the House report on this matter, it cited a South Dakota Supreme Court case that defined malfeasance as reference to evil conduct or illegal deed, the doing of which one ought not to do in the performance of an act by an officer in his official capacity that is wholly illegal and wrongful. So as you consider malfeasance, consider whether it was integral to the Attorney General's office and whether it rose to that high a standard. So members of the Senate, we heard a lot this morning about a very tragic situation. But this is, as I noted, a very rare and solemn and unusual and weighty impeachment and removal proceeding. This is not, as I mentioned before, a vote of no confidence. This isn't a civil case. This isn't a criminal case. This certainly is not a bar case. The objective here, the issue here, it's not to punish. It's not to provide restitution. It's not to reprimand. It's not a recall effort. It's not to make a statement. It's not an employment action. This is not a censure provision. This is undoing the will of the voters. Make no mistake, that's what you're considering doing. And here's, in the case of Nixon, the House Judiciary Committee conducted an investigation and produced a report, the Rodino Report. Here's how that report put it. Impeachment is a constitutional remedy addressed to serious offenses against the system of government. Impeachment is directed to address constitutional wrongs that subvert the structure of government or undermine the integrity of office and even the Constitution itself. The committee went on, the crucial factor is not the intrinsic quality of behavior, but the significance of its effect on our constitutional system or of the functioning of government. That's the measure, members of the Senate. Federalist 65 looked at it. Federalist 65 said impeachment and removal is reserved for those offenses which proceed from the misconduct of public men, or in other words, from the abuse or violation of a public trust. They are of a nature which may with peculiar propriety be denominated political, as they relate chiefly to injuries done immediately to the society itself. That's the standard. That's the standard. And the prosecutor's burden of proof reflects that standard. It is very high. The prosecutor has the burden of proving this to you. by clear, satisfactory, and convincing evidence, a very high standard, which is why I think you saw in the case of the governor of Illinois a unanimous conviction. This has to be something that the prosecution proves by clear, satisfactory, and convincing evidence, and that constitutional standard that I discussed was met. In this situation, it doesn't exist. But I'd ask as you consider it, because it's your decision that matters, you weigh those constitutional standards. You weigh the burden of proof. Thank you.
Mr. Butler.
I want to begin by focusing on House Resolution 7002 that sets forth the two articles of impeachment. And I've asked that those be put on the screen, and I'll first focus on Article 1. Article 1, the first that you must consider, the first that you must find that the government's lawyers have established by a standard of proof that we believe is appropriate, clear and convincing evidence. It states Attorney General Jason Ravensborg committed crimes causing the death of Joseph Beaver. It then breaks it down into three subparts, focusing principally on the driving outside of his lane of travel. I want to stop now there. There has been no finding that Mr. Ravensborg was criminally culpable for the death of Mr. Beaver. This happened on September 12th of 2020. Bureau of Criminal Investigation out of North Dakota was brought in. South Dakota Highway Patrol was brought in. I believe as Special Prosecutor Mike Moore stated, as did Emily Sovell, the most investigated accident in their lifetime in the state of South Dakota. In the end, after the investigation, the charging decisions were made. A lane violation and distracted driving using your phone. The special committee rejected this as a basis for a finding that he should be impeached. Commenting on the lane change, this is a common violation that occurs each and every day in the state of South Dakota. It is insufficient for removal of a constitutional officer. And again, I go back. There is no finding here of criminal culpability in the death of Jason Beaver. None. I respectfully submit to this body that Article 1 is not complicated. It requires a vote to not sustain the article of impeachment. Article 2, malfeasance, which we know by now requires conduct occurring in office. Attorney General Jason Ravensborg committed malfeasance by the following wrongful deeds. Following the collision, he identified himself by his official title, made a direct misrepresentation to the dispatch officer, misleading first responders as to the crime he had just committed. If you want to assume for a minute that was done while in office, which my assumption is for the sake of discussion, not because I believe it, I hope that you do listen to the 911 call. Don't accept my interpretation of it. Make your own. He did identify himself as the Attorney General, said that he had struck something, was asked if it was a deer, and he said it could have been. Now, according to the government lawyers, this somehow gained an advantage for him, was a misuse of his power. Folks, he called 911. They dispatched Sheriff Mike Volek, who was there within minutes. He lived nearby the accident. Sheriff Volek arrived at the scene. They both walked up and down the area of the road and ditch. Mr. Volek, when he was interviewed, said, "I would have walked right by where the body was in order for me to see the small light that he did see." Sheriff Volek said, "I did not see a body." I've not heard the allegation that Sheriff Volek is incompetent, was dishonest, or was also engaged in a conspiracy to cover up. I submit that the tragedy that did occur here was traumatic. There's no question about that. The government lawyers would have you judge him now in hindsight, but not for what occurred at the moment. And again, please listen to the audio recording of the 911 call. Listen to his first interview done on the 14th of September. Without legal counsel, he was asked to come in, and he did. Certainly the Attorney General knew of his right to counsel. He waived that right and went and answered questions. In that first meeting, they asked about his cell phones. He turned over his personal phone, gave consent. And on this point, I will say, at every stage of this investigation, the Attorney General consented to everything. Every piece of property, every piece of electronic equipment the government wanted to analyze, he consented. Those are not the actions of a man trying to conceal wrongdoing. On the 30th, let me back up. He kept his work phone. His personal phone was turned over 2 days following the accident. He kept his work phone at that time. Then, on the 15th of September, 3 days following the accident, and I don't know if you can put that up on the screen, but he went to the Department of Public Safety here in Pierre, and he turned over his work phone, gave his consent to search it. That consent did not reveal any misuse of that phone, any attempt to delete or alter any data coming off the phone. Nothing. That same day, but later, the Attorney General goes to the Mickelson building here in Pierre, where his offices are, where DCI is. He did run into Mr. Gromer, who I believe is now retired. He did ask him about the forensic technology, its capacity to capture in real time what was going on, such as use of his cell phone flashlight, would the timing be accurate, etc. He was seeking information, but he wasn't seeking advantage. His phone was turned over. The devil's in the details, but the details support that Attorney General Ravensburg at all times cooperated with this investigation, which went on for several months until February of 2021. Appearing before the House Special Committee was Prosecutor Mike Moore, Prosecutor Emily Sovell. And I've included those reports and documents that I submitted to be uploaded because they reveal a very thorough investigation. Many questions asked, many questions answered. Some questions could not be answered, including by investigators. Both prosecutors waited until the investigation was completed, then by their account, following meetings, discussions, etc., considerations of the elements of each offense that could be charged, came up with their decision. Class 2 misdemeanor lane change violation, distracted driving. The cell phone would reveal that it was no longer in use 90 seconds prior to the accident. And so while some may want to talk about it, it was not a factor in the accident. That evening, driving back from Redfield to Pierre, he spoke approximately 25 minutes with his father. He spent 5 minutes looking at headlines from political websites, and the phone was locked and off 90 seconds before the accident. Those are the unrefuted facts of this case. Any effort to twist them otherwise would be improper. When he was asked, was he in the center lane, or was he in the center of his lane of travel when the accident occurred, or in his lane, he said he thought he was. In fact, he strongly said he was. But it turns out he was wrong. The Highway Patrol accident reconstruction investigation that followed establishes that. His vehicle went off on the shoulder of the road. Exactly how far is unclear. Special Prosecutor Moore said there's no question it went off the road, but exactly how far was not clear. But we accept that finding, not here to dispute it. But I respectfully submit, and in my career it has proven to be true, that people can be involved in traumatic or tragic events and have two very different views of what happened, or believe that they did do something that later establishes they didn't. It's not proof they're lying. It's proof they're mistaken. Being mistaken is not impeachable. Being mistaken is human. And although Attorney General Ravensburg was elected Attorney General, he did not leave the human race and become perfect. He's still not perfect. But what he did here, each and every step along the way, was to provide complete cooperation. He doesn't have the answer why he was wrong as to where his vehicle is located, but he was not lying about it. And if you're going to say he knew it and he was lying, don't just say it, prove it. Prove it by clear and convincing evidence. Allegations are easily made, and it is especially true today. They're made anonymously, mean-spiritedly, but when we come here to this chamber, you have to put your name behind it. You have to answer for it. If you know he lied, don't just say it, prove it. During his second interview, Mr. Ravensburg was asked, would you take a polygraph? Now, in this case, what could you polygraph on? Was it a human being that you hit? Did you see a human being in the ditch? I think it's a pretty clear question. He responded, absolutely. I'll take a polygraph. and he said it more than once, I'll take the polygraph. A polygraph is an investigative tool. It is not admissible to prove guilt, but it is used frequently. Hence, that's why prosecutors, or I should say law enforcement, always have polygraphers on their staffs. But it is used to conduct investigations. If someone is deceiving, it'll indicate so, and they'll be confronted by it. If someone is not, they may be cleared. It's a powerful tool. Mr. Ravensburg, the Attorney General, when asked, so if we arrange for a polygraph, you'd be willing to take one? Absolutely. I'll go to North Dakota. Hell yes, I'll go. I'm willing. But no polygraph was ever offered. When the polygrapher from North Dakota was here before the special committee, he was asked why. And he opined that, well, I discussed it with some others, and we concluded that even if he's telling the truth, it'd probably show he's lying. I can tell you, I've never heard that before. A qualified polygrapher understands that everybody under investigation believes somebody thinks they might be lying. But it's their skill as a polygrapher that is supposed to be able to discern that and eliminate that from the consideration. An alternate view is, well, what if he passes? Are we better off just not knowing so we can make an accusation that he really can't answer? I say you knew, but I didn't know. I didn't see it. I say you did, but I didn't. And back and forth it goes. A polygraph and its results would have appeared in the investigation. As we go through, or the government goes through its case, establishing on each article its proof, clearly and convincingly, I'm going to ask that you listen carefully and ask how it supports each of the articles, how it establishes that a crime that qualifies as impeachable was committed, and malfeasance in office. In considering that, here is a definition provided by our state Supreme Court on the meaning of clear and convincing evidence, evidence that is so clear, direct, weighty, and convincing as to allow the trier of fact to reach clear conviction of precise facts at issue without hesitancy as to their truth. That is a high standard, as it should be. Now, I do respect that your task here is a weighty one, but I also respectfully submit it's not a difficult one. We shouldn't be here. As the addendum to the report filed by the special committee indicates, undue influence was brought to bear on the prosecutors to charge something more serious. Undue influence was used to persuade members of the House of Representatives by robocalls, by billboards. The special committee asked that it stop. The head of the Department of Public Safety, Mr. Price, was removed from further discussions with those involved in the investigation because of his efforts to unduly influence the outcome. Now, that's wrong. I trust that the line has been drawn, and that will not occur here. We know that the public may not understand exactly what impeachment entails. We understand that. And they have opinions, but they're not fully informed about what must be found specifically in our Constitution, by what standard of proof, and does it apply in each of the articles. If you follow that and you acquit the Attorney General, you can hold your head high because you did the right thing. Thank you.
We are going to take a 15-minute recess. And this clock is stopped, so I don't know if there's a message there. 15 minutes. Mr. Vargo, you may call your first witness.
Is my mic? Oh, whoa, there we go. Sorry, it has an on and off and a volume, and I wasn't familiar with those, so thank you, sir. So our first witness will be Sergeant Kevin Kinney of the South Dakota Highway Patrol, and I believe LRC is summoning him from the witness room. Sergeant of Arms, that is.
Raise your right hand and repeat after me. I do solemnly swear that the testimony I am about to give in this matter is the truth, the whole truth, and nothing but the truth.
Sergeant, would you please introduce yourself to the members of the Senate?
Good morning. My name is Kevin Kinney, and I'm a sergeant with the South Dakota Highway Patrol.
How long have you been with the patrol, sir?
I've been employed by the Highway Patrol since August of 2003, so in August it'll be 19 years.
Trying to get a little closer, you know, the audio here is not very good for Bobby, so you could speak up.
And in what capacity do you presently serve with the patrol, sir?
My current position with the South Dakota Highway Patrol is that I am the director of the crash programs. So I oversee the crash reconstruction program and also the crash assistance program for the entire state of South Dakota.
Can you give us a little bit of an idea of your background, both educationally and experientially, that allows you to oversee all of the reconstruction work in the state of South Dakota on behalf of the patrol?
Sure. When I came on the Highway Patrol in August of 2003, approximately 1 year later, I started to pursue educational opportunities in regards to investigating crashes or reconstructing crashes. In 2004, I took my reconstruction course, and I was considered a reconstructionist at that time. In 2010 is when I was promoted to a squad sergeant. 1 year later, I took my current position in headquarters staff as the director of the crash programs. During that time, amongst all the different opportunities of going to training, conferences and such, I also went back to school, and I attended the South Dakota School of Mines and Technology in Rapid City starting in 2015, and I graduated in May of 2019 with my Bachelor of Science in Mechanical Engineering.
Over the years, how many reconstructions would you say that you have performed?
I don't have an exact number, but it's been hundreds.
Can you explain to us a little bit, for those of us that maybe don't do this every day, Sergeant, what is a reconstruction?
And the easiest way to describe a reconstruction is the process of putting a crash back together and determining what happened in that crash if possible. And so when you have one vehicle that's moving to another vehicle, essentially all objects want to move in a straight line. And so we look at those forces and the physics applied with a reconstruction, and we determine speeds of vehicles and causes of crashes.
And when you say that objects want to move in a straight line, is there something special or something different that you need to do to apply that to a vehicle-pedestrian crash as opposed to a two-vehicle crash?
No, the laws of physics are the same for every crash.
So can you describe in brief what happens during a vehicle-pedestrian crash in terms of the impact on the pedestrian in particular?
Sure. When a pedestrian is struck by a vehicle, you're going to have a couple different options, and some of it depends on the shape of the vehicle. A pedestrian can be projected forward. They can go underneath the vehicle. They can go up over the top of a vehicle, or they can go off to the side of a vehicle. Depending on the speed of the vehicle, will depend on what type of injuries that pedestrian would sustain in that crash.
Okay. And specifically, in the event that a pedestrian does not either bounce off to the side, or go underneath, or go over the top, in other words, if the pedestrian remains with the vehicle for an appreciable period of time, does that pedestrian, by definition, go the same speed as the vehicle for a period of time?
That is correct. If you have an object that becomes, for lack of better terms, entangled with the other object, it will gain the speed of the object that it got struck at.
So what, if anything, was your role in the investigation of this particular crash, sir?
So my role as the director of the crash programs was to come alongside of our district crash coordinator and be the on-scene or on-site supervisor to help make sure that we had all the necessary tools that we needed to complete a thorough investigation of this crash.
And as part of that, did you oversee both the collection of evidence, the taking of photographs, all of the things that would normally be associated with the reconstruction, even if you didn't do them yourself?
I was a part of that entire process. I saw photos being collected, evidence being gathered by North Dakota BCI, and I did observe that taking place.
Sergeant, I'd like you to draw your attention to a couple of different photographs. I believe they'll come up on the screen in front of you. If not, I have hard copies that we can give you. Okay. So, Sergeant, is this the vehicle that the Attorney General was driving at the time of the crash?
That is correct.
And would you explain to the members of the Senate what it is that this immediately tells you about the nature of the crash that occurred?
There's a couple things that stand out in this picture to me. One is there's a hole in the windshield, which would indicate that part of the pedestrian came through the windshield. We know that it's farther up on the vehicle, so we know that it also indicates a higher speed. And then you'll also see that there's damage to the passenger side mirror and what we would refer to as the A-pillar, which is the pillar in between the windshield and the passenger side window. You can see that there's a dent in it, meaning that some object struck that with some force to create that dent.
And moving on to the next photograph, I believe this shows a little bit more detail as it relates to the side mirror. What does that show you?
Yeah, you can see that the side mirror is not fully detached from the vehicle, but it is essentially hanging there by the wires that control or operate the mirror. And so it was also hit at some point during the impact.
Okay. From all of the evidence that you observed on scene, particularly the evidence as it relates to the Attorney General's vehicle, were you able to determine whether or not it appears that Mr. Beaver either went under or over the Attorney General's vehicle?
Based on the evidence that we have before us here in this picture, we found no evidence that the pedestrian went under the vehicle, but he did go on top of the hood and then off to the side of the vehicle.
And would it be your opinion, sir, that he fell off to the side and that would be potentially where the damage to the mirror occurred?
That is correct.
So while that we'll go to one more picture. Does this then also show the damage that was done to the lower part of the Attorney General's vehicle?
Yes, you can see that the majority of the damage is constrained to the right front of this passenger vehicle, along with, if you follow the line from the headlight down, you can see where there's appears to be dust to the right and a clearing to the clear red to the left. That would be where Mr. Beaver's leg would have impacted the front side of Attorney General Aronsberg's vehicle.
So after you've done the examination of the vehicle that's involved and knowing what little you knew at the time about the injuries to Mr. Beaver himself, what does the process of reconstruction look like from there, sir?
Well, one of the first things that we do is once we are made aware of the situation, we would secure the scene. I think it's important to collect and document and look at all the evidence that's left behind so that we can use all of those pieces of evidence, whether it be components from the vehicle that are left on the ground as debris, any type of blood that we could locate on the ground that would give us an area of impact, document each of those things by taking photographs and creating a forensic map that would later be able to be used to help us to determine that area of impact and also what would have caused that crash.
Okay. From what you knew at the very beginning, is it fair to say that you were aware that this was a crash that occurred at, for lack of a better term, highway speed?
That's correct.
And is that based in part on the traumatic injury to Mr. Beaver's leg?
That is correct.
Okay. In addition to anything associated with the victim, and you mentioned blood, and obviously we have the victim's remains, his leg where it came to final rest. Looking at this picture, number 68, does that tell you what other objects you might be looking for in the area of the crash that would inform, again, an area of impact?
Yes, it does. When you look at this, you can tell that there's significant damage done to the front of the vehicle. That would include the front bumper. Also, you'll notice that there's numerous areas on the vehicle's hood and bumper as well where there's red paint chips that are missing from the vehicle. Also, you have damage to the windshield that would indicate that there's glass breakage, and so there's a good potential that you'll also see glass at the site of the accident as well.
And so in terms of putting together the physical evidence, Would it be fair to divide that physical evidence potentially into at least 3 categories, which would be the blood, the paint chips, and the vehicle debris?
That is correct.
With reference to those 3 things, sir, during the course of the examination or the investigation that was conducted by the Highway Patrol specifically, were any objects conforming to those 3 things found in the lane of travel?
There was one piece of debris that was found in the lane of travel, which would have been just to the south of the white fog line on the northbound, or on the side that you would be traveling westbound on. So it was approximately 2 inches into the lane of travel. Every other piece of evidence that was located that evening was completely on the shoulder or in the ditch.
Okay. And is the process that you underwent next sometimes referred to in the reconstruction community as mapping the scene?
That is correct.
Okay. I would like to show you another photograph, 268. Okay, we got a little lag there. So, Sergeant, if you would, can you orient us a little bit to where we are looking here and why this is kind of the broadest angle that we'll look at, but what areas are important here?
Sure. So as you're looking at this photograph, your back is towards Highmore, and you're looking to the west. This is the lane of travel that the Attorney General would have been in as he's traveling westbound. Approximately, you'll see that there's a no passing zone sign. That's also in our forensic map. And then a little bit further down the road, you'll see it just appears to be like a yellow leg of some sort. It's off of our tripod, which is our total station, and we use that to document points of evidence, lane lines, fog lines, rumble strips, any other items that would be important to drawing that map to give a representation of that scene to somebody else.
And specifically, are you trying to create what you, I believe, refer to as trend lines?
So that's part of the process, yes. As we're documenting all the debris and all the evidence and everything like that, we're documenting those red paint chips that we're locating. We're documenting the vehicle car parts, and then Trooper Burnt, who was the lead investigator, was on his hands and knees looking for the blood evidence and locating all those pieces of blood evidence, and we were documenting those into the forensic map.
And can you describe how that works in terms of creating the trend line from the evidence that you find?
Sure. So one of the ways that I describe determining the trend line is to help us determine the direction that the vehicle would have been traveling at the time of impact. If you think of a cup of sand and you're standing on the roadway or another surface and you take this cup of sand and you throw it out in front of you, it starts very concentrated and then it slowly moves out to the left and right of that line where you threw it. Debris from a vehicle does exactly the same thing. As it hits the ground, the majority of the evidence is going to be located down the center of that line, but also it will move to the left and to the right and shape what appears to be like a V pattern, and it points back towards the area of impact.
Trooper, I'm going to try to translate this to something that maybe more of us are aware of. Is this something like what happens with a shotgun blast?
Sure, yeah. If you're shooting a shotgun, as the pellets come out of the end of the barrel, they're going to be very concentrated, but as they get closer to your target, they're going to be spread out more.
And when you're doing a reconstruction, is it normal process, normal practice to use all of the points of evidence, whether it be, again, the blood, the paint chips, or the vehicle debris?
Yes, it would be considered negligent on our part to just neglect pieces of evidence that are located on the scene.
Despite that fact, at the request of one of the prosecutors, did you and the Highway Patrol at the prosecutor's request, create separate trend lines for the blood, the paint chips, and the vehicle debris.
Yes, we did.
And when you did that, were your results any different than when you considered all of the evidence taken together?
Surprisingly, there was very little difference. When we plotted the trend lines onto the forensic map of all three of those separate items, they were within 1 degree of each other as they were traveling down the road. And so that gives us an extremely high confidence that the information we have is very accurate.
And based on everything then that you had done, were you able to reach a conclusion as to where you believed was the area of impact?
That is correct.
And I'm going to show you the next photograph, and that's 276.
There we go.
There we go. Where would you describe the area of impact as being?
The area of impact was fairly close to where we set up the total station. That's where the majority of the evidence began, and then it continued towards the west along the shoulder of the road.
And specifically with respect to the north-south variance, was the area of impact within the shoulder?
Yes, the area of impact would have been closer to the grass edge, but on the shoulder to the right of the fog line and the rumble strips that you're seeing there.
Trooper, I'm going to draw your attention first of all to the fog line, and then I believe we can see just to the right of the fog line kind of those striations. Are those the rumble strips?
That is correct. To the right of the fog line would be the rumble strips.
And then about midway through the paved section before you get to the grass, there's a darker area that seems like it's where the asphalt makes a transition between what type of asphalt that is. Is that accurate?
Yeah, it appears to me that the roadway was wider and then they laid another set of asphalt over the top of it, and so it's a transition area there.
Okay. Based on everything that you observed and your professional experience, is it your opinion that the area of impact in this case occurred in that last section between that dark line to the right and the grass?
That is correct.
And as best you can establish the area of impact, once the Attorney General's vehicle was appropriately situated for the area of impact as you determined it, would all 4 of his tires have been past the fog line?
Yes, they would have.
Would all 4 of his tires have been past the rumble strips?
Yes, they would have.
Now, Sergeant, excuse me, don't want to demote you.
We're all troopers.
Is there some uncertainty in reconstruction as to an exact area of impact? Is there a reason we don't call it a point of impact?
Yeah, there's always some uncertainty. Yes.
And I believe in presenting the voluntary presentation that was done prior to the House vote, you referenced the fact that you were 95% certain on the area of impact. Is that correct?
Yes, I referred to 95% accurate for the area of impact.
Do you have an opinion, though, as to the degree of certainty with which you can say that the Attorney General's vehicle was on the shoulder?
I do. I would say that the shoulder here between the fog line and the edge of the grass is, I believe it's approximately 10.5 feet or so. The Attorney General's vehicle is approximately 5.5 feet wide, and the area of impact happened within a foot or 2 of the grass edge, which would put his entire vehicle to the right side of the rumble strips, and so I can say with 100% confidence that he was driving down the shoulder of the road.
And because of the importance of this case and its high-profile nature, did you consult people that you might not otherwise consult specifically a gentleman by the name of John Daly.
Yes, we did.
Who is John Daly?
John Daly is somebody who's published 3 books or more, numerous articles. He has a master's in mechanical engineering, and he's been in the reconstruction field for many, many years. He teaches many classes. I've been in some of his classes that he teaches, and he's somebody that I guess I would call a mentor. That you know, he's somebody that's renowned. He's taught all over the world and all across the United States.
Okay. And when you submitted this to Mr. Daly, did he concur with your conclusions?
Yes, he did.
And specifically, did he concur with your conclusion that he would say with 100% certainty that the vehicle was entirely past both rumble strip, or all 4 tires are past the rumble strip?
Yes, he did.
Okay. We now have photograph number 99 up on the screen. The reason I'm asking you to look at that one is because of the dark object that is seen about 2/3 of the way up the photograph. Do you know what I'm talking about there in front of the trooper?
I do.
What is that?
The object that you're looking at is actually to the left of where the cursor was there. It's a piece of vehicle debris from the bumper of the Attorney General's vehicle.
And is that something that will be referred to repeatedly and is mapped on the diagram that the Highway Patrol created for the benefit of the Senate?
Yes, it will be.
Okay. And then I believe you now have picture 301, which is just a little bit further down the road with the same thing. So, Sergeant, because we're being mindful of ensuring that we aren't accidentally showing anything that relates to our victim, I'm going to ask you to take a look at 327 as soon as that comes up. And is that essentially the same area but now taken in an eastward-facing direction with that same large piece of debris?
That is correct. That is facing the east, looking back towards Highmore with the large debris piece on the shoulder of the road.
Okay. Sergeant, in addition to determining the area of impact, was it a part of your investigation to also determine the braking capacity of the Attorney General's vehicle?
Yes, it was.
And we will not go into the mechanisms by which that was done. If a person driving the Attorney General's vehicle on this road engaged in what I will call full braking, first of all, did the Attorney General's vehicle have ABS braking systems?
Yes, the Attorney General's vehicle did have ABS braking.
And are they particularly efficient at braking?
Yes, they are.
Okay. And when a vehicle that has ABS brakes goes into a full braking mode, does it leave those big, dark, thick skid marks that we're used to seeing on pictures?
No, the intention of ABS brakes is to stop the tire from, or it's to prevent the tire from locking up. You get a higher and a better stopping force when the tire doesn't completely lock.
Okay. Based on the examination of the Attorney General's vehicle, can you say, assuming that he was going 67.6 miles an hour at the time of the collision, how long after full braking would his vehicle come to a complete stop?
It'd be approximately 175 feet.
And do you know how far it was down the road between the area of impact and where the Attorney General's vehicle actually stopped?
Yeah, the total distance from what we identified as the area of impact to the final rest or the stopping location of the Attorney General's vehicle was 613 feet.
Now, because this was an anti-lock brake system, were you able to determine the speed based on the physical debris or any other evidence that you gathered at the scene.
No, we were not.
However, did you also have access to some information from GPS?
Yes, we did.
From that information, were you able to determine the Attorney General's average speed between Redfield and the point of, or the area of impact outside Highmore?
Yes, we were able to do that, and it averaged between 68 and 71 miles per hour.
And in the course of doing your testing, did you also discover something about the Attorney General's speedometer?
Yes, as we were testing or doing the brake testing to check the brakes on the Attorney General's vehicle, we were verifying the speed of his vehicle going into those brake tests by radar, and it was determined that his speedometer in the vehicle was reading approximately 3 to 5 miles per hour higher than what he was actually traveling.
So if he was traveling at, we'll just pick a number, 60 miles an hour, his speedometer would have said somewhere between 63 and 65 miles an hour?
That's correct.
Thank you, Sergeant. Mr. President, I have no further questions of this witness at this time.
Mr. Butler, your witness.
Okay, Trooper, that photograph we were looking at with the piece of debris on the shoulder, you know what I'm talking about?
I do.
And that was from the right front corner of the Attorney General's private vehicle?
That is correct.
Do you know whether or not it was moved?
We have no indication that it was moved based on the Attorney General's own statements that it was there that night and that it was also there the following morning in the same location.
Okay. The photograph was taken what time of day, the one that we were looking at?
I don't know the exact time of day, but it would have been in the middle of the day.
Would you describe what the conditions were when the accident occurred?
My understanding is that it was later in the evening and that it was a dark evening out.
Was it cloudy?
Not that I'm aware.
Okay. Well, I did a little bit of homework, and it was cloudy, and it was dark, and Sheriff Bolick, in fact, said it was very dark. Do you remember seeing his statement?
I don't recall seeing that.
Okay. How long was the Attorney General's vehicle on the shoulder of the road?
Again, I don't know the exact time frame that he was on the shoulder. I don't know.
So if it was nearly instantaneous, or if it were a few seconds, you wouldn't know.
What I can tell you is that if a vehicle makes an evasive maneuver to the left or to the right, if it's an extreme enough maneuver, you will see tire marks that will give you an indication that there was some sort of extreme input in the steering. We did not observe any of that. So because of that, that would tell me that he was on the side of the road more than a second or two because he had already transitioned over to the shoulder.
Okay. What were the weather conditions that night?
Again, my understanding is that it was clear, it was dark. I'm not aware of any other weather conditions. We did look at the weather as far as wind, and there was a slight breeze that evening from what I recall.
By slight breeze, do you mean 18 miles an hour?
The 18 miles per hour that you're referring to is the highest recorded wind gust, which was not a consistent through the evening. It was one time it was recorded at that velocity or speed.
From the time of the accident until the South Dakota Highway Patrol was on the scene, you would not know how much traffic or the type of traffic that passed the accident scene, would you?
I don't have an exact count of how many vehicles would have been through the area, but it is not a highly traveled road compared to other roads in the state.
And was that considered in determining any movement of debris such as paint chips?
It absolutely was. The reason that we did, part of the reason we did the trend lines was we wanted to look at each of those 3 different components of evidence that we located, starting with the paint chips. Paint chips are smaller and lighter, and we thought, well, could the wind have affected the paint chips? Based on what we determined with it matching with the other types of evidence that we had, we can say that we don't feel that they were moved at all. Same thing with the vehicle debris. It was still along the shoulder of the road in the same type of V pattern that you see in the forensic map. And then there's also glass that's in a straight line. That's not going to move. And then the other piece of evidence that I think is probably the most convincing is the blood. The blood hit the ground. It's considered high velocity spatter. And if you know that liquid hits the ground and the wind blows, it's not going to blow it anywhere. The blood's going to stay exactly where it was. And all of those other pieces of evidence, the trend lines line up exactly with those same.
Was any of the debris specifically excluded from trend line considerations?
At one point later in the investigation, we were asked to exclude all the evidence except for the blood that was near the body against my recommendation.
And all other evidence then was included in the trend lines, such as the bolt that was found in the lane of travel?
That is correct.
Okay. Thank you. I have nothing else.
Mr. Fargo, do you wish to redirect?
No, Mr. President.
Thank you. You may call your next witness.
You hit them where they said you hit them.
But, so this guy is the guy that sits across from me. This one here. He's the one that sits across that way.
Okay. Is he the one that,
He's in charge.
he's the one that said that he knew you were on the cell phone at the time? Excellent. Okay, you have to have the rest of the operators.
Yes, he's that guy. He's the one you're at.
This is the clearances.
He's the more quiet. This is the more aggressive guy. I guess I don't know which one said which.
Oh, yeah.
Raise your right hand. Repeat after me. I do solemnly swear
I do solemnly swear
that the testimony
that the testimony
I am about to give in this matter
I am about to give in this matter
is the truth,
is the truth,
whole truth,
the whole truth,
and nothing but the truth.
nothing but the truth.
It-
Will you please state your name and occupation?
Joseph Ahrens, Special Agent with the North Dakota Bureau of Criminal Investigation.
I'll ask you to get as close as you can to the microphone. Try to speak loudly. What is your law enforcement background?
I have a bachelor's degree in criminal justice. I am a licensed peace officer in the state of North Dakota. I've been a law enforcement officer for 22 years, including time with 2 local police departments where I spent approximately 7 years as a patrol officer, and the rest of my time has been as a criminal investigator investigating various different criminal acts. I have attended the National Forensic Academy through the University of Tennessee, which is a 10-week crime scene processing school. I'm also a licensed polygraph examiner after attending the Texas Department of Public Safety Polygraph School.
In your capacity with the North Dakota Bureau of Criminal Investigation, the BCI, did you have occasion to become involved in a law enforcement investigation here in South Dakota in September 2020 regarding a pedestrian being struck by South Dakota Attorney General Jason Ravnsborg's vehicle?
Yes, I did.
How did that matter come to your attention?
I was at home and received a text message along with numerous other agents from our chief agent, who was looking to see who would be available to travel to South Dakota to assist with a vehicle versus a pedestrian fatality accident involving the South Dakota Attorney General.
What day was that?
That would have been on September 13th, which I believe was a Sunday.
And where did you respond to thereafter?
Upon me stating that I could travel to South Dakota, I ended up traveling initially to Pierre, South Dakota, where the BCI agents met up. Once we all got to Pierre, then we traveled to the area west of Highmore in Hyde County.
When you arrived, what role were you specifically assigned by your supervisor for this case?
I was assigned to be the case agent.
What does that mean?
As the case agent, I am in charge of overseeing the case along with the supervisory special agent that's on scene. We delegate responsibilities, ensure all tasks are being done, and I maintain the investigation throughout the course of it, ensuring all reports are completed and dispersed to where they need to be.
Who was your supervisor for this case?
Supervisory Special Agent Arnie Rummel.
And as you mentioned, he participated in this investigation as well?
Yes, he did.
Who did you first speak to when you arrived at the crash scene near Highmore?
When we got there, initially we met with a trooper west of Highmore that was stationed near a white pickup that was in a ditch near a hay bale. And he explained to us that the rest of the scene was further east, closer to Highmore. We then traveled to where the accident scene had occurred, and upon arriving there, myself and Supervisory Special Agent Arnie Rummel were provided information from Sergeant Kinney and Trooper Burnt.
What did you learn?
They walked us through the scene. They showed us debris that was along the road. They explained that a body had been found alongside the road, which was still there when we arrived, and they showed us the body of Mr. Beaver and stated that Mr. Beaver's leg had been amputated during this accident, and they showed us the leg, which was further in the ditch. They explained to us that the body had been discovered earlier in the morning, and that the South Dakota Attorney General Jason Ravnsborg had been in an accident the night before and had struck something at that time, but they weren't really sure what he had struck, possibly a deer, but nobody had known really, and the deer wasn't discovered at that time. It was the next morning then Jason Ravnsborg came back and discovered a body.
So what else did you do that evening to further your investigation?
Initially assigned other agents duties such as photography, flying our drones, collecting evidence. The first thing I really did was I interviewed Sheriff Mike Volek, who is the Hyde County Sheriff and the officer that had responded to the accident the night before.
How did that go?
Spoke with him at the scene, he basically explained to us that he had been called to an accident, had met the Attorney General, Jason Ravnsborg, at the accident scene, that there was damage to the front of the vehicle. The vehicle had been towed. He had provided Jason Ravnsborg with the sheriff's personal vehicle to drive back to Pier. And then the next morning, when Jason Ravnsborg brought the vehicle back, Jason reported to him that he had found a body at the scene.
Had the sheriff done up a report on that matter at that time?
He did eventually provide a report. It wasn't at that time, though.
Did you, throughout your investigation that evening, attempt to get in touch with Jason Ravnsborg himself?
Yes, that night at approximately 10 p.m. I did.
How did that go?
I called and his phone went straight to voicemail. I actually called twice. The first time I called, I did not leave a voicemail. I called back a short time later and left a voicemail to have him call me.
What happened the next day, September 14th, 2020?
North Dakota BCI agents went to the Pier Police Department. We had been advised that Jason Ravnsborg's vehicle had been towed to the Pier Police Department and was in a secure facility there. We went there with the intentions of processing that vehicle. We had a search warrant written for the vehicle before we processed it, and then once the search warrant was written, we processed and collected evidence from the vehicle.
Did you personally participate in the processing of that vehicle for evidence?
Yes, I did for a short time.
And thereafter, as the case agent, you would have reviewed the photographs and evidentiary items seized and been familiar with that entire processing?
Yes.
I want to present to you some photographs from that processing. Let's start with photograph 445-0204. Once it comes up on the screen here, I'll just ask you to advise what that photo depicts and confirm that this was a part of that processing and investigation.
Yes, this was a photo of basically the overview of the back seat of Jason Ravnsborg's vehicle.
And as you look at that photograph, it's kind of where the cursor is. Can you describe what's included in that photograph? What's noteworthy?
Yes, there's part of a pair of broken eyeglasses. So what you see there is the black frames for the eyeglasses.
Let's go on to photograph 445-0198.
This would be a photograph of the front compartment of the vehicle from the driver's side, taking a photograph of the passenger side.
Okay. And moving on to photograph 445-0212.
That is the front passenger seat floorboard. So what you see there is what I believe to be a phone charging cord, and then there is part of the broken black eyeglass frames there, and the lenses for the eyeglasses lying on the floor, and then broken glass debris.
When did you first have occasion to speak to Attorney General Jason Ravnsborg?
On September 14th at approximately 1:30 p.m.
During the course of that interview, did he tell you anything that surprised you or stood out to you?
The purpose of that interview was just to sit down with him and get a statement from him, his version of and his perception of what had happened that day. Basically, what he said is he had been driving. He had been at a Lincoln Day dinner, I believe is what they call it, in Spink, County and had been traveling back, had traveled through the town of Highmore, and shortly after leaving Highmore, traveling towards Pier, all of a sudden he hit something, didn't know what he hit.
And any other statements that he made to you during that interview that struck you?
Yeah, he made the statement that he didn't know what he hit until impact.
For the course of that interview, what did you notice about the specificity with which the Attorney General described certain topics, but not others?
He was more specific about certain topics prior to and after the accident than during the accident. During the accident, it was rather vague. Couldn't really give any detail about what happened.
So leading up to the crash, he provided details about listening to a Twins game?
Yes, he had listened to a Twins game. He was able to give some details about the dinner, what he ate.
Phone calls with his father?
Yes, 2 phone calls with his father. He had described that he had been on the phone and must have hit a dead zone, so the phone call disconnected, that he called back then as soon as he received cell phone service again, basically to let his father know that he hadn't hung up and that it was a dropped call.
He was going to stop at the gas station, but it was closed. He talked about that too?
He traveled through Highmore, was going to stop at the gas station, looked at the gas stations on both sides of the road, as there is a gas station on both sides of Highway 14 there in Highmore, and that they looked closed, so he continued on. He remembered seeing a 65-mile-per-hour sign and also seeing a sign that said 48 miles to Pier.
After he mentions those signs, do you have additional specificity about the next transpiring events?
No.
Does he reiterate the same specificity after the crash itself?
Yes, somewhat. He describes how he pulled over to the side, that the vehicle had been shaking, that he got out immediately and walked around his vehicle and then called 911.
So he mentions those markers in time, and then how specifically does he describe events after he says Sheriff Volek arrived?
He explains that when Sheriff Volek arrived, they had looked at the vehicle, checked the area, that Sheriff Volek had told him that the vehicle wasn't going to be drivable and it would need to be towed, and so Sheriff Volek took him to Sheriff Volek's house to loan Sheriff Volek's personally owned vehicle to Mr. Ravnsborg.
Do you recall Attorney General Ravnsborg demonstrating and going through where he located his insurance and his registration and all of those things?
Yeah, he explained that Sheriff Volek had asked him for his registration insurance card and that he had to reach across the center console to the glove box, but the glove box was already open due to the impact of the crash.
And he talked about his conversation with the sheriff about the Lincoln Day dinner, him leaving, and did he provide additional specificity about the sheriff having to flag him down to get the keys to his vehicle?
Yes, he explained that after he was given Sheriff Volek's vehicle, he then left the scene, and shortly after Sheriff Volek pulled him over because Mr. Ravnsborg had taken the keys to Mr. Ravnsborg's vehicle and they were going to need those to have it towed. So he explained that he then was pulled over and explained how he took the keys off the key ring. He initially gave the whole set of keys to the sheriff, and the sheriff said, no, I just want the vehicle key, and he described how he then took the key off the ring and provided it to the sheriff.
So the benign, irrelevant details he provides great specifics about, but he shortcuts the information when it's important to the crash itself.
Yes.
During this interview and as a part of the initial fact gathering, did you ask the Attorney General about the speed he generally travels?
Yes, we did talk about some speeds. He said that he generally doesn't go more than 4 miles over the speed limit.
Okay. And why did you ask about this?
Just wanted to again know about the potential of excess speed.
I'm going to show you a series of clips from that interview that you're referencing regarding speed.
So, speed-wise, you usually try to stay around the speed limit? I mean, are you...
Yes, I mean, I don't, okay. I go, if at the most, 4 over.
Any really excessive ones?
No, I wouldn't say excessive. If at most 5 or 10.
Do you have any idea what you would have been setting your cruise at when you were going?
Right around 65.
Okay.
65, 67.
Okay. Okay. But then
You may never go more than 4 over, ever, anywhere in the, anymore. I just lock it in.
Do you recall those moments of that interview?
Yes, I do.
When was the next time that you spoke to Attorney General Jason Ravnsborg?
On September 30th of 2020
Where was that at?
at the Pierre Police Department.
In the second interview, did you ask the Attorney General if he had reached out to the victim's family in any way?
Yes, we did.
And what was his response?
That they had contacted the Sheriff's Department about getting the victim's family information to reach out and express their condolences, but they didn't get anywhere with that, so they actually looked up the obituary and found information. They then did further research and found that approximately 6 weeks previous to Mr. Beaver's death, Mr. Beaver's father had passed away also, and so at that time they elected that due to all of the circumstances, it wouldn't be proper to reach out to the family.
And this would have been about 2 weeks after Mr. Beaver's death.
Correct.
I want to show you some video clips referencing those statements.
So have you had any other contact with the sheriff at all?
No, I have not I have not had any contact at all with the sheriff. I think Tim might have reached out because we were trying to figure out who the family was.
Oh, okay.
To offer condolences, sympathy.
Were you guys ever able to get anywhere with that?
No. I no, not at all.
Okay.
We found a different way to find out than the funeral home. They put the obituary and put the funeral home of where that had happened, and then we learned that the father passed away about 6 weeks prior. We were looking to reach out to the mother, but we saw that and did not reach out then because obviously she just lost her husband and then 6 weeks later loses a son. So we just didn't think that was the right time.
Right.
Because the father was still on the funeral home registry.
The family of Joe Beaver says you haven't reached out to him, have you?
We attempted to reach out to him early on, yes.
Bob.
Obviously, that last clip wasn't a part of your interview, but was from a statement significantly after that. So any other statements that the Attorney General may have made publicly about reaching out to the victim's family would not be consistent with what he told you during the interview?
That's correct.
In your years of experience as an officer, why would a person lie about reaching out to the family in a situation like this when they didn't?
Could be a couple reasons. It could be that self-interest, attempting to make yourself look more concerned and that you care more would be one reason.
Okay. Paint yourself in a better light?
Correct.
What data did you recover from the iPhone, the Attorney General's iPhone that was used during his travel on September 12th, 2020?
We were able to retrieve data that would show internet usage, such as email, or access to email, internet access, phone logs, text logs, those sorts of information.
While traveling.
Yeah, we could basically obtain it from whenever, but specifically we were interested in during his travel.
So by the time of this second interview, you have this phone data.
Yes, we do.
And that phone data that showed call logs, internet activity, phone usage on the trip from Redfield back to Highmore, was that different than what the Attorney General had previously told you?
Yes, it was.
How so?
He had told us that his only phone usage was to call his father those 2 times, and then when we were able to obtain that data, it showed that he had been checking emails and also going online and accessing different websites.
Did you ask him about that in the second interview?
Yes, I did.
What was his response?
Initially, he maintained that he had just used the phone for the phone calls, and then I started asking more about how he accesses his email and if that was possible, and then he acknowledged that he may have checked some of his emails, and that eventually it got to the point where he acknowledged that he also goes on and browses news headlines.
And so did this subject about phone usage come up throughout the second interview repeatedly?
Yes, it did.
Would you characterize his responses to you as forthcoming?
No, the way I would characterize it is he was only willing to acknowledge something once he knew we knew the information already.
Even though he knew that you already had his phones, right?
Correct.
I want to show you 4 different clips from your interview referencing those inquiries.
Do you remember using your phone for anything other than phone calls? Or to your dad that night on the way home?
Right, yeah.
What were you using it up to the time of the crash?
Not that I recall. Well, I set it down. I remember sitting it down. I pretty confident I shut the radio off and then went, looked at the speedometer. It was the best I remember. And then wham. I was not looking at my phone. Do I look at that stuff? Yes.
And do those clips show a progression of those inquiries throughout that interview?
Yes, they do.
By the time of this interview, do you know that Joe Beaver was not struck in the middle of the road?
Yes, we do.
And what information have you received to that end?
We had received the information from the South Dakota Highway Patrol's work that it had been on the shoulder of the road.
You had also been out to the crash scene yourself
Yes, I had.
and observed the debris and items there?
Yes.
And was there anything from that scene that led you to believe that this happened, Mr. Beaver was struck in the middle of the road?
No.
Did the Attorney General ever directly admit that he was on the shoulder of the road in this interview?
Not directly.
What did he tell you about that?
He made comments throughout the interviews that he had been in the middle of the road, but then he also made comments about who would ever have thought that a guy would have been walking on the side of the road.
So would you say that that's an indirect acknowledgement that Mr. Beaver was on the shoulder of the road?
Yes.
And you had mentioned in your law enforcement background that you are a polygraph examiner.
That's correct.
Why was a polygraph not used in this case?
Whenever you administer a polygraph is not an appropriate tool to use on every single case. Each case has to be evaluated, and what happens is if it's going to be considered as the examiners evaluate the case to determine if it's it's a case that's proper for a polygraph. We have to consider numerous different things when we're looking at that. We don't want to ever administer a test that we don't have the confidence in our results. From the nature of this, just with all of the facts of the case, not only myself, but a few other examiners did not feel that it was a case that would allow for a test that any examiner was going to have great confidence in their results.
And a lack of confidence in those results could actually be more harmful to the suspect, correct?
It could be. Specifically in this case, I personally felt, and so did the other examiners I spoke to, that the likelihood that Mr. Ravnsborg would fail this test and show that he's lying were very great, to the point where, and just with the nature of it, we wouldn't have been confident in those results for certain due to a polygraph itself. And just the nature of everything that we had discovered, we didn't think it would be appropriate to use a polygraph at that time.
And when you say would fail the polygraph, regardless of whether or not he was answering the question truthfully?
Correct. Regardless of whether he was being truthful in everything he had told us up to that point, we believed that it would be very likely that that sort of test, he would fail and show that he was lying about it. And we didn't want to give him a test that could potentially show he was lying when he was, in fact, telling the truth on something.
Okay. What, well, before I ask that, and the entirety of your 2 interviews with Mr. Ravnsborg were recorded, correct?
Correct.
And I would just reference the Senate once more to those interviews and the transcripts in the case as evidence. What were some of the other things that were done during the course of your investigation?
We interviewed the individuals who were at the Lincoln Day dinner, so the people who had attended. We also interviewed the waitress that was there, who was able to ensure us that Mr. Ravnsborg had not been consuming alcohol. We did have a blood draw done on him on the 14th also. We had went to the scene and skid testing a couple days after the accident, where the Highway Patrol tested the braking of his vehicle. We went out to the scene several days after and used a chemical that's supposed to show blood that maybe isn't visible to the naked eye. In the dark, when you spray it, it'll glow a bright blue color, to see if there had been blood towards the area of impact, to help determine specifically where that was.
Did you receive the results of the autopsy in this case?
An autopsy was done, and we received those results also.
What was noteworthy about those results and discussion with the physician thereafter?
The results were, I believe the terminology they used was something along the lines of multiple impact trauma to Mr. Beaver, in a conversation that was had with the medical examiner by Supervisory Special Agent Arnie Rummel. The medical examiner stated that Mr. Beaver would have been hit on the front side, not in the back.
Because the injuries that they observed in the autopsy were consistent with being struck from the front.
Correct.
Why was that important?
It showed Mr. Ravnsborg was traveling west on Highway 14, so it showed that Mr. Beaver was traveling east.
You may have already mentioned this, but did you interview other motorists who passed by?
Yes, we did. We interviewed numerous other motorists that had passed by around that time frame, up to all the way around the time when Mr. Beaver's vehicle had been driven in a ditch and struck the hay bale.
And did you learn that some individuals had actually seen him walking?
Yes.
What else did you learn about that?
Learned that he had been seen walking. One individual had actually stopped and asked him if he wanted a ride, and they noted that he had some sort of flashlight, whether it was a cell phone or a flashlight, illuminated in his hand.
You received, during the course of your investigation, contents of the cell phone exams conducted on the Attorney General's cell phones?
Yes, we did.
Did you re-interview Sheriff Volek?
Yes, we did.
Why was that important?
The biggest reason that we wanted to interview him again was because when we were out at the scene on the 13th, we found a small flashlight laying along the shoulder of the road, basically right where the concrete meets the grass. And as of when we got there, and we didn't get there until 5 o'clock that evening, that flashlight was still turned on and still illuminating. And just through investigation, we were able to determine that that was most likely Joe Beaver's flashlight that he had been carrying that day. And so in reviewing Sheriff Volek's report, he notes that when he was out there, he saw a light laying along the shoulder of the road that was illuminating. So I wanted to speak with him about that light.
In your interview with him, do you recall if he indicated he went all the way up to that light to take a look at it?
He did not walk over to check out the light. He saw it and thought it was part of the car that was still illuminating.
Do you recall if he indicated to you whether he would have walked right by the body and not seen it himself?
I don't recall if he said that, but if he had walked to the flashlight, he would have walked right past the body.
But he didn't give any indication that he walked up to it, or?
Yeah, he said that he didn't walk up to it. He could see it in the distance, but he never walked over to further examine it.
And what was his explanation for that light that he saw?
He thought it was part of Mr. Ravnsburg's vehicle that was still illuminating, even though it had been disconnected from the rest of the vehicle.
You also received the South Dakota Highway Patrol reports and crash reconstruction.
Yes, it did.
And how did that affect your investigation?
It assisted in the reconstruction in the path of the vehicle, and then I believe our cyber forensic guy was able to provide speeds for the highway patrol using the phone GPS, so that all was taken into account.
So there was some communication back and forth about that.
Yes, there was.
Special Agent Ahrens, I have no further questions at this time.
Cross-examine, Mr. Butler.
So Sheriff Volek did tell you he walked past where Mr. Beaver's body would have been while looking at the light, or while looking for the light.
No, I don't believe he said that.
The sheriff states he would have walked past Mr. Beaver's body to get to the flashlight. Quote.
Okay, I don't recall him.
You disagree with that statement appearing in a Bureau of Criminal Investigation report?
No, I believe that it's there. I just don't recall him specifically telling me that.
Was Mr. Ravnsburg resist, or did he resist turning over access or giving access to any investigative items in this case?
No, he did not.
With regard to the polygraph, why did you even offer one if you had no intent to provide it?
At that moment when I offered him the polygraph, I hadn't made that determination yet. That was something that was considered, but then after further discussion with other examiners, it was deemed that it wouldn't be necessary or wouldn't be appropriate, and it's not an exam I would have done anyways. I would have had to find an examiner to do it.
So when you offered the polygraph examination, did you think at that time it could be appropriate?
I didn't know at that time, but I offered it, and that is something we do once in a while, is offer something that we may eventually not follow through on anyways.
And you say you had a meeting with other polygraphers?
That's correct.
And what are their names?
I had a meeting with Supervisory Special Agent Mark Nickel, who's a polygraph examiner in North Dakota for the Bureau of Criminal Investigation. And I also had a phone conversation with Tyler Newharth, who is a DCI polygraph examiner.
And I'm really trying to understand this because your answer was confusing to me. You think Mr. Ravensburg could have been telling the complete truth but failed the polygraph. Is that right?
I think that the polygraph was not going to be able to answer the question on whether he was telling the truth.
For example, could you have fashioned a question, were you aware that you had struck and killed a human being on the night of September 12th of 2020?
No, that would not have been an appropriate question at the time.
I have spoken with a polygrapher who's been in the business longer than you. He was with the Sioux Falls Police Department. DCI has taught polygraphy, and he strongly disagrees that you could not fashion a question for a polygraph exam on whether he was aware that he had struck and killed a human being, which is why I'm not sure how you can tell this body it was not possible.
I didn't say it wasn't possible. I said that we didn't feel that it was appropriate. Polygraph is somewhat subjective in that different examiners have different opinions on that, and I'm not saying that no examiner anywhere would ever disagree with that, but the ones I spoke to, we all agreed, including one of his examiners himself, who didn't think it was an appropriate test.
What was it about the Attorney General that would have made him a unique person in any respect with regard to administering a polygraph?
The unique part about this would have been that even though his statement is that he didn't know what he hit on the day of the accident, the next day he went there and he saw what he hit and he saw the body, which is going to always be ingrained in his mind for the rest of his life. And as examiners, we did not feel we could ask questions that image of that body laying there along this roadway wasn't going to pop into his mental image, or that mental image wasn't going to pop up every question we ask.
Have you polygraphed people who were suspects who knew specifically what they were accused of?
Yes.
Even though they were denying it, you still offered them a polygraph?
Yes.
Okay, how did those turn out?
Various different ways. I've run a lot of polygraph tests.
Okay.
Some have passed, some have passed and shown to be not showing any deception, some have shown deception.
Mm-hmm. Are there techniques for attempting to determine whether a person's anxiety, nervous condition, etc., can be adjusted for during the course of a polygraph?
Yes.
Okay. Did you ever inform the Attorney General that you would not offer a polygraph?
I don't believe we ever did tell him that we wouldn't. We just never came back with offering that again and attempting to set one up or schedule it.
When he told you that he would absolutely take a polygraph and for you to set it up, the truth is you were surprised, weren't you?
Not really.
Okay. The technique of offering a polygraph oftentimes is done to test the person who is denying what he's being accused of. For example, you saw a human being. He says, no, I didn't. You want to take a polygraph. You expect him to say no, don't you?
No.
And I noticed in none of your reports did you mention that you had offered him a polygraph. Why was that omitted?
I believe it is in one of the reports. I believe it's in my interview report.
It's in a transcript of your interview, but do you recall putting in a report?
I can't remember if it's in the transcript or in the report or in both.
Nothing else, thank you.
You wish to redirect the witness?
Agent Ahrens, are you aware that Attorney General Romsberg had talked to Tyler Newharth about a polygraph?
Yes, I am. Or that somebody had. I don't know if it was specifically Attorney General Romsberg or one of his staff.
Okay. And that Tyler Newharth had advised that the polygraph would not be valid?
I believe that was something that was said, something along those lines. That's very similar to the conversation myself and Tyler Newharth also had.
So it'd be somewhat disingenuous to offer to do something that you know wouldn't be valid anyway.
That's correct.
No further questions.
That report that you were just showing, counsel, does it say in there Mr. Ravensburg spoke with Tyler Newroth?
I don't know if questions are being asked of me, but I was reviewing my notes to myself, Mr. Butler.
Does that report you were showing the officer tell you that the Attorney General spoke with Agent Newroth? Yes or no?
I don't know what report you're referencing. I didn't show the witness the...
Well, you should. You were showing him something. The fact is, no one has said the Attorney General spoke with an Agent Newroth here in South Dakota about polygraphs. Are you aware that he ever had that conversation?
Like I just said, I don't know that he ever did have that conversation. I believe it was one of his staff members spoke to Mr. Newhart, or Tyler Newharth.
Okay, a staff member spoke with Agent Newroth, correct?
So, yes.
Okay, was it at the Attorney General's request?
I have no idea.
Was the Attorney General in any way, shape, or form involved in that communication?
I do not know.
That's all I have.
Anything else, Mr. Vargo?
Nothing from this witness.
Thank you. Witness may step down. We are going to take a 10-minute recess. Back here at 1:15. Senate will return to order. Ms. Tracy, you may call your next witness.
Thank you. The prosecution calls Special Agent Cassidy Halseth.
Proceed.
Raise your right hand and repeat after me. I do solemnly swear
I do solemnly swear
that the testimony
that the testimony,
I am about to give in this matter
the testimony I'm about to give in this matter
is the truth,
is the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Will you please state your name and occupation?
Cassidy Halseth, I'm a special agent with the Bureau of Criminal Investigation for the state of North Dakota.
What is your law enforcement background?
Started my law enforcement career in 2001. 2002, I moved on to the Minot Police Department where I was an officer there until 2017. 2011, I was brought into the investigations unit at the Minot Police Department, where I kind of started specializing in cyber crimes, crimes involving computers, cell phones, things of that nature. Became an active member of the Internet Crimes Against Children Task Force. In 2017, I took a position with the Bureau of Criminal Investigation and was assigned to the cyber crime unit, again, kind of specializing in those crimes against children.
In your capacity with the BCI, did you have occasion to become involved in a law enforcement investigation in South Dakota in September 2020 regarding a pedestrian being struck by the South Dakota Attorney General, Jason Ravnsborg?
I did. I was contacted via a text message from a chief agent asking if there was agents available to respond to South Dakota to assist with an investigation.
And did you respond?
I did.
Approximately when did you arrive down to the crime scene then?
So where I'm located in North Dakota is a little bit further away from Pierre than the other agents that responded, so I was a couple hours behind them. I would guess I got to the Highmore area approximately 5 to 6 o'clock, if I remember correctly.
And what were some of your main roles in the investigation?
So initially when we arrived on scene, it was myself and another agent from Bismarck headquarters, Pat Helfrich. Again, other agents were already there. They were already starting to start their crime scene processing. So I turned into more of an assisting role, whatever help those agents needed as far as taking photographs or whatever the case may be. I filled in whatever they needed.
Did you end up assisting specifically regarding your areas of specialization with some of the technology review?
I did. So that day, I'm a drone pilot with the Bureau. Another agent that was also a drone pilot, I assisted that agent with flying the drone, taking overall drone scene pictures and collecting that data. But that initial response, there was no other technical stuff that was done that day.
How about the next day?
So the next day, I responded with Agent Helfrich. Again, Agent Helfrich is part of the cybercrime unit. One of his specialties is vehicle forensics. So we responded to where the vehicle was located, and I assisted Agent Helfrich with attempting to recover data from the infotainment center on the vehicle.
Did Supervisory Special Agent Rommel ultimately that day receive consent to search the Attorney General's cell phones?
Yes. While we were working on the vehicle, I got word that the Attorney General's cell phone had been turned over and that he had consented for the extraction of the data from the phone to be completed. So I was called away from the vehicle and started working on that cell phone. And
what type of phone was this phone that was provided to you that day?
I was told that it was Jason Ravnsborg's personal cell phone, and it was an LG model cell phone.
When you conduct cell phone analysis or exams, can you give us an explanation of how that's done?
For the most part, with the North Dakota Bureau of Criminal Investigation, we have two tools that we use for most of our cell phone extractions. One of them is probably very familiar with everybody, or most people in law enforcement side of things, and that would be called the Cellbrite. So that phone is connected to the Cellbrite unit. In this case, I was using the Cellbrite Universal Forensic Extraction Device PC version. So the phone was plugged into a laptop computer. The software then communicates with the cell phone to extract the data out of the cell phone.
And so, in layman's terms, are you trying to take, say, a copy of that phone's contents?
Yeah, that's exactly what we're trying to do. We're not altering the content of the phone or the data on the phone. We are trying to get a copy of the data that was existing on the phone in this state when we received it.
and then conduct an analysis of that copy of the data.
Correct.
How did that go on this phone?
Not well. That particular phone wasn't heavily supported by Cellbrite or the other tool that we use to extract cell phones. I was able to get an extraction done on it, but the data that was recovered was pretty minimal. Mainly consisted of things like pictures and videos, things of that nature. In my opinion, I knew that there was probably a better way to get the data out of that phone. I just didn't have the tools with me at that time to get that data.
So was the phone taken with you?
It was.
And is it fair to say it took quite a while to find the tools to extract data from that phone?
Yeah, I actually reached out to Cellbrite, the company itself. They have a service called Advanced Services where you can actually send cell phones to them. Their engineers will then use different techniques to recover the data from a phone, and then they'll return that data along with the phone to you for your analysis.
Once you received the contents of that LG phone and you were able to finally search it and analyze the data, did you discover anything noteworthy?
The biggest thing that stood out to me on that particular cell phone, that LG cell phone, was that Jason Raunsberg was utilizing a third-party application that basically one would use. It gives the user of the cell phone a benefit by not using their phone while driving. So you turn on the application while you're driving. If you don't use your phone, you collect these rewards that can be redeemed at different places, you know, for all kinds of different things.
And are you referencing the On My Way app?
That is correct, yes.
Did anything else that you discovered about the contents of that phone indicate that the Attorney General was using that personal cell phone after the Lincoln Day dinner on the ride back from Redfield to Highmore?
No, the only thing of note that was located on the phone is that there were some missed calls on the phone, but nothing that was answered, some missed phone calls. That phone appeared, again, to be, you turn on that application, you put that phone down in the car and collect the benefits, because you're not going to obviously use it and get the benefits.
Let's talk about the second phone, the Attorney General's iPhone XR. And did Supervisory Special Agent Rummel also receive consent to search that work cell phone as well?
We did, yes.
And when was that?
So that would have been on the morning of September 14th, probably late in the morning of September 14th.
Okay. And did you subsequently utilize the technology at your disposal to extract information from that phone?
Yes. That phone was hand-delivered to me by Jason Raunsberg. I immediately started working or processing on that cell phone. While that phone was processing, though, I was contacted by a Supervisory Special Agent Rummel, and he requested that I return. I was in Pierre at that time at the Department of Public Safety office working on that phone. They had given us some space, and Supervisor Special Agent Rummel asked if I would return out to Highmore to assist with the recovery of surveillance footage. So I left that phone processing with Special Agent Helfrich so that I could go do that.
And what happened with the processing of that phone thereafter?
So I ended up not ever returning back to Pierre. While we were recovering the video surveillance footage, the agents that were in Pierre were told to start heading back. We were going to head back to North Dakota. So I met with Agent Helfrich in between Pierre and Highmore, he turned over my equipment that I had brought with, along with the cell phones, and he had stated that the extraction that I had started on the phone had failed, and that he didn't have time to restart it, so that it needed to still be processed.
So once you got back to North Dakota, did you run further extraction on that phone?
We did, and again, I knew right from the beginning that we had a piece of hardware at headquarters in Bismarck called a gray key that I knew was going to get us the best extraction on that particular model of phone. So as soon as we returned to Bismarck, that Apple iPhone XR was put on the gray key unit and a full file system extraction was completed on it.
Is it fair to say there was a lot of data extracted?
Yeah, if I remember right, it was in the 20 millions or close to 20 million artifacts on that phone.
And what types of information were recovered?
All kinds of different, I mean, there was phone logs, text messages, application installations, the screen time on and off, if the phone was unlocked, if it was not locked, data showing if the flashlight had been turned on and off, third-party texting applications had been used, GPS, different GPS coordinates and locations. It even documented like how many steps he took around the time of the 911 call, things of that nature.
In your analysis of that data, did you break that out into some reports?
I did. I thought it was prudent to kind of show the usage of the cell phone. Using the data that I recovered, I was able to approximately determine when Jason Ravnsborg left Pierre for the dinner in Spinks County. I documented then his travel from Pierre to there, any of the phone usage that was done on the phone during that time period. I then broke it down when he got to the dinner to show the different types of usage that was going on the phone during the dinner time. I again was able to determine an approximate time that he left that dinner and started to head back to Pierre. So I documented phone usage, travel from the dinner to up until the time of the 911 phone call. And then I broke it down from the time of the 911 phone call till the time he left Highmore, and then Highmore to Pierre.
In conjunction with that analysis, what were some of the noteworthy things you recovered from the Attorney General's work phone?
The biggest thing that I noticed is that he did use his phone quite often while he was traveling. He was checking his emails, he would be checking websites, things like that. He was traveling, so when he was going to the dinner, activity like that was going on. When he left the dinner, activity of that such was going on. And I definitely noticed that just a few minutes prior to the 911 phone call that there was activity of email being checked and web browser activity showing that the user was manually looking at some websites.
Was it your understanding from the investigation that the Attorney General had denied being on his phone for this trip home?
That was my understanding.
So the phone data you recovered refuted those statements?
Correct.
How is GPS data recovered?
So, especially on a smartphone, there's a lot of different applications that are working to show that phone's location because it's an important aspect as far as the working of the phone. You know, if you want to use your Google Maps, you have to have a location. Also, the applications that you're using, they want to track your behavior, where you frequent to travel, things of that nature, so they can get you, the best advertisements and kind of target things towards the things that you're looking at. So there's a lot of social engineering that's going on in the background, and GPS location is one of the things that those applications, want to focus on.
So the more the phone's being used, the more GPS data you can have to recover.
I mean, that's all very dependent, but it seems the more usage that the phone is doing, there's probably a more chance or a greater chance that something is going to interact with it that's going to want to know a GPS location.
What did the GPS data on the Attorney General's phone tell you about the speeds he traveled on his way back from Redfield to Highmore?
It showed that he was traveling, sometimes he was getting down to as low as 62 miles per hour, and his phone speed got up to as high as 77 miles per hour as he was driving between Redfield and Highmore.
So if his phone is showing that it's traveling with the vehicle at a maximum speed of 77 miles per hour, but the Attorney General's speedometer was reading 3 to 5 miles higher than that, he would have thought he was traveling 80 plus miles per hour at that point?
I have no reason not to believe that.
Certainly more than that at most 4 miles per hour over that he told Special Agent Ahrens?
That is my understanding.
What data let me rephrase that. Special Agent Halseth, did you note some of the GPS time data in your original report?
I did.
And were you asked to do some additional review of the GPS data included in the phone dump contents in preparation for today's proceeding?
I was.
Including GPS data points for the phone travel leading up to and through Highmore, but also the GPS data points and timing through and after the crash?
Yes.
I want to show you a table that's been marked GPS phone data point table.
Sorry, I'm going to need my readers for this.
Okay. And it's a 2-page document there. Do you recognize this document?
I do.
And what does it depict?
It depicts the time and speed of the GPS coordinates that I was able to collect from the cell phone, along with some artifact times that were also collected off of the cell phone.
And so it's a true and accurate compilation of speed and timing of other events from the phone contents that you recovered on the Attorney General's work iPhone?
Correct.
Depicting the second breakdown of the GPS data, flashlight use, etc.
Correct.
I would note for the Senate that this document has been provided to you in advance of trial on the prosecution folder labeled cell phone data, the document labeled GPS data points. Now I want to show you what's been labeled AG driving. Agent Halseth, do the blue lines on this diagram, are they the GPS coordinates and that are registering the times and speeds that come from the phone data we just referenced?
Yes.
Arising from the phone content you acquired?
Correct.
And so those are plotted out on this AG driving diagram.
Correct.
Now I want to show you what's been labeled AG 911 intervals. Is the information displayed on this document consistent with the data and location information observed between the beginning and ending of the 911 call the Attorney General made as evidenced by the information you recovered from his phone?
Yes.
And finally, I want to show you what's been labeled AG walking increments. Does this document also contain data based upon the GPS data you retrieved from the iPhone in question?
It does.
At 10:33 p.m., how many GPS data points does the phone register?
I'm sorry, can you repeat that time? I didn't catch it.
Yes, at 10:33 p.m., after 10:33 p.m., excuse me, how many GPS data points does the phone register?
4.
And as we analyze this, why would we have a 6-minute gap of GPS coordinates from the time that the phone flashlight goes on at 10:33 until the flashlight goes off?
The data was basically a null set. It was inaccurate, or I shouldn't say inaccurate, that's a bad term. There was no accurate GPS points recorded on the phone between 10:26 and 10:33, and we don't really have an explanation for why.
You testified that there were all of these other GPS data points registering on the Attorney General's phone throughout the day, following the Redfield dinner, tracking back through Highmore, at the crash, and then after 10:33 p.m., when the Attorney General is stopped roadside, there are only 4 data points for GPS. Is that correct?
Correct.
Certainly, there's other information that indicates the phone still is used thereafter, right?
There is.
With text messages, a photograph text message of the photo of his vehicle that he sends.
That is correct. I know there was some phone calls and some texting and a picture sent after leaving the accident scene and heading back towards Pier.
But no additional GPS data points.
No.
Agent Helseth, I have no further questions at this time.
Mr. Butler, you have the witness.
You indicated that the Attorney General denied using his cell phone between Redfield and Highmore?
That is what I was told. I never spoke with the Attorney General, but that's kind of the general consensus that I got from the agents that had spoke with him.
Well, I can tell you he was on the phone for 25 minutes with his father.
You are absolutely correct. I did forget about that. Yeah, I think he did reference that he made a phone call, but other than that phone call, he wasn't on his phone.
Okay. When you receive a phone from someone, do you typically attempt to ascertain whether or not there's been any effort to alter or remove or eliminate data from the phone?
Yeah, we'll normally be able to tell that once we get the extraction completed on the phone. We'll be able to see if there's any type of manipulation that way.
Was that done in this case?
Absolutely, yeah.
And did any data that you could tell that was altered, eliminated, or removed?
Not that I can tell, no.
And from your report or reports.
Actually, could I answer that question maybe a little more truthfully? I mean, there were some things that were deleted, but I have nothing to believe that the things that were deleted on the phone were done in any type of inappropriate fashion, if I guess.
That the phone or the cell phone that had been examined, the work phone, was in locked mode or locked position at least 90 seconds prior to the collision, is that correct?
I don't know the times right off the top of my head, but it was around a minute or two, if I remember correctly.
And nothing you've testified to here today changes that conclusion?
No.
To your knowledge, were your reports and findings disseminated to all appropriate parties, including the prosecutors in this case?
That's my understanding, yes.
Okay. I don't have anything else, thank you.
Reader Brock. Thank you. Witness may step down. You may call your next witness.
Call Special Agent Brent Gromer.
Raise your right hand. Repeat after me. I do solemnly swear
I do solemnly swear
that the testimony
that the testimony
I'm about to give in this matter
I'm about to give in this matter
is the truth,
is the truth,
the whole
the whole truth,
truth, and nothing but the truth.
and nothing but the truth.
Mr. Varr, you may proceed.
Thank you, Mr. President. Special Agent Gromer, would you please introduce yourself to the members of the Senate?
My name is Brent Gromer. I am a retired supervisory special agent with the South Dakota Division of Criminal Investigation.
And can you give us just a very brief background in your training and experience as a law enforcement officer, and perhaps a little bit about what positions you served in as a law enforcement officer, especially around the end of your career with DCI?
I spent 25 years in law enforcement in South Dakota. The last a little over 22 and a half years was with the Division of Criminal Investigation, where I investigated all types of felony crimes. The latter part of my career, about the last half of my career with the South Dakota DCI, I was assigned to the South Dakota Internet Crimes Against Children Task Force. In the last 8 years of my career, I was the supervisor over the South Dakota Internet Crimes Against Children Task Force, as well as the Electronic Crimes Unit for the Division of Criminal Investigation, where I oversaw the forensic examinations done in South Dakota.
And is there the interplay between that Internet Crimes Against Children and the, I think you called it Digital Crimes Unit? Is that simply because many of our Internet Crimes Against Children involve technology?
Yes, that's correct.
And at that point, would you say that you would have occupied the highest position in the DCI as it related to the examination of forensic devices?
Yes, that's accurate.
And you said that you did that for 8 years?
Yes.
I would like to direct your attention to about the middle of September of 2020, shortly after the crash that brings us here today. Do you know the date that I'm talking about?
I do.
And were you in Pierre shortly after that crash?
I was.
And for what reason?
We were actually conducting new agent interviews to hire a new ICAC agent.
Okay. And were you basically borrowing space from somebody?
We were utilizing a conference room in the headquarters at the Mickelson building here in Pierre.
And at that point, the Attorney General had been in office for just a little over a year and a half, basically?
Yes.
Up to that point, what was the nature of your contact, direct contact with the Attorney General?
Very limited.
Okay. Describe what you mean by very limited.
I don't recall ever having a private conversation with him prior to that. It was just he and I.
Okay. Had you ever had an extended conversation with him about your job or the needs of your department or anything like that?
No, never.
Would that principally have gone through chain of command, essentially?
Correct.
Okay. When you were in Pierre, getting ready to interview these 8 potential agents, did you notice that the Attorney General was in the same vicinity that you were?
I saw him come to the door, and he and Director Natvig left the office that I was in.
Okay. And shortly thereafter, did the Attorney General return to the office that you were in?
He came to the doorway, yes.
And what did he do when he got to the doorway?
He motioned for me to follow him.
Okay. And where did he take you?
To Director Natvig's office.
And at that point, where was Director Natvig?
I'm not sure where he was when we walked in. He was not in the office when we walked into the office.
Did he join you at some point during the conversation that we're about to discuss?
Yes, he did.
Okay. When the Attorney General summons you to Director Natvig's office, what was the topic that he led with?
He wanted to ask me about evidence that could be recovered from a cellular telephone.
Was there any pretense that this was about him educating himself on the activities of your unit?
No.
Or a criminal case in which the state of South Dakota was prosecuting?
No.
Or his office was prosecuting, I should be more exact?
No.
How do you know that?
Just based on the context, he immediately asked about information that could be recovered from a cell phone and started referring to his own phone.
What specific questions did he have about the capacity of a forensic expert to seize data from his phone?
Specifically, he had asked me about an app that was on his personal phone, or what he called his campaign phone, the On My Way app, and he stated that this phone would ping even when it was locked or in airplane mode, and was questioning whether or not that app would make it appear that the phone was being used when in fact it was not.
And were you able to reassure him that the very nature of the app is to show that you're not using your phone?
Correct.
Did that seem to put him at ease somewhat?
No. Then he switched and asked questions about whether or not the activation of the flashlight would be recoverable, as well as any emails and things of that nature.
And again, was there any pretense that this was about anything related to your job?
No, he was actually talking about facts of the investigation.
Were you uncomfortable with this?
Yes.
Why?
We were not supposed to be involved. We conflicted out of this investigation and contacted North Dakota to do the investigation, and we were not supposed to have anything to do with it.
Have you ever given a criminal defendant expert advice where the state of South Dakota is prosecuting that criminal defendant?
Not outside of a criminal trial.
So when you're called at a trial, you simply testify to the facts.
Correct.
But if, for instance, the Brown County State's Attorney's Office were prosecuting the case and a criminal defendant called you and wanted to know from you things that would help them prepare their case, would you participate in that process?
No, I would not.
Would you have participated in this process if it weren't the Attorney General himself that was asking you to participate?
No, I would not.
Special Agent Gromer, have you had a chance to listen to some of the testimony that was presented to the House Special Investigative Committee?
Yes, I did.
And specifically, did you listen to the testimony that was given by Mr. Borman and Mr. Natvig?
Yes, I did.
And are there any portions of that testimony that you would take issue with?
Yes.
And specifically, what are they, sir?
The context of that meeting, I believe, was the meeting that I had between the Attorney General and myself was minimized, and there were certainly aspects of that testimony that were not factual.
Let's go first of all to the minimization. What do you mean by that?
It was referred that the meeting was just a happenstance meeting by the water cooler between two individuals that knew each other. That was not the correct context. And then as far as the context would minimize that it was just a happenstance.
And then what about, you referenced that there were some things that you believe were just flat out wrong. What were those?
There was statements that the conversation was just about transferring data between a cell phone as they were trying to exchange those cell phones, and that it was just about moving contacts and things of that nature. That was not correct.
Special Agent, I do want to ask you one other question then. You've been involved in how many searches related to electronic devices over the course of your career?
Thousands.
At any point when you were interested in seizing or examining a cell phone, and one for which you believe you had probable cause and if necessary could obtain a search warrant, have you ever had a defendant tell you, well, I'll give you one phone, but I won't give you the other one?
During the course of an investigation, we've had them turn over certain phones and not others, yes.
And if that happens, do you just let the other phone walk out the door, or would your process be then to go get a warrant for that phone?
If we had probable cause to support affidavit in support of request for search warrant, we would complete that document and attempt to get a search warrant for that device.
Thank you, Special Agent Gromer. I have no further questions on direct.
Thank you. Mr. Butler, you have the witness.
What date did this conversation take place?
On September 15th of 2020.
3 days following the accident?
I believe that's correct.
Was Mr. Ravensburg a defendant at that point in time?
He was certainly a subject in a criminal investigation that I was aware of.
Was he a defendant at that point in time?
I guess it depends on, he was not charged at that point in time, so if that's when the title of defendant kicks in, he was not charged at that time.
Do you know whether he had either his personal or his work cell phone any longer in his possession when he spoke to you?
I do not know. I do recall he handed a phone case to someone, but I did not see a cellular phone.
He had turned his personal phone over on the 14th of September. Are you aware of that?
I'm not, but okay.
And on the morning of the 15th, prior to speaking to you, he had turned his work phone over to the Department of Public Safety. Were you aware of that?
I don't know that information.
With that information in mind, could you tell me what advantage the Attorney General gained by having that conversation with you?
In speculation, it may prepare him for a later interview to be able to explain some of the data that may have been recovered on his phone.
What information did you give him that would help prepare him?
I didn't say that I gave him any information, but that may have been some of the information. I told him in generalities what data would come off the phone and basically explained to him that if he was on his phone at the time of the accident, the digital evidence would show that, and if he was not, the digital evidence would also show that.
Okay. That wouldn't particularly be inside baseball information, would it?
No, I didn't give him any inside baseball information.
So you didn't give him anything. So going back to my question, what advantage did he gain by asking you how something might work when his phones were already turned over into evidence?
I don't know, I guess. I don't know the answer to that.
That's all I have.
Redirect, Mr. Vargo.
Briefly, Mr. President. Special Agent Gromer, you've also done interviews with criminal defendants, have you not?
I have.
Or in this case, I suppose more accurately, a criminal suspect.
Correct.
Is it useful to the suspect when doing an interview to know what you know?
It would be.
In other words, to know what information you already have or what information you may later obtain.
Correct.
Would that be of advantage for the suspect?
I believe so.
And from your answers to Mr. Butler, is it fair to say that you tried to avoid any kind of detail here?
I did.
Why?
Because he was a criminal defendant or criminal suspect at that time, and I knew there was a criminal investigation that was ongoing.
Thank you, sir.
I have no questions.
Thank you. Witness may step down.
Thank you.
Mr. Vargo, you may call your next witness.
Raise your right hand and repeat after me. I do solemnly swear that the testimony that I am about to give in this matter is the truth, the whole truth, and nothing but the truth.
Mr. Vargo, you may proceed.
Thank you, Mr. President. Special Agent Rummel, would you introduce yourself to the members of the Senate?
My name is Arnie Rummel. I'm a supervisory special agent for the Bureau of Criminal Investigation for the state of North Dakota.
You're going to need to get as close as you can to that microphone.
Okay, I'm sorry.
Please repeat your answer.
My name is Arnie Rummel. I am a supervisory special agent for the Bureau of Criminal Investigation for the state of North Dakota.
And in that capacity, sir, have you become the supervisor overseeing the investigation into the affairs of the death of Joe Beaver and the involvement of the South Dakota Attorney General Jason Ravnsborg?
Yes, I have.
Have you previously testified before the House Subcommittee on Investigations in this matter?
Yes, I have.
And did you at that time express to the House Special Committee your opinion that the Attorney General had not been truthful with you during the course of this investigation?
I did.
Special Agent Rummel, I'm going to tell you that, well, I'm going to ask you, I guess, first. Did they ever ask you to elaborate in what ways you believed that Mr. Ravnsborg had been untruthful?
No, not specifically.
Okay. Well, that's what I'm going to do today.
Okay.
But before we get there to any kind of specifics, I want to ask you, is there an overarching reason that you would conduct more than one interview with a witness or a suspect, either one?
Yes.
What are some of those reasons, sir?
So one of the reasons is we get the person locked into the story of the events of the day. That, in this specific case, it was prior to us having the information that we were going to get from the evidence that we had collected. But we wanted to know the version of what happened coming from the person that was involved in the event.
And particularly if that first interview is conducted early in the investigation, is it sometimes useful to go back to again, either a witness or a suspect and ask more detailed questions when additional information has been unearthed by the investigation itself?
Yes, as more information is brought out or more evidence is obtained, whether it be from witnesses or from the crime lab, we would go back and speak to the person to get what their answers are in light of what we knew at that point in time.
So I'm going to ask you about some very specific factual scenarios. During the course of your interviews with Mr. Ravnsborg, did he inform you, I think multiple times, about where he had walked during the process of his call to 911?
Yes, he said he walked past the piece of debris on the shoulder of the road when he was on his walk with 911.
And during the course of that, did he also express to you or tell you what his motivation was for doing so?
He said he wanted to make sure that it was Highmore that he had traveled through, that it was the city of Highmore rather than something different.
And specifically, did he say what he was looking for to make sure that it was Highmore?
It was the sign indicating Highmore was the town that he had driven through.
Had you seen that sign in the course of your investigation?
Yes, numerous times.
And can you describe it? I mean, we're not talking I-90 here, so can you describe what the sign looks like?
It's a green and white sign. It's approximately 2.5 feet wide. I believe it has a white border on it, just on the outskirts of Highmore.
Okay, so if we could play clip number 2 and clip number 13, please.
I had jumped out, called 911, walked backwards towards town to confirm Highmore, scanning the ditch with my light, and came up and took that photo of the car when it stopped.
Actually pause there.
So you're not really. So you're not really sure. So you're.
Sorry, lag. So when he describes both walking toward Highmore to see the sign and then back to the car and where he took the photograph, is your impression of that first clip that he's talking about the entirety of the time that he's away from his car?
Yes.
Okay. So if we could play number 13.
So you're not really sure how far you walked to see the Highmore sign?
No. I walked back in that easterly direction towards the sign until I could see that enough that I could tell it was Highmore, the sign.
So at the time of this second interview, Special Agent Rummel, did you have concerns over whether or not what the Attorney General was telling you was truthful?
Yes, I did.
Why?
Part of the
Closer to your mic, please.
part of the evidence collection and is we're confirming the statements that he made. So I actually went out there at night to determine how close you had to be to the sign to actually see the sign and to be able to read the sign.
So if we could pull up the driving intervals. Special Agent Rummel, this is kind of a conglomeration of data entered by the Highway Patrol as it relates to certain physical evidence, and then the information that Special Agent Halseth was able to retrieve from the phone. Are you familiar with this diagram?
Yes, sir, I am.
So if we use the large piece of debris as the rough point that Mr. Ravnsborg was describing, from that location, roughly how far is it to the Highmore sign?
About 475 feet.
Okay. And when you recreated this event the next night, did you get close to the sign? Or, excuse me, did you get close to the spot that Mr. Ravnsborg had described?
I'm sorry, I didn't catch the last part of it.
When you recreated this event the next night, did you get close to the spot that Mr. Ravnsborg described?
Yes, I walked the distance to where I was able to actually read the sign.
And in order to do that, did you have to go far beyond where Mr. Ravnsborg had described?
Yes, I did.
Now, you do wear glasses.
That is correct. It's for astigmatism and for reading.
Does that have any impact on your ability to see things at a distance?
No, I actually have 20/20 and 20/15 in separate eyes.
Okay. Do you remember how far you had to get beyond where that piece of debris had been before you could see the Highmore sign?
Yes, I had to, there's a fence line that borders the state shop that's out there. I had to get to that fence line before I could actually read the Highmore sign.
And that Highmore sign, is there any illumination on it in the normal course of events?
It's reflective, so if there's light shining on it, the light would allow people to see it better, but in this particular case, it was at night. There was no headlights, so it's not illuminated at all. You can see it in the distance, but it isn't lit up.
Okay. And you just mentioned something about headlights, though. Do we know whether or not there were other vehicles on the road at the time that Mr. Ravnsborg was looking at the sign?
Mr. Ravnsborg said he did not believe he was passed by any vehicle while he was standing out or while he was at the scene of the crash.
So as far as he told you, the light or the sign would have been unilluminated.
That is correct.
Now, once Special Agent Halseth had done some additional work with the GPS data, would you pull up the 911 increments, please? Intervals. Did you have additional concerns about the veracity of the description that Mr. Ravnsborg had given you?
Yes, I did.
So as we look at this diagram, the 911 intervals, this represents the GPS locations for the entirety of the 911 call.
That is correct, sir.
And I think we used every 5 seconds because otherwise it just got way too busy.
Yes.
But what is the furthest east from the place where the Attorney General's vehicle stopped that he ever walked while he was still on 911?
Somewhere around 100 feet is the furthest he got from his vehicle.
And that would mean an additional 300 feet to the west compared to that piece of debris, roughly.
That is correct.
So if you couldn't see it from 400 and some feet, are you likely to be able, 475 I think is what you said?
That is correct.
Is there any chance you're going to be able to see it from 775?
Absolutely not.
And then if we could pull up the walking increments. This last diagram, Special Agent Rummel, I am referencing as walking increments. And I believe it shows us two related but somewhat separate sets of GPS data. To the right, we see a number of, I think those are the black ones, a number of GPS data points which are numbered 1 through 5. Do you see those?
I do.
And based on the fact that the GPS and the phone data are drawn from the same device, can we reliably compare the GPS data with other events that occur on the phone?
Yes.
So for instance, we know that the 911 call ends at 10:26:44, and the GPS data point number 1 is at 10:26:47, so 3 seconds later.
That is correct.
And we know that at 10:26:59, the flashlight comes on the phone.
That is correct.
And that that data point, 10:26:59, represents further down the road than any of the previous data points that were made while the Attorney General was on the phone with 911.
Yes, sir.
And then we have 2 more data points proceeding down the road. They now get spottier, so we have 10:27:05 and 10:27:09.
Yes, sir.
And then the next data point in terms of time returning to the vehicle would be number 6, which is listed at 10:33:25.
Yes, sir.
That's roughly a discrepancy of 6 minutes and change.
Correct.
And then we have 3 more data points, total of 4, in the next 10-15 seconds, all clustered around the vehicle.
Yes, sir.
And according to Special Agent Halseth, those are our remaining GPS data waypoints. That's all we got.
That is correct.
So, what I want to ask you, first of all, Special Agent Rummel, is whether or not that is then consistent with the description that Mr. Ravnsborg gave you of where he walked with reference to the large piece of debris. In other words, is 6 minutes enough time to get up to that and then get back to the vehicle?
To the debris?
To the debris and back to the vehicle.
Yes.
Would that even be very much of a stretch?
No, not at all.
And in that description, sir, that's actually the next area that I'd like to cover with you. In that description, is Mr. Ravnsborg very adamant that he walked up to that large piece of debris?
Yes, he is.
And slightly past it?
Yes.
Knowing what you know, can you envision any mechanism by which a person could walk down the shoulder, past the large piece of debris, with a flashlight on, scanning the ditch, and not see the body of Joe Beaver?
No, I don't believe it's possible.
And was that an opinion that you formed even during the first and second interviews prior to the GPS data?
Yes.
What makes you think that that's true?
Due to the fact that Mr. Beaver's deceased and he is completely white. He's laying just off of the roadway within 2 feet. And if you're scanning with a white light, a light from your flashlight or from a camera light, and you go across a white anything, it's reflective. So therefore, you would see it. It would stick out. And there isn't any way you can go by without seeing that.
Special Agent, are you familiar with all of the photographs that were taken by all of the various agencies, your own and the South Dakota Highway Patrol, the drone footage, whatever, that were taken in this case?
Yes, I'm familiar with all of them.
From those, we have selected 7, which we believe it is appropriate for the senators to view as against the statement that you just made, that the body would have been highly visible to anybody walking in the vicinity. Mr. President, it would be my suggestion at this time, I have 1 or 2 more questions prior to this moment, but I do believe that it would be appropriate then to release the senators. We have physical copies of those photographs to protect the family of Mr. Beaver from those being accidentally disseminated from this chamber. We will set up 2 copies on each lobbying area, and I am going to ask the witness a couple of questions about 2 of them in particular, but there are a total of 7. I will tell you they are not pleasant, but I do believe that they are very important and would ask your indulgence in actually viewing them. If we want to do that consistent with the lunch break, we could possibly make that happen at the same or subsequently, so that we don't have to break, reconvene, and then break again. But that's up to you, Mr. President.
I believe I would just assume that we wrap up this testimony, and so I think we should.
Very good. I'll ask my questions, and then I'll ask the President for the indulgence of 5 minutes for the senators to go see those particular photographs.
Very good.
Special Agent Rummel, within the 7 photographs that we've selected, some are largely to ensure that people understand the relationship between that large piece of debris and Mr. Beaver.
Yes, sir.
But I'm going to ask you about 2 in specific. Photograph number 2 and photograph number 7. What do they depict that, again, feeds your opinion that Mr. Ravnsborg was not being truthful with you when he said he had not seen Mr. Beaver's remains?
I believe that from that point of view, you would see the whiteness as you went by.
And so is number 2 a photograph taken facing east?
That is correct.
And probably 5 to 10 feet before you actually are even with Mr. Beaver?
Yes.
And then photograph number 7 is the same thing but coming west, and again 5 to 10 feet taken from the shoulder.
Yes, they're from both sides of where the victim's body was came to rest.
All right. Mr. President, if we could take that 5 minutes to allow the senators to view those photographs.
Yeah, we'll be at ease for 5 minutes while the senators view the photographs, or less than that if all the senators are, as soon as senators are back in the seat, we'll go back to questioning. Yes. Members of the Senate, the audience, we are going to, I think, take a break now for lunch for 1/2 hour. So it is 12:20 now. We will come back in at 10 minutes till 1. And the senators, there is pizza in the lobby. And I would make an announcement that the downstairs cafeteria in the Capitol basement is open. So if you want to grab some lunch down there. With that, we'll be in recess until 10 till 1. Thank you. Senate will come to order again. Mr. Vargo, you may proceed.
Thank you, Mr. President. Special Agent Rummel, I want to go back to the question of what the Attorney General would have seen or could not have seen. In addition to just kind of the physical facts, the sharp contrast between Mr. Beaver's body and the surrounding area. And for those that maybe chose not to look at the pictures, and I certainly understand that, Mr. Beaver was originally dressed in darker clothing, wasn't he?
Yes, he was. Yes, he was.
So a dark blue shirt and blue jeans.
Blue jeans, correct.
Did it appear to you that the traumatic nature of the crash had essentially, if not removed those, had bunched them in such a way that almost most of his body was visible?
Yes, sir, that's accurate.
And is that part of what you were saying when you said a white object against a dark background with a flashlight would show up quite visibly?
That is correct.
But in addition to all of that, Special Agent, was there something about, or was there anything about the way that the Attorney General described how he was scanning the ditch that stood out to you?
His description was he was scanning the ditch, and as he was describing it, he was showing us that he's looking up in the sky, which was absurd at best.
And did you confront him on that?
Yeah, because he would have been laying in the ditch if it would have been there, whatever he said he was looking for.
So I'm going to play you the clip of that, sir.
I mean, I'm scanning, but I didn't, it's a camera light. It's not great either.
But if you're looking for a deer, you'd be looking at the ground. You're looking at the ground, aren't you? Wouldn't you look at the ground?
I looked both, I kind of did, I don't know where my hand went exactly.
So when you confront him with that, he says he looked at both?
He looked at both. And
both on the ground and in the air?
Correct.
Agent Rummel, we talked at the very beginning about the fact that you were the supervisor on scene here.
Yes, sir.
And from one man with gray hair to another, can you tell me a little bit about what makes you the supervisor? I've been admonished that I introduced you by name but not by experience. Can you tell us a little bit about who you are and where you've been as it relates to law enforcement?
I started my law enforcement career in 1981. I worked for the Dickinson Police Department as a patrolman for a period of like 5 years. I was an investigator at that same agency for another 5 years, and I've been with BCI for 30 plus years, of which I've been a supervisor for all of it.
And how many criminal investigations would you say you've conducted over that 40 plus years?
I would say hundreds. If we're talking about death investigations, easily in the hundreds. As far as other things, I can't even venture a guess because there's, smaller crimes that we end up investigating, including narcotics and burglaries and such. But they all are investigations of importance.
In this particular case, so in addition to doing whatever you did on the ground, so to speak, participating in the interviews and whatnot, were you also responsible for knowing what was being done by the rest of your agents?
Yes, I was.
And we had some cross-examination of Special Agent Arens here just a little bit ago. Mr. Butler wanted to know whether Agent Arens, had put his offer of a polygraph in a report specifically, not just in the transcript of the interview. Were you able to go look at Special Agent Arens' reports and find that?
Yes, I was the one that approved those reports, and in paragraph 66, he does talk about the polygraph with the Attorney General at that time in that report.
And there was also some discussion about whether or not Mr. Ravnsborg himself would have known about what his people had said about the propriety of a polygraph.
That is correct.
And again, you're not a polygrapher?
No, sir, I am not.
Have you supervised polygraphers?
Yes, I currently supervise some.
And were you Joe's supervisor in this case?
Yes, I was.
And so, let me ask, first of all, is a question about what you knew and when you knew it one that is more difficult for a polygraph? I won't say impossible, but is it more difficult for a polygraph?
Yes, it is.
And did you specifically have a conversation with the Attorney General about that during the course of your second interview?
Yes, I did.
And I'm showing you on screen your questions, or I guess mostly it's Joe's questions, and his results. But do you see about 5, 6 lines down, well, they told me the only concern would be now you know it versus you didn't know it at the time.
That's correct.
And the they that he is referring to, that would be South Dakota DCI agents?
Yes, sir.
That either he or some member of his office had talked to?
That's correct.
And it is pretty clear from this that the information that they received had come back to the Attorney General.
Yes, it did.
Okay. So let's go back to some of your impressions about the Attorney General's veracity during the course of your interview with him. Were there things that you believed long before the GPS data came in about the crash and the aftermath of the crash suggested that Mr. Ravnsborg knew that he had hit a man not just before he left the scene, but before his vehicle came to a stop?
Yes.
What are some of those, sir?
Well, part of...
you need to be by your mic.
So prior to the GPS coordinates, during the first interview, he said, I turned around and I saw him. To me, that was one of the indicators. The other indicator was I did not know what I hit until impact. Well, that tells me that upon impact, he knew what he hit. He could identify what he hit after the impact, which is instantaneously.
So I'm going to kind of focus in on that part of it, between impact and the vehicle stopping, because the reference to turning around and seeing the body is after that, obviously.
Yes, it is.
So let's start with first whether he knows that he hits a man before he comes to a stop. Did you participate in an experiment or recreation of trying to recreate what it is that the Attorney General would have seen as he drove down the road?
Yes, I did.
And specifically, were you the Joe Beaver in that experiment?
Yes, I was.
And you were dressed in dark clothing?
I was dressed in blue jeans, and a dark blue shirt.
And you were carrying specifically Joe Beaver's flashlight?
We used Joe's flashlight for that, yes.
And is it fair to say that west of Highmore, there's not a lot of artificial light?
It's very dark out there. There is not.
And is that specifically how the Attorney General described that location that night?
I think his words were extremely dark.
Okay. Does that flashlight show up?
Yes, it does.
And did you use the phrase, I believe in one of your reports, like a beacon?
Yes.
Now, is it possible that if the flashlight's pointed in a direction other than in front of the person who's walking down the shoulder, if it's pointed in a different direction, might it be harder to see?
I agree with that statement. Yes.
But can you come up with a good reason why you'd be pointing it in the air or behind him or off into the grass?
No, I believe he'd be using it to watch where he's going. There might be some hand movement as he steps, but that movement in itself would make it more of a beacon because it would be shining in the light of the person that's approaching them.
There'd be almost like the difference between a flashing light and a light that's simply on.
Correct.
And would you say that that is visible from how far? Did you guys attempt to recreate that?
We did, and the people in the car said that we could see you for a long ways, almost from the highway department building that's there. So it's quite a distance to the scene because we actually went to the area of impact to do that test, and they said they could see me right away if I was walking with that light. I'm sorry.
And the highway department entrance would be just past that Highmore sign?
I believe it's just before that.
Okay. So we're talking in the vicinity of 300 feet?
Yes.
And so if you don't see anybody for 300 feet, is that a fairly egregious lack of attention?
I say that, yes.
Even for people who are on their phones?
That is correct.
Even people who are messing with their radios?
That is correct.
Even people who might be looking to reset their speedometers or their cruise controls?
Yes, sir.
Was there anything else physically about the scene that suggests to you that the Attorney General knew what he had hit before he even came to a stop? In terms of where he parked?
The fact that it took him such a long period of time to actually stop made me think that he was panicked, if you will, about what he just did.
So sometimes we use the phrase panic stop to mean you slam on your brakes as hard as you can. Are you using it really in the opposite sense?
That is correct. I'm using it that internally he's like fight or flight, possibly, or I can't believe what I just did, and slowly comes to a stop because he needs to make a decision at that point of whether he's going to, call 911 or what he's going to do at that point.
Okay, so we'll get to the when again, but I want to ask you about the where. I am showing on the screen photograph 35350, and I believe that's in our packet under the reconstruction photos. Is this an attempt by North Dakota BCI to recreate where the Attorney General's vehicle was at the time that it came to a full stop prior to being towed?
Yes, it is. Yes, it is.
And that's based, I assume, on the picture that the Attorney General himself had taken?
Yes, the Attorney General took the initial picture, and I had another agent from BCI superimpose it so that we could put it in the exact place that it was when it came to rest.
So using the various markers like telephone poles or lights from Highmore or whatever the case may be, did they attempt to establish exactly where the Attorney General's vehicle was and then take a photo without the vehicle to recreate that location?
Yes, sir.
And then superimpose the Attorney General's photo And that's why we can kind of see, it's almost like a ghost vehicle in the sense that you can see through it.
Yes, you could see the white fog line through the vehicle in this picture that was superimposed.
And from where that would have been, sir, is it fair to say that the Attorney General's vehicle was parked at least partially in the lane of traffic?
Yes, it was.
Would you consider that normal?
No.
Is that another indication to you of more of a panic situation?
Yeah. Yes.
And is the panic, let me just ask you this, did the Attorney General describe to you that he'd hit deer before?
Yes, he did. He said he had hit a couple before.
And so whatever the opinions may be in this room, for all of those of us which has got to be most of us, have probably hit deer at some point. Is there any reason to be panicked after you hit a deer and you realize you're uninjured?
No, there isn't anything you can do at that point. So it's a deer that was hit.
It's sort of obvious from the picture, but let me ask it out loud. Is there room to move the vehicle to the right and get entirely out of the lane of travel?
Yes.
So in addition to that, you've referenced already the amount of time that it took him to come to a stop.
Yes, sir.
Well, I'm not going to pull this up because it's basically numbers. It's not all that helpful. But we'll pull up the diagram that gives us a little bit of a visual on this. The area of impact is the small red car and then an AOI in the middle of that screen. And as we move to the left on that, Special Agent Halseth identifies that those are each the times and the speeds at which Mr. Ravnsborg's vehicle is traveling. So for the 2 seconds after the collision, which we know based on the location, not so much timing, but from the location, if we know the area of impact, we know that that happened at 10:23 and 36 seconds. In the next 2 seconds, there is no real appreciable slowing. It goes from 67.6 to 67.1. Is that what you're talking about?
That is correct. That is correct.
And then in the next 7 seconds, the vehicle slows from 67.1 miles an hour to 11.9 miles an hour. Is that right?
That is correct.
And I believe that the reconstructionist would refer to that as moderate braking.
Yes, sir.
Would you agree with that?
I would agree with that.
So it's not exactly slamming on your brakes, but it's also, you're braking at least.
You're stepping on the brakes, slowing down. You're not hammering them or slamming them, no.
In the next 7 seconds, from 10:23:45 to 10:23:52, the decrease in speed is from 11.9 miles an hour to 7.9 miles an hour. Is there something about that that, again, causes you concern about exactly what was going on inside that car?
Yes, I believe it's just a rolling stop.
And then we have a 2-second stop from 7.9, 2 seconds later the vehicle is stopped.
That is correct.
And I believe you already started to answer this, but if you could, tell the Senate why it is that you believe that that is inconsistent with somebody who just hit a deer.
Because somebody that just hit a deer would just stop and pull over to the side, not take their time and do a rolling stop. In my opinion, it's whether to flee or stop or what am I going to do next, because I know it just happened to me.
And before we move on to some of the other statements that the Attorney General made to you, from the time that the vehicle stops until the phone is unlocked is how long?
About 2 seconds.
And then another 10 seconds before the phone is unlocked?
Before yeah, it's 2 seconds, and then there's an additional 10 seconds before dialing of 911.
And then another 16 seconds between the phone being unlocked and the 911 call?
I believe that's correct.
What does that tell you, if anything?
There's hesitation about what needs to be taken care of.
And again, in your experience, North Dakota has deer, right?
Yes, sir.
That's something that you associate with even a catastrophic collision with a deer.
No, sir.
Special Agent Rummel, in the course of interrogation, is it unusual for someone to have kind of their talking points that they want to repeat over and over?
Yes, they're trying to make a point and they repeat it and repeat it.
Okay, so I guess I phrased that badly. Is that usual or unusual?
It's dependent on if they're telling the truth or not.
Okay. Are there times when somebody who has their talking points, if you can get them off their talking points, they might accidentally tell you the truth?
That is correct.
Did you feel like that happened to you at times with the Attorney General?
Yes, I believe so.
And I have two specific instances that I want to talk to you about. Just a sec. So we got to listen to a couple of references to a man on the side of the road.
I'm sorry, I missed that again.
Let's do this. Let's go with 7 and 8. I want to play for you two clips from the second interview that you conducted with Mr. Ravnsborg.
I had no, and I still don't believe, I would not expect a man to be on the side of the road in dark like it was. Why would you think a man is walking down the side of a road in dark?
What I want to ask you is, during this phase of your investigation, your conversation with Mr. Ravnsborg, had he ever acknowledged that he was on the shoulder?
Not until that point in time.
And did it appear did he then again deny it later?
Yes, he denied it later, but he actually said, why is he walking down the side of the road?
And did you take that as something where he was admitting something, maybe you'd moved him off his talking points a little bit?
That's correct.
All right, so 1 and 2, please. 1 and 2. This next statement relates to what he saw prior to impact, or prior to coming to a stop, I should say.
Okay, I hit, the incident happened. I never saw anything until the impact.
When somebody says, I never saw anything until impact, what does that suggest to you?
He saw somebody at impact.
And let's play the second one, please.
And then I turn around and I'm looking into the ditch. So I don't know exactly where I turned around and saw him. I didn't see him. I did not see him.
So in that incident, he says that he did see him. When he turned around, he saw him, but then he caught himself in that particular statement and tried to downplay it, or reverse it, if you will.
So those would be instances where Mr. Ravnsborg may have been accidentally telling you the truth.
That is correct.
I'd like to talk to you about some of the other statements that he makes. Special Agent, are there times when it is very important to you to know not just what a defendant said happened, but maybe a little bit about what's going on in their mind?
One more time, please.
Are there times when you want to know not just what they saw, but what they were thinking?
Yes.
And are there times when defendants use what they're thinking to try to convince you that what they're telling you is the truth?
That is correct.
Okay. So I'd like to play for you, it's actually 4 different clips, and we'll do them one at a time, and I'll let you comment on each of them, where I believe that you have said that you found that that was what was happening here. So if we could start with the new one.
I'm a military guy. You do not leave people on the battlefield. You do not leave people behind. If I had any thought that he was a man, I would have tried to render aid or do whatever to get an ambulance out there or whatever. You know, obviously I didn't know. You told me he died on impact. It would have been too late, but I would have been telling the sheriff and everything. You know, if I thought it was a man, obviously I would have insisted on a, you know, blood test or breathalyzer or something at that point, you know, immediately.
So that basically has two contentions in it, or two assertions in it. One is that he's a military man and he would never leave a dead man behind.
Yes, sir.
And the second is that if he knew that it was a man that was hit, he would have demanded, insisted upon, I believe are his words, an immediate blood test or breath test.
That is correct.
When he found out the next morning that this was in fact a man, and that what was left by the side of the road was the remains of a human being, did he leave that man behind?
Yes, he did.
Were there two of them standing there at that time?
There were two people standing there.
They each had a car.
Each had a car.
They each had a phone.
Each had a phone.
He knew how to use his phone.
Correct.
He's called 911 just 12 hours before.
That is correct.
And yet, he decided that the fastest way to find the sheriff was to drive to his house, and neither of them stayed behind.
That is correct. I'm unsure, just to make a clarification, I'm unsure if Borman actually had his phone with.
But if Mr. Ravnsborg is acting according to plan, he has two phones with, right?
He has two phones with him, correct.
So we have at least two phones, probably three.
Quite likely.
And the second assertion is that if he knew it was a man, he would have insisted on a breathalyzer right away.
That is correct.
Would have insisted on a drug test right away.
That is correct.
And the next morning when he found out it was a man, did he insist on a breathalyzer?
No, sir.
Did he insist on a drug test?
No, sir.
And then I said, I talked with Tim of, we need to look, you know, I never looked on the other side of the road when I looked. I looked on the right north side, but I never looked on the left south side. You know, we should probably look there and look at the, you know, how, you know, I want to see what this deer, if it made it or you know, what happened.
So that really has two parts that I want to talk to you about. One is his expressed concern was that they check the other side of the road.
Yes, sir.
When he went back, did he check the other side of the road?
No, sir. They drove past that area to the gas station, turned around, and came back to the north side of the road.
And the second one, and we're going to get to a few others of these, but I might as well do it now when we've played the clip. The second one is that he wanted to see if the deer made it.
That's absurd because if the deer isn't there, how do you know if it's alive or what it is? So it's just an absurd statement.
Now, I got that, and I didn't go back to look at him because I thought that I'd hit a man. I went back because the debris was still there.
So this time he's telling you that he went back because the debris was there and it might be a problem for some other driver. Or at least that's the implication, right?
That is my belief.
Now, first off, the debris is on the shoulder.
Yes.
The rest of us who are driving down the lane of traffic, that shouldn't be a particular problem.
No, sir.
From his description, though, of where he parked and where he walked before he saw Mr. Beaver, did Attorney General Ravnsborg acknowledge that he had gone past the debris?
Yes, sir.
And consistent with his statement and his worry that this debris was a danger to somebody else, did he pick it up and throw it in his trunk?
No, sir.
Did he kick it into the ditch where it might be a problem for the lawnmower, but probably not for anything else?
No, sir.
Never touched it?
Nope.
And that's even before he knew that this was a crime scene, or before he acknowledges knowing that this is a crime scene.
That's correct.
And I was kind of trying to put my mind at ease of how did this happen?
You ever hit a deer, Special Agent Rummel?
Yes, sir.
Was it single digits still or double digits?
It's single digits.
Okay. You ever have anybody tell you that they had to put their mind at ease about how they hit a deer?
Other than Jason Ravnsburg, no.
One other type of untruthfulness that I'd like you to focus in on. Were there certain statements that he made to you that you deemed so absurd that they just put in doubt basically everything else that he said?
The not using the cell phone was the start of it. That due to the fact that most people use their cell phone.
Mike?
I said the fact that he said he doesn't ever use his cell phone and that he's in the middle of the road. From the initial investigation at the scene, we knew that it was not in the middle of the road.
Okay. So that kind of set the tone. Were there other individual statements, though, that even standing alone, without reference to the physical evidence or the witness statements of others or all the other investigation that you put together, so deeply made no sense to you? Tell you what, why don't I play some clips and then you can comment on each of them.
Okay. We found a different way to find out than a funeral home. They put the obituary and put the funeral home of where that had happened, and then we learned that the father passed away about 6 weeks prior. We were looking to reach out to the mother, but we saw that and did not reach out then because obviously she just lost her husband and then 6 weeks later loses a son. So we just didn't think that was the right time. Right. Because the father was still on the funeral home registry.
The suggestion is that because the family has already suffered a tragedy, it would be the wrong time to offer condolences for this tragedy.
Yes, sir.
You ever had somebody tell you something like that before?
No, sir.
Did it feel to you more like this was he was trying to convince himself that it was okay not to contact the family?
That is my belief.
So what were you doing before you got to Highmore? If you set it down at Highmore,
I look at the time and such. I know I do that. I would open it up and I'd see the time better.
When you say glance at your phone, what do you mean by that?
Glance and see what time it was.
Okay.
Just a periodic check.
So is this sort of part of your conversation about phone use?
Yes, it is.
And specifically, he's gone from the I don't use it for anything except phone calls to the I used it for something, right?
That is correct, yes.
But at this point, he's now saying he looks at it for the time?
That is what he's saying he's looking at it for, is just the time, which he opens it to see the time, which actually makes the time smaller.
When was the last car you were in that didn't have a clock radio in it?
I think I had a 73 Chevy pickup that did not.
All right, one more for you, Agent Rummel. Truth's number 4.
I was not looking at my phone. I know it's the law, and I was not looking at it at the time it happened. No.
So here, Mr. Ravnsburg is basically suggesting to you that he wouldn't use his phone in the car because he knows it's the law.
Yes, sir, that is correct.
From your investigation, though, did he use the phone before the crash?
Yes, he did.
Did he use the phone after the crash?
Yes, he did.
So is it only the law within a mile of Highmore?
That is what he's portraying there, but it's still the law even then.
So Special Agent Rummel, I want to finish up by talking to you about your supervisory role. In the course of supervising agents, are you occasionally called upon to judge whether they've done a good job or not?
Yes, I am.
And specifically, is there something that we refer to in the business as giglio? Do you know what that is?
Yes, sir, I do. It's a U.S. Supreme Court decision.
Okay. And for ease of translation, let me just say, giglio is a law that requires, or a case that requires us, if a law enforcement officer has been found to be untruthful, that agency has to turn that information over to the prosecutor, and the prosecutor has to turn it over to the defense. If an agent under your control, sir, had any level of administrative finding about being untruthful as it related to a criminal case, would they be subject to that giglio rule?
Yes, they would. They would be.
What would the practical effect be on their career?
It would end at that point in time.
Why is that?
Because they are no longer useful in the court of law. They're not trustworthy, and you have to release that information to the defense, and with that, you're not able to continue in your position.
And would that qualify whether you were a rookie patrol officer or the director of BCI?
That is correct. Everybody has the same rule.
I believe that's all the questions I have for you, Special Agent. Thank you, sir.
Thank you.
Mr. Butler, cross-examine.
Is everything that you've been testifying about here today contained in your reports?
No, sir.
What is not contained in your reports that you've testified to?
Are you speaking specifically about my reports or
your reports?
Or the team reports?
Your reports.
There's a lot of things that are not in my report.
Well, let's go back again because you've testified to quite a few opinions, particularly regarding the truthfulness of the Attorney General. Are your opinions contained with regard to Mr. Ravensburg in your reports?
No, sir.
These opinions that you're now expressing, did you have them then and choose not to put them in your reports?
I am the supervisor, so I don't usually, the case agent is the one that does the reports of record for the most part.
Here, let me back up again. Did you have these opinions?
Does the case reports.
Let me go back. The opinions that you have been expressing here to the State Senate regarding all the various reasons you question the credibility of the Attorney General, can you identify where those are contained in reports authored by you?
They aren't in the reports.
When did you arrive at these various opinions regarding the credibility of the Attorney General?
As we were working on the case, I made those opinions throughout the investigation of the case.
But I want to know why they're not in your reports. This is something that you would need to disclose if you held those opinions, is it not?
We don't generally put opinions in our reports.
Well, you're testifying to them here today. Are you not?
Yes.
But you kept them to yourself. That is your testimony.
No, I've shared them with the House as well as here today, as well as the other people involved. Did you get that?
Okay. For example, having testified to these opinions but not disclosed them in your reports, would it be something that you would be permitted to testify to in a court of law?
Objection as to relevance. This is not a court of law. I don't believe there's any comparison that needs to be drawn or is fruitful to be drawn.
Objections overruled. Objections overruled. You may answer.
Could you repeat the question, please?
Not having disclosed any of the opinions that you've been testifying to today, would you be permitted to testify to those opinions in a court of law?
I believe I would.
Okay. Are you allowed typically to give your opinion on the credibility of a witness in a court of law?
Sometimes.
Okay. And sometimes, are you not allowed to give that opinion?
Yes, I'm sure there are times that would apply.
Part of the reason I'm asking is a great deal of what you're testifying about here today I'm hearing for the first time. I've never seen a word about a number of these opinions that you now express. And that concerns me. Do you understand why?
No, sir.
You don't understand.
If you read the reports, they would intermingle, and you would know that there was some problems with the truthfulness.
Okay. I'm supposed to guess rather than hear it directly from you?
You heard it from me today.
How many traffic fatalities have you investigated in your career?
Maybe 3.
The interviews that you've referred to here today, the findings of accident reconstruction, findings of the telephone forensics, everything that was done, have you reviewed it?
Yes, sir.
And it was turned over to our state prosecutors?
I believe so.
Did you have conversations with our state prosecutors?
Yes, I did.
Did you express opinions to them about the Attorney General that are not in your reports?
Yes.
So they're aware of much of what you were saying here today?
Yes. A portion of it, at least.
And despite being aware of them and everything contained in your reports, the charges here were leaving the lane of travel and distracted driving, which are Class 2 misdemeanor offenses in the state of South Dakota. Is that correct?
I believe that's correct.
You were aware that I guess the Bureau of Criminal Investigation interviewed Sheriff Volek.
Did you say our bureau?
Yes.
That is correct.
And did he inform your investigators that he would have walked right past the location of where Mr. Beaver was found the next day?
I don't believe so.
BCI interviewed Sheriff Volek and was given the following information. And I'll skip down to the part I'm referring to. Quote, the sheriff states he would have walked past Mr. Beaver's body to get to the flashlight, period, end quote. Does that refresh your memory?
I believe that was us that was saying that.
You believe what?
It was us that told them
Are
that.
you familiar with this report?
I think you're going to try and get on your mic a little better.
Maybe like this. Is that better? Is this better? Let's try it. Okay. I'm sorry.
Okay. Assuming your officers took down correctly what he said, is what I read to you help refresh your memory?
I believe that it was one of us that actually said that.
The sheriff states he would have walked past Mr. Beaver's body to get to the flashlight.
I don't recall seeing that.
Okay. Well, now that I've read it to you, and it does come from the official investigation which you headed up, how do you explain that he did not see the body?
The sheriff?
Correct.
Because he said he didn't go to the light. He did not go to the light that was on the side of the road. He saw it, but didn't go to it. He thought it was part of the car.
All right. He says he would have walked past Mr. Beaver. And my question to you is, how do you explain he did not see Mr. Beaver's body?
I don't believe he walked past it.
So you are saying either the person who wrote the report or Sheriff Volek is not being accurate or truthful?
I'm not sure, but I am sure that he did not walk to the light.
Tell me why you're sure of it.
Because I was in those interviews.
I'm sorry, say it again.
I was in those interviews.
Okay. Do you know why it would be contained in a report, a BCI interview of Sheriff Volek?
It may have been a misunderstanding or something, I'm not sure.
Or maybe you're the one that's misunderstanding. That's a possibility as well, is it not?
No, I was in those interviews. I know he said he didn't go to that light.
The photographs that you made available, or that I should say the prosecution made available for Senate members to look at, what time of day were they taken? The pictures of Mr. Beaver's body?
Estimating around 6 o'clock in the evening.
Okay. What was the lighting outside at that time?
It was daylight. It was bright.
And so there was not an attempt, and I understand why not, but there was not an attempt to replicate what the Attorney General was seeing that night under the conditions that he saw them.
That is correct. We removed the body to the funeral home prior to that, to darkness, because we needed to complete our crime scene.
Earlier, there was a diagram, I believe, charting GPS points taken from the phone or something like that. Do you know what I'm talking about?
There were several of them.
I want to know from that data that was provided from the cell phone, how close was Mr. Ravensburg to Mr. Beaver that night?
within, I believe it was 12 meters.
And that's from the cell phone data?
I believe so.
And at that point in time, his phone was positioned how? Cell phone light?
Said he was scanning the, like this.
And
like
Mr.
this.
Beaver was in the ditch, and that was a slope away from the road, correct?
That is correct.
How many times did you yourself speak with Sheriff Folek?
3 times.
3 times?
I believe so.
Okay. Did you find him to be credible?
Yes.
With regard to the cell phone data that was obtained, was the Attorney General on his telephone at the time of the collision?
No, sir, we could not prove that.
So your answer is no.
That is correct.
When you were meeting with the Attorney General on the second occasion, that would be the 30th of September, in that interview, you indicated to him that you knew he was on his cell phone at the time of the collision, or words to that effect, didn't you?
Yes, I believe so.
And he insisted that that was not the case.
Yes,
And you insisted that it was.
that was my belief, yes.
And you believed what you were saying, no doubt.
As, what's the question again?
You believed what you were saying to him in that interview, the second interview, when you told him he was on his cell phone at the time of the collision. You believed that.
That it was likely that he was on his phone, yes.
Okay. And the subsequent analysis done of the phone proved you to be incorrect and the Attorney General to be correct.
That is correct.
Okay. And were you as sure about yourself on that occasion as you are as sure of yourself today regarding the supposition about the Attorney General's credibility?
Am I as certain about his credibility?
So you were certain of yourself in that second interview, and you were proven to be wrong. Today, you testify again with a certain level of certitude. Why wouldn't you be wrong this time as well?
Because we have more evidence since then.
Say that again.
We have additional information and the totality of all the situation.
What does this additional information prove? For example, you were speculating as to his state of mind after he struck the body, and it took him longer than you think it should have to stop his car. You were up here speculating as to what must have been going through his mind at the time. What is the additional information that informs that opinion?
The time frame that it's broken down into seconds from the collision and the speed all put together in the total case.
Okay. How does that help you understand the Attorney General's state of mind within a second after the collision?
It's just mere deduction and evidence.
Okay, so what is the evidence that supports your opinions as to what he was thinking?
So if somebody is in a crash and they say that they slam on the brakes, they stop that car within a short distance of time. That is what he told us. That wasn't the truth. He went for a longer, way longer period of time, which indicates to me that he had other thoughts going through his mind at that time.
What was the answer or explanation that he gave for why it took him longer than you thought appropriate to stop his vehicle?
He said he was pumping his brakes and trying to save his own life.
He said he was tapping on the brakes, that he had learned that while in the military that would keep the vehicle from probably potentially sliding out of control, or words to that effect. That is what he explained to you.
That's incorrect. He said he was slamming the brakes or hammering the brakes.
You don't think he used the word tapping on?
I don't believe so.
Okay. Do you have that tapping part? Okay. And what was wrong with that explanation?
I'm sorry?
Is there a problem with that explanation?
With anti-lock brakes, if you slam on the brakes, your car stops faster.
We'll see if we can find it. I believe his words that he was tapping, but he came to a slower stop than I guess your studies or somebody's studies would have shown panic braking would have led him to do. After the charging decisions were made in this case, did you call and express your opposition to those charges to Michael Moore or Emily Sovil, the two state prosecutors?
No, sir, I did not.
And in the years that you've been conducting investigations, typically your role is to investigate, and then ultimately prosecutors make the decisions as to what offenses they believe have been shown by the evidence. Is that a fair statement?
In the state of North Dakota, it would be something comparable, but we're in South Dakota and I'm not aware of all the South Dakota laws that pertain to this. If this event happened in North Dakota, it would have been a felony.
Well, let's go back to South Dakota, and we had South Dakota prosecutors who got your information.
Yes, sir.
And they made the decisions they thought were appropriate. And without regard to what you say would or would not have happened in North Dakota, you do have to accept their decisions, don't you?
Yes.
You're not questioning their competency as prosecutors, are you?
I did not.
Had you ever met Jason Ravensburg before you interviewed him?
No, sir. Had never met him. Did not know him.
You know anything about him?
No, I don't know anything about him other than what I've learned through this investigation.
Okay. And part of the reason I ask that question is if a person had known they'd killed a human being and wanted to cover it up, don't you suppose they would have gone about it just a bit differently than the manner in which you have described here?
Not necessarily.
Mm-hmm. Was it just sheer luck that the sheriff didn't see the body?
In regards to the sheriff, he's obviously deceased now. He was 70 years old, and I don't think he did a complete investigation. That's my thoughts on the sheriff.
Okay. So he avoided that problem. And then coming back the next day and finding the body. And then I believe you were asked about two people with cell phones and both going to the sheriff to report what they had found. And you found that to be an odd thing or unusual?
The fact that one didn't stay because he's a military man and would never leave him behind. The fact that they both left him behind and went to the sheriff.
And from that, you infer a guilty conscience or a guilty mind on his part?
It's just a statement that he said he would never do and did.
And from that, you then infer what?
Another incidence of not being truthful.
Okay. So could you tell me again what it is that he said with regard to the brakes? As far as your recollection goes, what did he say as to how he worked the brakes following the collision?
I believe he said he slammed or hammered the brakes, something to that. I don't remember the exact words, but I don't believe it was tap.
Well, you're part right. He said he was pumping the brakes.
He was also demonstrating at that time. He was hitting his knee and showing that maneuver.
And he said he pumped the brakes. Are you denying that?
No, he did say he pumped the brakes.
And in looking at the transcript, I do see that you said slam the brakes, but he is saying he pumped the brakes. Maybe it's a tomato-tomato comparison, but it's different than you described. Thanks. I don't have any additional questions. Thank you.
Thank you. Redirect Mr. Vargo.
Thank you, Mr. President. Mr. President, I'd like to start by asking Mr. Butler if I could borrow the copy of the report to which he's referring with Sheriff Volick's statements, or at least a reference so that Special Agent Rummel can see it in context.
It's actually in two places. This is one, but there's another two. It's underlined there. But there's another one that I was specifically looking at.
Mr. Butler, can you identify to us what the name of the document is so we can enter that in the record? Mr. Vargo, can you identify this document we're talking about?
Certainly, as best I can. These are ones that the defense bait stamped, so I don't know what their original references are. But it is Ravensburg documents 93 and 95, presumably, Mr. Butler, from the bait stamp version that you submitted.
Stamp numbers, but it also has, I think, report page numbers, and it does reference the investigative entity as well.
Good,
I'm sure
thank
it does. It doesn't necessarily on every page, so.
Please proceed.
So let's start there, if we could, Special Agent Rummel. So in both of those documents is the sheriff's reference to walking past the flashlight, not walking past the piece of debris.
I'm sorry, could you ask the question again, please?
Let me put it this way. The flashlight is found significantly further east to the area of impact than is the piece of debris. Is that correct?
That is correct.
So if in fact the sheriff had walked up to the flashlight, that would have meant that he walked past Mr. Beaver's body. Is that correct?
That is correct.
Okay. The sheriff, at least on one occasion, denied that he'd walked up to the flashlight. Is that correct?
Yes, sir.
And specifically, he said he thought that the flashlight was the headlight of Mr. Ravensburg's vehicle, which had been knocked out and was somehow still functioning.
That is accurate.
From Mr. Ravensburg's second interview, I want to quote you something just so we can see if we can reach some form of consensus on exact language. Do you recall Mr. Ravensburg saying, "I remember hitting it and letting off, hitting it, letting off, hitting it, you know. I don't know if it was 3 or 4 times or I don't know." Do you remember him saying that to you?
Yes, now that it's read to me.
And his explanation as we go further is that if you slam it, you could spin yourself or go in a ditch or roll over or something, is I guess what I knew. That's why I hit hard, but not to the floor. Do you remember that?
Yes, sir.
Does he explain at any point why it would be that he would spin out at 12 miles an hour?
No, he does not.
Mr. Vargo, for the benefit of the members, could you, when you're referring to these report, could you give a page number?
The truth is probably not, because I don't believe that these are numbered. We can find it, and I will make the reference shortly. But I do believe that's all the questions that I have on redirect. Thank you, Special Agent Rummel.
Any further witnesses? Mr. Vargo. Mr. Butler, you may present the respondent's case.
Mr. President, we have no witnesses to present, so we rest.
So the respondent rests.
Mr. President, per your previous question, pages 96 and 97 are the source of those particular quotes of operation.
96 and 97. Thank you, Mr. Vargo. And the respondent rests. Being all right with the members, or whether it is or not, we will take a 15-minute recess. 15 minutes. Senate will return to order. We are now in the question phase of the trial. I've had the senators thank you for submitting your questions. Some of these questions to me are a little confusing, so I've decided to have the members who wrote the questions ask them personally. So I'll go down the list and you can stand, key up your mics, and state your question for the appropriate party. With that, we'll start with Senator Wheeler. I believe you have a question.
Thank you, Mr. President. My first question is directed to the prosecution in general. The articles of impeachment for the first article specify crimes and mention a few statutory crimes, but don't necessarily charge out a specific crime that we're asked to sustain on. I'm asking, is the prosecution asking us to sustain that article based upon any particular crimes?
The prosecution would believe that any of the crimes leading up to the involving the death of Joe Beaver, I think it would be most prudent to consider the crimes that were actually charged, and so would refer the Senate to count 2, improper lane driving. That was specifically mentioned in the articles, and I think it would be appropriate to consider count 3, careless driving, that he was originally charged with as well. This is not a criminal burden of proof, and I think that whether that was pled out or as a part of a plea agreement or a burden of proof matter is not pertinent to these proceedings and could still be considered.
Senator Wheeler.
Thank you. I did want to ask a question of one witness, Joel Ahrens. Joel Ahrens.
Joel, Mr. Ahrens, could you come in? You have a question for a witness? Thank you, sir. Senator Wheeler, would you state your question, please?
Thank you.
And we would remind the witness that you are still under oath. Senator Wheeler.
My question gets to this further issue of whether the sheriff walked by the area in which the body would have been located. We already heard some testimony on that specifically, but I believe you were also in those interviews with Sheriff Volek, and because he is no longer here to testify, I want to ask you specifically, based upon your recollection of what the sheriff said, would he have walked directly by the area where the body was located?
My recollection of what he said is that he did not walk by that, but that if he had went to the flashlight, he would have walked by it, but that he never went and checked the flashlight.
Senator Wheeler?
Thank you. That's all the questions I have for the witness. My third and last question.
You're dismissed. Thank you.
Goes to the respondent. And I would ask the respondent to, at the time of the crash, how far into the shoulder was your vehicle?
I don't know. I would agree that there were at least 2 wheels in the shoulder and possibly 4. I would go with what Mr. Moore, when he appeared before the committee, said, which is that there's an area or an approximation, there's some discretion in the judgment with regard to accident reconstruction. So was he on the shoulder of the road? Yes. How far? I don't know.
Thank you. Are you finished, Senator Wheeler? Thank you. We will move to Senator Otten. You had a couple questions, Senator Otten. You have the floor.
Thank you, Mr. President. The first one is for any one of the investigators. My question is when the Attorney General retrieved his insurance card from the glove box, were the interior lights of the car working? If unknown, were the lights observed to be working or not at any other time during the investigation?
I believe that Joe Ahrens.
Are your microphone on?
Mr. Ahrens is probably the best.
Mr. Ahrens, did you hear the question? You under oath. Would just a reminder, you're still under oath. Would you like to have the question repeated?
Yes, please.
Senator Otten.
My question is so when the Attorney General retrieved his insurance card from the glove box, were the interior lights working? And if unknown, were the interior lights observed to be working or not at any other time during the investigation?
So at the time that he removed the insurance card, it is not known. We don't have any idea. As far as the next, or the day after, 2 days later when we examined the car, I believe it was on. Am I absolutely certain? I am not.
Senator Otten.
That would be my last question for the investigators. Do you want me to proceed to my next?
You're dismissed. State your, you're dismissed. Thank you.
This question would go to, and it's a two-part question to the defense. Actually, more than 2 parts. So my first question is, how many Lincoln Day dinners, approximately, does the Attorney General think he attended in 2021?
Sir, could you repeat that? I wasn't sure.
Could you repeat the question?
How many Lincoln Day dinners, approximately, does the Attorney General believe he attended in 2021?
Zero in 21.
Was he Mr. President, was he not attending a Lincoln Day dinner in 2021 that he was coming back from? Or 2020, I'm sorry. So my question is 2020. My apologies.
In 2020, approximately 10.
A follow-up on that is, so is the Attorney General saying he attends these and other events as a citizen and not as a function of being the Attorney General?
I'm not sure how to answer that question. I mean, he's obviously the Attorney General, but he's going like everyone here goes to political events in their off hours. And I think that's the answer I would stand with. I mean, in terms, I'm not sure, I want to be sure I'm responding to your question. Okay, ask it again, would you? Or
Is the Attorney General stating he attends these and other events as a citizen and not as a function of the Attorney General? Parts of the articles and impeachments and what's been in question is whether the Attorney General is actually performing a function of the office of the Attorney General, so it goes to that.
Well, one, he was not performing the functions, official functions of his office as Attorney General by attending a political event. And I'd probably stay right there with that. Otherwise, you get into the position where once elected until out of office, you are in office. And I don't think there's any support in the Constitution. And I think, as Mr. Garber said earlier, that is a meaningful distinction. But there is not the in-office performance of duties taking place when he went to Redfield.
Mr. President,
Senator Otten.
Does the prosecution have a response to that also?
The prosecution would reference the senators to the Attorney General's own statements and the recorded interviews that he is always on as Attorney General, that he possesses his work cell phone with him at all times. The prosecution is not familiar with a prosecutor in this state who does not anticipate being contacted for work events and is not familiar with off hours for the job. So yes, the prosecution believes certainly at the time it's part of his constantly presenting himself as the Attorney General, and I think in that function it's appropriate. Beyond that, the malfeasance that comes afterwards, he certainly is acting in his capacity as he answers questions and utilizes that title. Thank you.
Senator Otten.
Thank you, Mr. President. And this is a question, not a curiosity, also, I guess. So if the Attorney General was attending the Lincoln Day dinner as Attorney General, but personally, why was he using the state phone for personal use instead of his own personal phone that he had with him?
Who do you wish to direct that question to, Senator Otten?
To the defense, Mr. President. And then a response from the prosecution.
I don't know that I have an answer for that per se, that he does have a work phone, he has a personal phone. And he's indicated to me at times he does use his work phone on, like, for example, here calling his father. I would characterize it as an innocent act, not something malevolent, evil, or illegal, an innocent act.
Thank you. Next question, Senator Otten.
Thank you, Mr. President. Is there a response from the prosecution to that question and answer also? Thank you.
The prosecution's response, Senator, would be that he gets paid to not utilize his personal cell phone. I think that's one of the practical reasons with the On My Way app that he's not utilizing it, but would certainly believe that use of that state cell phone further underscores that he is still serving in his capacity. Thank you.
Thank you. We will move on to Senator Sutton. I believe you have a question.
Thank you, Mr. President. And actually, I have several to the defense. And my first question is to the Attorney General, what made you decide to call 911 first and not a tow truck if you thought you hit a deer?
The Attorney General did not testify here. And it strikes me a little bit as what's happening is I'm going back and asking him questions that he otherwise would have answered had he testified. And I don't say that lightly because it makes me the fall guy that I have no desire to be. He called 911. As to what else, what his thought processes were beyond that, I just can't answer.
My second question,
Senator Sutton, I believe, did you submit to me 2 questions?
Yes, sir.
Okay.
So my second question is, how long was the initial search by the Attorney General and Sheriff Volek after the crash?
You know, I'm not sure that part of it is well documented as to how long they searched themselves. But I would say it's fair to say probably not more than 15 minutes, maybe less, a little bit less. You have the call to 911. Sheriff Volek arrives. He has a conversation with the Attorney General. I think at that point they both believed it was a deer. As Sheriff Volek indicated, he saw nothing unusual at that point about the Attorney General's behavior, but they did go up the road and look. As to how many times, I can't say because it's not clear in the reports.
Okay. That's all, Mr. President.
Thank you. And as a reminder, I was going to ask these questions presented to you from the podium. Thought it was a better idea to allow you to state your questions so you can explain it if there's questions about the questions. But it remains intact. The requirement is that the questions, all questions from the member, be submitted to me in writing. So with that, we will move on to Senator Colbeck.
Thank you, Mr. President. I would like to direct this question to Mr. Rummel.
Please.
I did not hear the
Reminder,
question.
you're under oath. You remain under oath. So
Yes, sir. Thank you. The question I have is, do you know what time the sunrise was on September 30th, 2020? Approximate time.
I do not.
I researched it, and sunrise was at 7:19 a.m. And I believe, if I researched it correctly, it was a sunny day. The body was not discovered until sometime after 9 a.m. that morning. So my question is, and there's been a lot of talk about traffic driving by the scene of that accident. My question is, if the body, as we heard, was lying only less than 3 feet off the shoulder of the road, how come a driver of a vehicle, a car, or a semi-driver, and I'm sure there was traffic, did not discover that body prior to it being found almost 2 hours after sunrise? So how much more difficult would it be to see the body the night by walking the side of the road versus the 2 hours of sunlight that we had that morning of September 13th, 2020?
So I would say, for one thing, at 65 miles an hour, it would be much more difficult to see an item in the ditch versus walking by at 2 miles an hour, 3 miles an hour. So that would be the logic part of it. As far as driving by at 65 miles an hour, there are things in the ditch that you just don't see. And it's not as you all well know, it's not a complete man. There's pieces missing. So with that, it would be so much easier and to see it walking versus driving at 60, 65 miles an hour. Does that answer your question, sir?
Yes, I can understand that, but you also gave testimony that Mr. Beaver was wearing blue jeans and a dark shirt, and that most of that had been removed from his body following the collision, and that his body was totally white or completely white, as we saw in those pictures. And so therefore my question would just kind of be relevant to the fact that if that was the case, and you testified that that was the way the incident was at that accident scene, that his body would not have been seen by some motorist prior to 9:30 a.m. on September 13th. But thank you.
Was that a question? Was that a question, sir? Or was that just a statement?
It was hard. It was,
Sorry,
Senator.
but the question would be is how come that, because of your description of the way the body was and the color of the body, that would not have been seen even at 65 miles an hour?
Yeah, during the daylight, there's more light everywhere compared to at night, where the color of the grass is absorbing what light there is versus the whiteness of the body that is reflective.
Thank you, sir. You're dismissed. Senator Schoenbeck, you have a question?
Thank you, Mr. President. I would direct this to the respondents based on a couple of comments that were made. Does the Attorney General believe that he has a constitutional right against self-incrimination in an impeachment proceeding?
We chose not to call him as a witness. I'm not prepared to go any farther than that.
Any follow-up?
Yes, Mr. President, I would like to hear from the prosecution on that subject of whether or not there was a constitutional right against
Can you
self-incrimination.
hold the mic a little closer? There.
Do you mean to repeat it, Alexis?
No, I think I heard you. The prosecution does not believe there is a constitutional right against self-incrimination in an impeachment process. It's a completely different function.
If I may, the only other observation I would make is the burden of proof is on the prosecution in this case, and so presumably nothing would have to be done by the respondent if it felt that burden was not satisfied. I have not called this a matter of constitutional right against self-incrimination, merely that the burden rests with the government.
There being no further questions, that's all I have on my sheet. Okay. We'll give Senator Curd a second to get his question jotted down. Senator Curd.
Thank you, Mr. President. My question is for Special Agent Rummel.
Mr. Rummel, can you hear us? Welcome back. Go ahead, Senator Curd.
Thank you, Mr. President. Special Agent Rummel, I'm curious if you are familiar with a condition called dissociative amnesia.
No, sir, I'm not.
Mr. President, if you'd allow the latitude to help further my question for the Special Agent and the members of the Senate, I could read a brief definition for you. It comes from the Cleveland Clinic. I'll be brief.
You'll need to hang close to your mic.
Okay. So according to the Cleveland Clinic, this is an extraordinarily rare condition. It affects about 1% of men and 2.6% of women in the general population. In general, dissociative amnesia occurs and has been linked to overwhelming stress, which may be caused by traumatic events such as war, abuse, accidents, or disasters. The person who has experienced such an event may have suffered the trauma individually or just witnessed it. There are several types, one of which is localized. In a localized dissociative amnestic event, memory loss affects specific areas of knowledge or parts of a person's life and could include memory loss for a very specific trauma. One example would be a victim of crime may have no memory of being robbed at gunpoint, but can recall details from the rest of the day with significant degree of certainty. So my question, Special Agent, although this is a rare condition, is it a potentially plausible reason why everything that you have stated before the Senate today and all of the information and facts provided by the prosecution, but still the Attorney General, if this was indeed a rare case of dissociative amnesia, the localized variety, to be an explanation where all things could be true? And I will elaborate slightly by saying that all of the information you provided, all of the prosecution information could all be true, full, and accurate, and I have no reason to believe that it's not, but that what the Attorney General has said could also potentially be valid, that he is unable to recall the specific events and the details because he himself is part of this particular phenomenon, albeit rare.
So the question is, do I believe that he has that?
I'm just wondering if you believe it could be an explanation. He certainly, to my knowledge, has not had a psychological or psychiatric evaluation, and to my knowledge has not been diagnosed with this. I'm just asking if you think it is a potential explanation where all things could be true.
I highly doubt that because he remembers some things that he wants specifically in great detail, things that are part and parcel to it, but the actual events that puts him at blame, that's the amnesia part, or that's the part he doesn't want to remember. The reference that you do is a victim that's held at gunpoint. I don't see the Attorney General as a victim. I see him as a suspect.
Just, Mr. President, same question for prosecution and the respondent, if they would just briefly opine.
Well, state that again, Senator Curd. What did you just say?
The same question, albeit rare, and what I'm offering here is the rare instance of dissociative amnesia, although it be localized, and understanding that the person doesn't necessarily have to experience the trauma themselves. They could only have witnessed it.
So Senator Kurt, I will err on being very generous as far as allowing questions, but it's an odd situation when you're, if this was a viable defense, the defense should have brought it forward, and now you're asking the defense if it's a viable defense. So
I understand, Mr. President. I'll accept whatever ruling you have. I have the same question for the prosecution and the respondent. So.
Okay. Do you wish to answer, Mr. Butler? Or reply?
My response is not so much to attach a label to it, but to look at some common experiences in life where you have or are involved in a traumatic event. Maybe not one involving death, but a traumatic event. And people remember what they remember. It's not always a knowing falsehood if it turns out to be incorrect. When he says I was traveling in the lane, did he believe that to be true at the time? I absolutely believe he did. Did accident reconstruction later come along and require him to reconsider? It did, and he did. That is normal, I believe, when traumatic events occur in our lives. I honestly don't think it necessarily requires a diagnosis as much as it may require us to look honestly at what occurred and not necessarily go back after 6 months and pick apart not just words but snippets of phrases in interviews and see if there is a way to characterize that as a falsehood rather than a misstatement.
And the prosecution's response to that was, no, we do not believe that that is a plausible explanation. If that were the case, then the inconsistencies would not conveniently be designed to mislead law enforcement. And I think that there has been abundance of evidence that's been demonstrated in that result. It wasn't that the Attorney General blacked out in this situation. It wasn't that there are periods of time that he can't explain. He provided explanations that he glossed over, providing the extreme details of other aspects. But there are significant moments where, when given multiple opportunities, and I think the use of his phone is the most blatant example of that, it wasn't good for him to tell the truth about that. He knew that would reflect poorly upon him, so he intentionally lied until law enforcement was able to pull out partial truths. And it's not mischaracterizations, misstatements, or snippets. It's pieces of evidence contained within the Attorney General's own explanations that just don't make sense.
Thank you all. And that brings us to the end of the question phase of this trial. We are going to take a 10-minute break right now. We will come back in at 3:15. At that time, we will receive the closing remarks, starting with the prosecuting side and then the respondent. Witnesses are hereby released. So thank you for your testimony to the witnesses today. We are in recess. Senate will return to order. Mr. Vargo, you can proceed with your closing remarks. 1 hour.
by deed and by word, Jason Ravnsborg has forfeited his right to be the Attorney General of this great state. The House impeachment articles make it very clear that he is charged both with deeds and with words. And we'll begin with Article 1 of the impeachment, which is the misdemeanors while in office. Those misdemeanors are absolutely clear. They are matters for which Mr. Ravnsborg has taken responsibility in a court of law to the extent that it was imposed upon him. His counsel now acknowledges that, in fact, he was driving outside of the lane. So while a good and honorable prosecutor decided that the charges that could be sustained beyond a reasonable doubt were misdemeanors, that does not mean that you should allow yourself to use the phrase that they were only misdemeanors. The words "only a misdemeanor" with respect to the death of a human being are offensive, and in this case, they are misleading. Joe Beaver lost his life. And he lost his life because of a pattern of conduct on the night in question and because of a pattern of conduct over the course of a career. The Attorney General was entirely outside the lane of travel. Mike Moore is not a traffic reconstructionist, and his doubt expressed to the House subcommittee means nothing more than the hesitancy of a prosecutor when you are faced with a standard of beyond a reasonable doubt. But there were warning signs to Jason Ravnsborg as he drove down the road. There is a fog line, which is the primary warning sign. There are the warning signs on steroids in the rumble strip, which Mr. Ravnsborg crossed first with the passenger side of his vehicle and then with the tires on the driver's side of his vehicle. We had a victim in this matter who was doing exactly what he's supposed to do. He is walking on the shoulder. He is walking against the flow of traffic so that he is more visible. He is walking with a flashlight in hand in a dark area where that flashlight stood out like a beacon. And Jason Ravnsborg, the degree of distraction was so severe that he claims that he didn't know what he hit until after he hit it. So one of two things is true, ladies and gentlemen. He is so far outside of the lane of travel, and he is so far from paying attention to where he is going. And I want you to think about this for just a moment, that as all of these things are happening, the GPS tells us that he doesn't brake for 2 seconds after the impact. And then he takes 7 seconds to slow to 12 miles an hour, and then another 7 seconds to slow to 8 miles an hour. When he is that deeply distracted, as John Daly told the House subcommittee, or special committee, we don't necessarily know why he was distracted, but we know that he was distracted. And there is one thing that is crystal clear to every single person in this room. Wherever his attention was, it was not on the road. And it was not on the road as he was accelerating to highway speeds coming out of the city of Highmore. Every single one of us, ladies and gentlemen, has been inattentive while driving. But what do you do while you're accelerating? What do you do in converse when you know maybe you're doing something you shouldn't do? You're looking at that phone. You're playing with the radio. You're reaching for a pop that you've got sitting on the passenger seat or in the seat behind you. You slow down. You take your foot off the gas. You don't bury your head in the sand and keep accelerating. The degree of distraction was extreme. And the habitual nature of that distraction is abundantly clear by his behavior both before and after. At highway speeds, heading down South Dakota's roads, Jason Ravnsborg has his phone on, his cruise control on, if we believe him. That's what he does when he gets outside of the town. And as far as the idea that he was not acting in an official capacity, he was not in office when he committed these misdemeanors, Jason Ravnsborg is the one that tells us, you're the AG, you're always running. He wasn't on stage there because he was a candidate for Attorney General. He was on stage there because he was the Attorney General. And so the misdemeanors, which these days are simply crimes that involve less than a year or less in jail. Class 2 misdemeanors involve 60 days or 30 days or less in jail. Misdemeanors in office, though, relate to the idea of what he was doing and why he was there. If the man is on his state cell phone, the man is coming from an event where he is recognized and accepted as the Attorney General, that man is acting in office. But he compounds what he did with lies. What does he tell you about his speed? What does he tell Special Agent Arts and Special Agent Rummel? I set my cruise control at 65, 67. That's what I would have done. Well, based on what his speedometer shows him, if he sets it at 65 to 67, we know he would have been going 61 to 63 miles an hour. We know that wasn't true. We know that he got up to 77 miles an hour, which means that his speedometer would have showed him that he was going about 81 miles an hour. So we know that he's lying about his speed. We know that he is lying to the people who own the app On My Way. Think about it for a minute. How honest is it if I have two cell phones to connect one to On My Way and be rewarded money, prizes, I don't know what the stuff is, discounts, whatever it is. He's earning benefit by having a phone that he's not using while he's driving. But of course, he's using the other phone at exactly that moment. How honest is that? How truthful, how representative of South Dakota values is it to be lying for pennies a mile? Now, Mr. Ravnsborg and his attorney would like to make a great deal out of his willingness to take a polygraph. I have several responses to that, one of which is he knew from his own people that this was not an appropriate topic for a polygraph. So Tyler Newhart told him, and he told Special Agent Rummel in the interview that he had been told that this was not appropriate because it's hard to prove the what did you know and when did you know it. Whether or not he knew once upon a time, at the moment of the collision, that that was a man, because he now knows it, he would likely fail that polygraph. But there is, of course, an unnamed, unquoted Sioux Falls polygrapher who thinks it's just fine to administer this polygraph. And I got to ask you, why isn't he here and why didn't he give the Attorney General a polygraph? He has every access to that. He could have presented that to you if he chose to do so. So the idea that somehow he was prevented by North Dakota from taking the polygraph is about as honest as the rest of the story that he's told you. He lies about where he is in the lane. And Mr. Butler has several times acknowledged on behalf of the Attorney General that he knows he wasn't in the lane of travel. Which is fascinating, ladies and gentlemen, because it's the first. Jason Ravnsburg lied to 911. He lied to law enforcement. But okay, let's say that he maybe didn't realize he was in the lane. 2 months ago, when the House Special Committee, the House proper, was examining the question of Jason Ravnsburg's impeachment, Mr. Ravnsburg issued a document that he referred to as evidence, allegations, and misconceptions. It's a little weird to think that it's him because he refers to himself routinely in the third person. But in the accompanying letter, he says, I'm going to be issuing this under separate cover or as a separate document. So these are his words, these are his allegations. One of the evidence, allegations, and misconceptions is headed, Jason's vehicle was off the road. False. So he didn't just lie to 911, he didn't just lie to law enforcement, he lied to the House the night before they were going to consider his impeachment proceeding. And he did that with all of the same knowledge that he has here before you today. So he can't claim situational amnesia, he can't claim that he has come around to understanding that he was outside the lane of travel. He lied to the House. And while I know that Mr. Butler will has referred, to the question of whether or not you can simply be mistaken about something, I want you to think about the difference between these events and the simple, logical conclusion that one reaches about the nature of a collision that is catastrophic. Let's assume for a minute that Mr. Ravnsburg is in fact unbelievably distracted, which we do think is true. Let's assume that he's so distracted that he doesn't actually recognize that he's on the shoulder. And then, as he says, wham! The crash happens. Now, first of all, we know that that body rode the front of his hood for about 2.5 seconds. Second of all, we also know that the natural reaction to that, after you probably blink, is that you're going to look up and you're going to see where you are. We can, I suppose, wrap our heads around the idea that he didn't know that he was on the shoulder prior to the crash. But it is not possible, I submit to you, to believe that he did not know that he had been on the shoulder in the immediate aftermath of that crash. And part of what we then learn from him is accidental truths.
And then I turn around and I'm looking into the ditch. So I don't know exactly where I turned around and saw him. I didn't see him. I did not see him.
You've heard better lies from 5-year-olds. But the last and perhaps the most egregious of the lies relates to the question of when and how he uses his phone. And I think it's appropriate that we simply do that. And I want you to understand when we play this clip, this is not reordered. This is in order. Obviously, there's snippets, so we're skipping things. This is in order how he started his story and how he finished his story. And if you can watch this and not come to the conclusion that the Attorney General was deliberately lying to BCI, I suppose we're done.
Do you remember, were you using your phone at all for anything besides to make a couple phone calls?
Nope, the only phone calls I made were to my father.
A flat no.
But you don't remember using your phone for anything other than phone calls? Or to your dad that night on the way home?
Right, yeah.
So when you were driving, you don't remember going into any of these email accounts while you were driving home that night?
No.
Are there any websites that you do frequently use, that you frequent on your phone? Well, when I'm around my house or around, the building, maybe you check out the news and such.
So what would you think, though, if I told you that when they did the phone extraction, they found some internet activity on your phone around that time?
Well, I guess I don't not use my phone, but I did not use it at the time of the crash.
I don't not use my phone.
But were you using it up to the time of the crash?
Not that I recall.
So what were you doing before you got to Highmore? If you set it down at Highmore,
I look at the time and such. I know I do that. I would open it up and I'd see the time better. I glance at it, Okay, nothing sticks out, I guess.
When you say glance at your phone, what do you mean by that?
Glance and see what time it was.
Okay.
Just a periodic check.
But you do have 2 Yahoo accounts. Do you remember signing into either of those? Do you remember being on either of those?
I guess it's possible that I could have checked those, yeah. I don't remember being on my phone. I set it down and I shut the radio off and I looked at the speedometers, the best I remember. Well, I set it down. I remember sitting it down. I pretty confident I shut the radio off and then went, looked at the speedometer. This was the best I remember. And then wham. I was not looking at my phone. I still believe I put the phone down and reached to shut the radio off. Now, was that 10 seconds, 5 seconds, 20 seconds? I don't know. But, wham, it's close relation, I guess. I guess I would say I glance at headlines a lot. I don't read articles when I'm driving. Like I said, I glance at headlines at best. Well, I took the photo, and then the sheriff comes. I don't think I send it until I leave the sheriff. I don't think I call anyone until I'm going down the road again. Do I look at that stuff? Yes. That's what I do. I guess I just see the headlines and stuff. I do that all the time. I look at it, maybe, like a scroll, and if it's a long one, I don't, ever read it. I mean, I can do that when I'm sitting here. I'm like, if they're too long, next.
It goes from, I don't use my phone, to I glance at my phone, to, well, that's what I do. I do it all the time. And if it's too long, I just hit next. And by next, do you think, folks, that he's talking about next, I pay attention to the road, and I drive down the road, and I pay attention to the things that are in front of me? Or do you think that he means he goes to a different article? He lies about whether he saw a human being and about whether he saw the remains of a human being. And much has been made over whether or not Sheriff Volek saw the human being or should have had the same opportunity. Those 2 references to which Mr. Butler referred are in the reconstruction reports from Trooper John Burnt. Trooper Burnt did not speak to Sheriff Volek. He was relating from his own understanding. How he made that mistake, I have no idea. It doesn't matter. If you look at the reports that were filed by Special Agent Arendz and Special Agent Rummel and Sheriff Volek's own description, he never says that he went up to the flashlight. But we've transitioned into a place where the Attorney General wants you to feel sorry for him. in his evidence, allegations, and misconceptions, the final one was Jason was treated differently because he is the Attorney General, and the italicized word right after that is true. And it is certainly true that he was on the news more than you and I would be, and we're on the news if we did something like this more than an average citizen would be. That part's true. There is a certain degree of scrutiny that comes with public office, and if you can't embrace that, you probably shouldn't be in public office. But let's look a little bit at what it is that didn't happen to him that would have happened to every other citizen of the state of South Dakota. He did not give a blood test till the next day. He did not give a blood test while he was on scene. He did not give a breath test till the next day. He did not give a breath test while he was till he was off scene. He was loaned the sheriff's personal vehicle. Now, I know we're real friendly folk here, but I don't think that happens all that often. He is not questioned on scene the night of. Sheriff Volek doesn't ask him anything about other than, oh, you hit a deer, okay. But then, and perhaps more to the point, he's not questioned the next day. We now know that a man lies dead. And the sheriff's response to that is to tell Tim Borman, oh, go take care of him. You want to know the quality of this investigation up to the point that BCI took over? It is encapsulated in that phrase, go take care of him. Doesn't ask, how did you not know it was a human being? Doesn't ask, how did it happen? Were you on your phone? Nothing. No questions at all until 2 days later. He turns off his phone. And when he is told, we need both your phones. And I submit that there's no doubt but that a search warrant could have issued on them had he not been cooperative. And he did sign the consent, don't get me wrong. He insists on keeping one phone because, well, I am still the Attorney General. Does that sound to you like the sort of thing that some poor mechanic, waitress, rancher would be allowed to do? So was he treated differently? He absolutely was, to his great benefit. So I want to address the question of impeachment and the standards that you apply here. LRC has provided you with an outline or a statement that each senator should make the decision on impeachment questions based on how they view the evidence and the performance of their duties as a state senator, and with regard to the oath of office they took to perform these duties. This is neither a criminal nor a civil legal proceeding. It is a constitutionally prescribed impeachment trial that you serve on and decide pursuant to your election to the office of state senate, and you should decide it as you see appropriate in fulfilling the duties of your office. And that is exactly the standard that was articulated as I listened to some of the podcasts that Mr. Garber has about impeachment. One of the folks that he had on as a guest was the prosecutor who prosecuted Elsie Hastings, federal judge who was accused of taking bribes. And the prosecutor basically said, the standard is whatever the Senate decides the standard is. And each individual senator, more to the point, whichever they decide the standard is. And another nationally recognized impeachment scholar has said that impeachment and the criminal matter are entirely independent of each other and should be treated separately. That expert is Ross Garber. When Nancy Pelosi thought that, well, you can't impeach Trump. She didn't have that opinion for very long, by the way, but for a while she held that. And he disagreed with her. I understand why we worry about impeachment. I understand why this can't simply be a given. In Federalist 65, Alexander Hamilton wrote that impeachment will seldom fail to agitate the passions of the whole community and to divide it into parties. There will always be the greatest danger that the decision will be regulated more by the competitive strength of the parties than by the real demonstrations of innocence or guilt. But I respectfully submit to you that that is not what has happened here. This chamber, I don't think I need to point out to you, is largely composed of the partisan allies of the Attorney General. There are multiple members of this chamber who wrote or texted to the Attorney General in the days following the crash, expressing their condolences to him, some, bless their hearts, to the family of Joe Beaver, and expressing their joy that Mr. Ravnsborg was unharmed. If there are factions that now exist in the question of whether or not the Attorney General deserves to be impeached, they arose from the events of impeachment. This is not a situation where one sector of the party had it out for Jason Ravnsborg and just waited for the moment when they could find something he did wrong. You, of all people, know that prior to this event, there wasn't a Jason faction and a not Jason faction. He was the Attorney General, and he was treated as such. If this created factions, it created them based on the Attorney General's conduct and candor, not a question of the subsets of the Republican Party. And I will point out that Mr. Garber's analysis of when impeachment is appropriate, judged by who actually got impeached, ignores a very important matter, which is the question of resignations. Mr. Garber, as he pointed out to me, has now represented 5 governors who were charged formally, investigated, or formal proceedings were initiated as it related to impeachment. 3 of those 5, ladies and gentlemen, resigned. If we defer the decision about whether an official should leave office to their resignation, we are relying on people who have demonstrably done bad things to make the moral decision about what their punishment should be. And I am old enough to recall that every once in a while, my father let me pick a punishment. Let me just tell you, that was not meant to be pleasant for me. And it was largely because if I suggested something too light, I knew that he would come up with the actual real punishment. But because this Attorney General has not done the right thing, because he has not chosen to acknowledge the harm that he has done to the reputation of law enforcement, of the bar, of prosecution, and of elected officials in this state, you now have the responsibility to do the right thing. And those cases to which Mr. Garber referred in opening, about cases that were impeached, I submit that at least a few of them are strikingly similar to what we have here. Money is the easy thing to look at. When you steal money, we kind of understand that we're against that. Who steals money steals trash. Who steals my good name? He put Brent Gromer into an impossible situation. A career law enforcement officer who was put between a rock and a hard place and kind of found an out by not really saying much of anything. But if loaning money to yourself is an appropriate grounds for impeachment, which Mr. Garber suggested, or if helping your son's election campaign is an appropriate grounds for impeachment, so too does it seem that stealing the knowledge and expertise of a good and honorable officer is grounds for impeachment. And then we get to the question of what it means to be in office. It feels like that moment where, in order to buy this argument, you truly have to just stick your head in the sand. This man made this about his office. When you lead with 911 with "I am the Attorney General," to what end? Because it works for him. It has worked for him, and it is.
Allie, this. say this. Well, Allie, I'm the Attorney General. Being a statewide official, I had pictures taken with people, and I have pictures of me on the stage.
Is there any reason why you're traveling that fast? I'm going to drill, and I'm the commander.
I regularly tell Tim and Dave where I'm at. Okay. As Attorney General.
Are you law enforcement? Okay. State car. Okay. Actually, the Attorney General.
And then just that I am the Attorney General availability. I call and I said, I am the Attorney General. Who is this? Is the response I get. You know, I am still the Attorney General. You're Attorney General, you're always running. Something to the effect of, hello, 911, this is the Attorney General.
Okay, so my other thing is, I'm also the Attorney General in South Dakota.
Ask yourself on any of those whether there was any legitimate purpose to informing the person who had pulled him over or the person to whom he was speaking to emphasize that he was the Attorney General. You can even see it in, or hear it in the 911 call, and see it in that very last clip when he's pulled over, I believe it's Nebraska. His hesitation. Well, Allie, I'm the Attorney General. Or when he's talking to the trooper on the side of the road there and he says, well, here's the other thing. And then he stops, he turns off the car, and he does this thing that appears to be his go-to gesture, and he says, thing is, I'm the Attorney General in South Dakota. Now, that's the same stop where he's already tried when the trooper asks him, why are you driving so fast? And he says, well, I'm going to drill and I'm the commander. Again, is there a legitimate reason to say that I'm the commander and that's why I'm speeding? Or is that just designed to impress upon the officer that I'm a big deal and you should probably just believe me and let me go? Historically, and in this case, Jason Ravnsborg uses his office to get out of trouble. He does it on the 911 call. Ask yourselves about the press release that he issued the next day. Now, drafted by a friend of his who's a representative with Tim Borman, who's a state employee. But it goes out on Attorney General letterhead. And does it simply reassure the public, hey, a bad thing happened, but I'm on the job, the office will continue to run? That's not at all what it says. It lays out the facts of the case. It begins his defense. It is the germ of what he is going to tell the world. It is his trial balloon, and it is out there on Attorney General letterhead. Is that the use of his office in an appropriate manner or an inappropriate manner? Why else is the chief of staff of the Attorney General's office the one that sets up your blood test? Is that an appropriate use of state employees? Why else does he talk to both Brent Gromer and Tyler Newharth about what it is that law enforcement is going to be able to find if they examine either, in one case, the polygraph, and in the other case, his phone? The day after, well, I don't know if I got it the day after, but the day after the impeachment vote in the House as a whole, in April, I received a letter from the Law Enforcement Standards and Training Division that referenced an officer who has the potential to testify in Pennington County who had been removed from the academy for lying. So we're talking about a kid not yet through the academy who lied, and let me be very specific here. The allegation is that he lied about whether he had done his homework. And as a result of that, he was booted out of the academy. So if we hold that youngster to a standard of professionalism and integrity and honesty that we don't hold our Attorney General to, what are we saying about ourselves? And what are we saying about the point of being elected in this state? Mr. Ravnsborg can come up and say, well, I really wasn't on the phone at the time of the crash, so none of this really matters. My lies about phone use, Bill Clinton did that one to us. he convinced the Senate that it didn't matter as long as the lie wasn't an important lie. Bill Clinton wasn't an attorney, he wasn't an attorney general, and he didn't act as the chief law enforcement officer of anything. He acted as the commander-in-chief. But we know what would happen to any officer, patrol officer, who did what Jason Ravnsborg did, and they would be a former officer, and that is what he should be as well. South Dakota law makes it a crime to lie in a criminal investigation, and I don't think I really need to cite chapter and verse to a bunch of people from South Dakota about integrity and honesty and why we don't lie in public life. Now, Mr. Butler has suggested that Mr. Ravnsborg was mistaken about being outside of his lane. Again, I bring you back to the fact that it's just not possible that he didn't know immediately after the crash, even if he didn't know immediately before the crash. And I also bring you back to the fact that he didn't simply tell that lie once. He told it probably half a dozen to a dozen times in the course of those interviews with law enforcement. And most of the time, I shouldn't say most of the time, several times, he makes a very clear gesture. He's going to the right. He's pulling over. He's trying to save his life. Only if he'd done any of that, he would have ended up in the ditch next to Joe Beaver's pickup. So those are the two questions that you have before you. There is a third, though. In the event that you vote to impeach, which I submit you should, I've often been warned you can't tell a judge or a legislator that they must do anything. And so I suppose legislators who are also judges, that would be particularly difficult. You also have to decide a question of debarment. In other words, can Mr. Ravnsborg ever run again? And I submit to you that if you have made the primary decision that he should be impeached, that becomes a fairly easy answer. But I want you also to think about this statement that he has made.
Well, again, the hardest part of this is I wouldn't do anything different. I didn't know that this was going to happen to me, obviously. Again, why would a man be walking down the road? I believe I'm on the road, and wham, and my life changes. I called 911. I got the sheriff out there.
This happened to me. My life changed. And most importantly of all, most offensively of all, I would not do anything different. How about you just look where you're going? That'd be something you could do different, and Joe Beaver would still be alive. How about you stay in your lane? We know for sure Joe Beaver would be alive then. And so if we think, if you believe that an impeachment vote is proper, the idea that the person who you're impeaching has already said, I'm going to go out and do it again. I wouldn't change a single thing I did. And you know how he's telling the truth on that one? Because he did. 10 minutes down the road, he's sending pictures via text message while he drives somebody else's car after Joe Beaver lies dead. So we know he's willing to do it again. And so if he is unfit to serve as Attorney General today, he will be unfit to serve as Attorney General tomorrow, and he will be unfit to serve as Attorney General in any foreseeable future. And so the debarment vote should closely follow the question of impeachment. Mr. Ravnsborg's attorneys have taken great pains to raise the specter of what impeachment would mean. They've used phrases like overturning an election, risking constitutional, I don't know if they use the word crisis, undercutting democracy itself, They referred to the genius of the American system. But the genius of the American system is where we got impeachment from. And there are consequences to inaction as well. There are consequences to law enforcement, who you have then told that little lies are okay. Even lies that result in somebody's death or lies about somebody's death can be okay. There are consequences to the bar where we have a duty of candor which has very clearly been violated. There are consequences to prosecution. Every South Dakota prosecutor that I know holds dear the idea that we don't do this for the cash. Go to your county commissions, ask them what they're paying us. I guarantee the men and women who fill those roles are not there because they are making the most money they possibly could. But there are also consequences to this great state as a whole and to our community as a whole. And none greater than this, that you will place a stamp of approval on Jason Ravnsborg's view of how office and position work. You would effectively endorse the idea that there comes a point when you are too powerful to fail, too powerful to be held accountable. And that there are two standards of law in this great state, one for patrol deputies and another for the chief law enforcement officer. And oh, the one for the chief law enforcement officer is lower. There are two standards in this state, one for working people and another for elected people. You will reinforce the idea that our elected officials are separate from and above the laws that you pass, and that they are sworn to enforce. By your vote here today, you will decide whether you want that to be who we are, and we will be seen as in our South Dakota.
We will now take closing remarks from the respondent, Mike Butler. Sorry, Mr. Garber. You have 1 hour.
Thank you. You're going to hear from Mr. Butler in just a couple of minutes. There were a lot of factual assertions that we heard, and Mr. Butler is going to address those. But before he does, I think I'd like to see if I could reorient us on the standards. As we've discussed before, it is true, I'm engaged by governor's offices to come in and explain the standard for impeachment and how it's applied. I teach a law school class where I explain to my students, here's the history of impeachments, here's the standards for impeachments, here's how they're applied. And if there's an acquittal in this case, I can explain that to everybody. I can explain that the Senate of South Dakota acted as a bulwark as the system is designed. I will tell you it would be very hard to explain a conviction. I've spent the day listening to what sounded like a prosecution of a vehicular crime. But we know that those criminal issues have already been resolved. There was also essentially a prosecutorial argument about lying to law enforcement. Notably, the Attorney General wasn't charged with that, hasn't been charged with that. But also, this isn't a criminal case. This is, as we know, an impeachment and removal case. And removal in this situation cannot be sustained without doing violence to some significant parts of the Constitution. For example, as I explained earlier, the notion of separation and balance of powers, co-equal branches. This is not the United Kingdom. This isn't a form of government that's parliamentary in nature. There's no vote of no confidence in this system. The executive branch is co-equal with the legislative branch. The legislative branch doesn't oversee the executive branch in that way. And removal in this case would actually do violence to the provision of your Constitution dealing with elections, where it's actually the voters who choose who the Attorney General is. It's the Constitution that prescribes the term of office. The legislative branch, the Senate, with all due respect, doesn't cut those things short, absent incredibly extraordinary circumstances. And if the circumstances were, as my friend suggested, we would have seen many, many, many more removals of public officials. Imagine if the standard were telling untruths. We would see many, many, many more of these kinds of proceedings. But that's not the standard. The standard, as we've talked about, is in your Constitution. The governor and other state and judicial officers, and the standard that, again, that you apply here is applicable to all of these other officials, shall be liable to impeachment for drunkenness, crimes, corrupt conduct, or malfeasance or misdemeanor in office. Now, you can't read the in office part out of the Constitution. And you also can't stretch it to the point where it would be meaningless, where an elected official is essentially in office 24 hours a day. That would read it out of the Constitution. I would urge you to look at two documents. One is a submission that I made to the House, going on at much more length than you're thankfully hearing today about the standards for impeachment. And the other is a report that the House Special Committee put together, which I think is quite well done. And it goes element by element by element. And in that report, it does note a decision by the Nebraska Supreme Court addressing impeachment of an attorney general in that case, where the Nebraska Supreme Court said that in office means, quote, act or omission for which, in that case it was the attorney general, may be impeached and removed from office, must relate to the duties of that office. And I'd ask you to focus on that standard. Is that what was happening here? Has that standard been met? Same thing with the standard for malfeasance. Again, the House Select Committee cited a case from the South Dakota Supreme Court saying, quote, reference to evil conduct in the context of malfeasance, reference to evil conduct or an illegal deed, the doing of that which one ought not to do, the performance of an act by an officer in his official capacity that is wholly illegal and wrongful. Again, members of the Senate, this isn't a criminal proceeding, despite how it seemed today. This isn't a civil proceeding. This isn't a bar proceeding. This isn't a vote of no confidence. This isn't an employment proceeding. This is a very rare removal proceeding, and very different standards apply. And with respect to the burden, it is true. You determine what the burden is, and what I mean by that is that the Supreme Court is not going to second guess you, is not going to ask you what was the standard of proof that you applied, isn't going to prescribe for you a standard of proof and say that you missed it. That was the lesson of Nixon versus United States, where the United States Supreme Court said that the Senate gets to make its procedures in the case of impeachment and removal. But as the House noted, the correct standard actually is at least clear, satisfactory, and convincing. That's the standard that the South Dakota Supreme Court applied to lower government officials. Certainly for a statewide official, it should be at least that high. Clear, satisfactory, and convincing. And I'll leave you with a reminder of what the U.S. House Judiciary Committee said in the context of the Nixon impeachment. Impeachment is a constitutional remedy addressed to serious offenses against the system of government. Impeachment is directed to address constitutional wrongs that subvert the structure of government or undermine the integrity of office and even the Constitution itself. The crucial factor, the report went on, is not the intrinsic quality of behavior, but the significance of its effect upon our constitutional system or the functioning of our government. Members of the Senate, that standard, those principles have not been met, not even close. I couldn't begin to explain an argument that they have. And so I think acquittal is the only answer here. And Mr. President, members of the Senate, Council, I appreciate your hospitality in having me here and listening to my discussion about this. And with that, I will turn it over to Mr. Butler.
Further closing remarks, Mr. Butler.
When we opened this morning, I referred the Senate to the articles of impeachment. Article 1 charged Attorney General Jason Ravensburg committed crimes causing the death of Joseph Beaver. As I pointed out then and I point out now, there was no finding of criminal culpability in the death, the tragic death of Joseph Beaver. No amount of fire and brimstone changes that as a given fact. The prosecution did slightly shift, either intentionally or not, to, instead of crimes, referring to it as misdemeanors in office. Is that important? It certainly can be, because we are back to in office. And as my co-counsel has pointed out, those words are central to the question of removal from office and when it can occur. Now, the prosecution, with regard to the in-office requirement that they must prove, said once Attorney General, always Attorney General. I would submit that's not a legal argument. It's a phrase, but it's not a legal argument. In office, as courts have looked at it, involves illegal or evil behavior involving the use of your office, not a traffic accident. Misdemeanor in office. The Florida Supreme Court defined the term misdemeanor in office as any act involving moral turpitude which is contrary to justice, honesty, principles, or good morals if performed by virtue or authority in office. The court found that misdemeanor in office is synonymous with misconduct in office. The term misdemeanor historically was adopted to apply to all offenses other than treason or felony. It says nothing about driving off the shoulder of a road. It must be a serious offense. The Senate should not be reduced to a traffic court. That's not the role that you would be playing here today. It is whether, for the first time ever, the conduct in office, the misdemeanor in office, was so egregious, unlawful, and evil, it warrants his removal. Not we're 2 tires off the road or we're 4. The second article of impeachment, malfeasance in office. Again, the conduct of your office. Do we really think that means when you call 911 after an accident, you identify yourself as the Attorney General? Is there any serious argument to be made by a serious-minded person that that warrants removal from office? I'm the Attorney General. You got to go. You can't do that. As counsel said, we literally would have to back up the school bus then, if that is the direction we would go, in minimizing and trivializing the seriousness of what went on here today. Not of the death of Joseph Beaver. That is a serious matter. And there was a civil settlement for negligence. Negligence is a civil standard, different than the criminal standard. But the family did receive a settlement. And they couldn't have done it without the Attorney General's cooperation. Going back to some of the facts of the case, as much as I really don't care to, because I really think it's beside the point. But there was one in particular, and it involved the sheriff, and what he said or didn't say about walking past the body. Now, I have 2 reports, neither of which I prepared, both of which the Bureau of Criminal Investigation did prepare. And I'll read them to you, the relevant part. On the report, it says, page 43, Sheriff Volek states he does not see Mr. Beaver's body, but agrees he had to walk directly past it. Page 13, the sheriff states he would have walked past Mr. Beaver's body to get to the flashlight. Now, we are told to disregard that because there's no good answer for it, other than Sheriff Volek didn't see it. It was dark, it was cloudy, the road was not lit up. The body was in a ditch, and the ditch sloped away from the road. It just happened. And for the government to simply fill in the blanks with a witness who acknowledged, I kept this out of my reports, all the different things about people being honest or what he can read into someone's mind and how each little action or behavior informed him of the dishonesty. That he kept out because it has no place in police reports, number one. I had never heard of it or seen it until today, and I suspect for good reason. And as sure as that officer is of himself, when he was asked, did he tell the Attorney General, you were on your phone? We know that. Second interview, September 30th, 2020. He admitted that he did do that. He admitted that he did believe that. The Attorney General said, I was not. Forensic evidence established the Attorney General was correct, and he was not. And yet I tell you, had it not been for the forensic evidence, he would have added that to his list to stand here and tell you he knows he's right. The human lie detector. And speaking of such, the Attorney General offered to take a polygraph, period. Even if he had been told, well, there could be a problem, because now you know the gentleman is deceased. I'll still take it, absolutely. All that remained for them to do is give you reasons they did not believe he should take it. Fine. But he never backed off, and he said, I would, absolutely. That is an action of someone who has an innocent state of mind. It's not the defendant saying, oh, I've heard bad things, I don't want to do it. It's the Attorney General saying, I have heard things, but I will do it. It has been a long day, and I'm not going to make it longer. But I want to leave you with a thought. What you do here today does make history in one form or another. Long after your terms have ended and I've been replaced, you've been replaced, and we've all been replaced. And they'll look back and wonder, what did they mean? And will they say, he was not well liked, that Attorney General. He'd lost the confidence of law enforcement, or of the people, or of the governor. Well, losing the confidence isn't grounds for impeachment either. That takes place at a ballot box, or, as will happen here in a few days, at a convention. And as we all know, he has lost on that level because he is not seeking the re-election. But he does seek to vindicate himself. The right answer here is the two articles alleging conduct occurring in office were not established by clear and convincing evidence. And again, I think it is important, so I'll read it one last time and then I'll close. Clear and convincing evidence is evidence that is so clear, direct, weighty, and convincing as to allow the trier of fact to reach clear conviction of precise facts at issue without hesitancy as to their truth. If that cannot be done on both counts, both articles, on the in-office component, it's done. But I submit to you this matter never should have been here in the first place. It was a tragedy and always will be. But justice isn't always done by not following the law to seek vindication. That will always be regretted in time. Whatever moment of feeling good someone gets from removing this man from office because he did cause the death, not criminally so, but he did. Whatever temporary satisfaction you get, this state will live with that in history. I hope and I do trust that you will not let that happen. Thank you very much.
We are going to recess for a 15-minute break, and we've got to do some setup to get ready for the votes. So the Senate is in recess. Second vote. First of all, they will be put to you in a form of a question. These questions are debatable. They will require a 2/3 majority vote. A motion to reconsider is never in order. Beyond that, the regular rules of debate will apply. Also remind the members that we have a court reporter. When we do the voice vote, we need you to speak up. Okay? We will get started. On Article 1, the question before the Senate is, shall the Senate sustain the first article of impeachment, crimes causing the deaths of Joseph Beaver against Attorney General Jason Ravnsborg and remove him from the office of Attorney General? Are there any remarks? Senator Schoenbeck.
Thank you, Mr. President. Members of the body. Every day in South Dakota, somewhere, our friends, our family, our neighbors are highly likely to be out walking somewhere on a road. It's not an unusual event. In the summer, we probably have tourists, flat tire, out of gas, any number of things. Could be Highway 12, 212, 81, 50, it doesn't matter. Picture that person that you know walking where they're supposed to be along the road, like hundreds, if not thousands, of South Dakotans do every year. Now picture a vehicle coming at them at highway speeds. And this vehicle has had its first set of tires on the side go over the fog line, then the rumble strips, which make a hell of a lot of noise. Then the other two tires, they've crossed the fog line, now they've crossed the rumble strips, and they're bearing down on that family or friend or neighbor that you know, and they smash them at highway speeds, accelerating their body to the highway speed that the car's accelerating to, so hard they put the face through the windshield so the driver of this vehicle could actually reach over and touch that face. And if the defense is, I was not a distracted driver, then there's a way, way bigger set of facts here we should be thinking about, because that means this person ran down that family, friend, or neighbor at highway speeds, seeing them right in front of them, put their head through the windshield. They were on the vehicle for a couple of seconds before the body rolls off and says, I hit something. Well, that was a lie. There is no question that was a lie. There's no question that this person ran down an innocent South Dakotan, ran them down. And we do not have to leave our decisions about crimes to the charging decisions of the Deputy State's Attorney for Hyde County. We don't have to. If we think that's criminal conduct, then it is criminal conduct for purposes of the Constitution. There's some other statements that have been made here. There is no such thing as a burden of proof. And every one of you knows that, because we make a couple thousand votes a year. And we don't sit down and say, beyond a reasonable doubt, clear and convincing, okay, I'll vote for that water bill or I won't. It doesn't work that way. What we do is the instructions or the statements that have been shared with all of you, that each senator should make the decision on the impeachment question based upon how they view the evidence in the performance of their duties as a state senator with regard to the oath of office they took to perform those duties. This is neither a criminal or a civil legal proceeding. It is exactly what you do with every single decision you have made every year and every day you've been in this body. There's no such thing as a burden of proof. So this discussion about clear and convincing, that's all made up. That's all made up. And here's another interesting thing. There is no such thing as a right against self-incrimination in this proceeding. That's a criminal concept. So the Attorney General, if he was going to, as the phrase, I didn't write it down, but vigorously defend or something, there's a mic right there. And that's a damn short walk. And somebody could have got up there and told us why the heck, if he wasn't a distracted driver, why he ran down a South Dakota citizen at highway speeds and put their head through his windshield and then lied about it. He had no right against self-incrimination. He chose not to be here to share with us what the hell he was doing killing that person. The issues about the tires off the road, those are science. The standards used by the National Highway Traffic Safety Institute to reconstruct, that's not guesswork, that's not magic. The law enforcement officers had no reason to make any of this up. We'll talk about malfeasance with the next one, but this one, as to criminal conduct, if this was anybody besides the Attorney General that did that to your neighbor, your family, your friend, we wouldn't be having this discussion. Why this is dragged out, why we're even having this trial is beyond me. This is only because of the sordid political agendas other folks have. There should have been a resignation a long time ago. There should have been contrition that hasn't happened, and there should be impeachment. Thank you.
Further remarks? Senator Heinert.
Mr. President. Senators, we were tasked with, it seems like an impossible task. It's never happened in the state before. Nobody wanted to be here. The Attorney General doesn't want to be here. We don't want to be here. The family of Joseph Beaver doesn't want to be here. But here we are. We were told that this isn't a criminal or a civil trial. So I'm not an attorney. I know a few members of our body, they are. So how do I reconcile all of this information that we've received? And it comes down to, what do you believe? Do you believe the actions that the Attorney General took prior to that accident and after warrant his removal from office? Now, I looked at the data, and I was extremely disheartened when I saw some of those pictures and when I read the reports. That man laid out there for almost a day. And in our way, you cannot go on your journey when that happens. With all of these proceedings happening right now, he still cannot go. So he's waiting for us to finish this. There was something that really struck me as we've went through this. I'm going to pause right now. That's how long it took for the time that he struck Mr. Beaver to stop his car. 18 seconds. He went over a football field and a half before he stopped. So what do I believe? Why did it take so long? Why was he so far down the road? What I believe is he knew. He knew that something terrible happened, and he was going to have to answer for it, and he panicked. And he thought, maybe if I get far enough down the road, they won't see what's laying in the ditch back here. And it worked. Worked the whole night. So if I believe that, then I have to look at what else was done. And from everything I've read, everything I've seen, and what I believe, I have to sustain this article of impeachment. Ask yourself if you believe it too.
Further remarks?
Mr. President.
Senator Kamak.
Mr. President, every day in South Dakota, there are folks that drive outside the lane of traffic. But in this instance, we've got, the science says that very likely there were 4 wheels outside across that fog line, 4 wheels that had crossed a rumble strip. Anybody that's crossed a rumble strip, you can, even if you're not in the car, you can hear it forever. And they crossed the rumble strip twice and ended up in the taking of a human life. In the end, regardless of the outcome of these questions, there will be no winners. It's not possible. But I ask that you vote yes on the question. Thank you.
Further remarks? Senator Rush.
Thank you, Mr. President. Ladies and gentlemen of the Senate, my fellow senators, my friends here after 8 years in this body, I never imagined in those 8 years that I would approach this on this kind of an issue regarding the impeachment of another person that I had regarded as my friend for many years. I think I've probably known the Attorney General longer than anyone else here. He started practicing in my court in Yankton when he first got out of law school. He appeared in my court numerous times. And, you know, I've difficulty reconciling the young man and the maturing man that I knew there in my court with a lot of the testimony here today. Based on my personal experiences with him, I don't believe that he would get up here and deliberately lie about these issues. But the fact that he isn't lying doesn't mean that his recollection about what happened is necessarily accurate. You know, that's one thing that I learned in many, many years in the courtroom is that people can tell absolutely what they think is the truth, and it's not the truth because they recollect things differently. You know, I don't think there's any evidence to support the claim by his cousin that he committed suicide by throwing himself in front of the car. I don't think there's any evidence to support a claim by his other cousin that this is some kind of a gigantic cover-up because he's an elected official. You know, if that was true, we wouldn't be here today. You know, I'm impressed with the investigation that the North Dakota BCI did. I think they did an absolutely thorough investigation and followed up on every possible lead that they could. You know, the issue addressed by the House Investigating Committee that he can't be impeached because this was not part of his official office duties as Attorney General is inaccurate in my opinion. He identified himself as the Attorney General. He consulted with the Attorney General's office staff about how to proceed in this matter. He consulted with the head of the Division of Criminal Investigation about this matter. He consulted with the Attorney General's office chief of staff. He consulted with different DCI experts about the cell phone and polygraph. He put out a press release on AG's office stationery. You know, regretfully, I think that the actions that he took after the accident converted this into something directly involving the Attorney General's office in the entire matter. And a result of that, this was treated differently than your ordinary vehicular homicide case. The decision what to charge him with was made by a committee of prosecutors. He was allowed to plead to 2 Class 2 misdemeanors. And just as an aside, I was one of the substitute justices that sat on the Bill Janklow case. Bill Janklow, in a similar case, although I would have to say much more egregious,
was convicted of second-degree manslaughter for that, and he served his sentence on that. He was, of course, a federal officer at that time, not subject to impeachment, but the prosecutor there made the decision to go ahead and try the case and left the decision to a jury of Moody County jurors, and that didn't happen in this case. In this case, the case was plea bargained away to a couple of Class 2 misdemeanors, and that's not our decision. We're bound by that decision. I spent a dozen years as a prosecutor. I'm adamant about the powers and the rights of a prosecutor, and we don't have a right to second-guess those charging decisions. But we certainly have a right to think about whether it should have been plea bargained down to that level. In preparation for this hearing, I don't want to call it a trial, this impeachment hearing, I got a book about the impeachment of Andrew Johnson, which is, of course, the most important impeachment that we've had in the United States. And if I could just read a paragraph or so here. So in 1868, Congress and the public would have to consider the definition of a high crime and the meaning of a misdemeanor. It was bewildering. The multitude of strangers were waiting for impeachment, Mark Twain observed. They did not know what impeachment was exactly, but they had a general idea that it would come in the form of an avalanche or a thunderclap, or that maybe the roof would fall in. For no one knew what the first ever impeachment of the President of the United States would look like, or what sufficient grounds, legal or otherwise, were necessary. No one knew, partly because the U.S. Constitution provides few guidelines about impeachment beyond stipulating in Article 2, Section 4, that a federal officer can be impeached for treason, bribery, or a high crime or misdemeanor. The President, if the President of the United States was to be impeached for treason, bribery, or a high crime or misdemeanor, then the country had to define high crime. Originally, the crime warranting impeachment was maladministration, but James Madison had objected as the term was too hazy. Yet high crimes and misdemeanors is fuzzy too. Alexander Hamilton clarified, sort of, a high crime is an abuse of executive authority proceeding from an abuse or violation of some public trust. Impeachment is a national inquest into the conduct of public men. Fuzzy again. Are impeachments to proceed because of violations of law or infractions against that murky thing called public trust? But surely, if the only crimes that were impeachable were high, then the founders must have meant high misdemeanors as well. For a misdemeanor is a legal offense, ranked below that of a felony. Could a president be impeached for any misdemeanor, like stealing a chicken, or did it have to be something well higher? And don't want in any way to indicate that the death of a human being is equivalent to stealing a chicken. But in this case, the misdemeanors that were charged were equivalent to that. What really troubles me about these proceedings is I don't know what happened here. I'm troubled by that. It's clear that Attorney General Ravnsborg has a long history of being a poor driver. He doesn't pay attention when he drives, and it was his plan that night that he wasn't going to pay attention because he was going to be thinking about upcoming cases. How fast was he driving? Was he using his cell phone when he hit Mr. Beaver? How did he get on the shoulder of the highway? No explanation of why he didn't see Mr. Beaver walking along the road with a flashlight. No satisfactory explanation about why he didn't see Mr. Beaver's face in his windshield. No satisfactory explanation about why he didn't see the body or why the sheriff didn't see the body when they apparently or may have walked right by it. No satisfactory explanation of why the sheriff didn't investigate the lit flashlight when he saw it. But the count 1 charges that he has been committed of crimes. He's only been convicted of a couple of Class 2 misdemeanors, traffic offenses. So do we impeach for Class 2 misdemeanors? And I guess my answer to that is no. And I may have a different answer to that in respect to count 2, but my answer in count 1 is that we don't impeach for Class 2 misdemeanors. Thank you.
Further remarks? Senator Castleberry.
Thank you, Mr. President. When I was growing up, I went between our two houses, which one was in Rapid Valley and one was in Hill City. And so many times during the week, we would drive back and forth on Highway 16 and Highway 385. And throughout my childhood, we probably hit 10 deer. And I will tell you, the one thing that we always did, because it was the humane thing to do, was to stop and ensure that that animal was deceased. And when it was practical, if they were not, my mother would discharge a firearm to ensure that that animal did not suffer. When he thought that he had struck a deer, he called 911 and he stayed. When he knew that he had struck a human, he did not call 911 and he left. There's no question here that this is a tragedy of chance. There were miles and miles of highway where he could have veered off the road. And for whatever reason, destiny has forever intertwined these two people. For Mr. Beaver, it meant the end of his life. And for Mr. Ravnsborg, it led to discrepancy after discrepancy to show us what the Attorney General of our state was capable of, which I think is grounds for impeachment. Thank you.
Further remarks? Senator Johns.
Thank you, Mr. President. First of all, on behalf of all the members of the Senate, we send our sincerest condolences to the Joseph Beaver family. It certainly is a tragedy, and it's too bad that we have to be here today, and things could have possibly been different if other charges have been brought in this case. Second, we're not entitled to exercise unbridled discretion in this case. The Constitution's clear. There's only 5 grounds for which you can impeach. One is drunkenness doesn't apply. Crimes, correct conduct, or misfeasance or misdemeanors in office. Crimes here mean felonies. There's no reason why you would say misdemeanors and felony, crimes and misdemeanors. Crimes are limited specifically to felonies. Now, the felony that could have been charged and was charged in Governor Janklo's case was manslaughter, recklessly taking the life of another human being. If you look at the elements of Article 1, he is not charged with recklessly taking the life of a human being, nor is he even charged with negligently taking the life of another human being. He's charged with lane changing and distracted driving. They're Class 2 misdemeanors. A felony is something you can go to the penitentiary for. A Class 2 misdemeanor is $500 and or $1,000. Well, no, it's 500 and 6 months in jail or something now, but it's changed. And then there's a Class 1 misdemeanor. We aren't looking at a Class 1 misdemeanor. We're not looking at a felony. We're looking at 2 Class 2 misdemeanors that cause the death of another individual. And neither of these relate to any performance of anything that would be related to his performance in office. These misdemeanors, as used in the Constitution, must relate specifically to duties of office. They must be integral to that office. And driving while you're coming back from a Lincoln Day dinner, which is an act of a politician, somebody that wants to get elected. It's not a requirement that I go to a Lincoln Day dinner as a Attorney General. There's no requirement. That's not one of the things that I'm required to do as an Attorney General. I'm doing that because I want to get reelected. I'm going to all these places and doing a lot of those things, but that's the act of a politician. I'm going to keep my remarks as to the second article, since we'll be voting on them separately, but we do need to keep our eye on the ball, and we don't have a felony charge here. There was nothing ever alleged in that respect, and we're limited to specifically what they said in the article. And there's nothing mentioned about a crime that would qualify under our Constitution for this death. And for that reason, I would submit that we must vote that the article has not been sustained. Thank you.
Further remarks? Senator Wheeler.
Members of the Senate, as I've been contemplating this matter for a long time, I try and bring myself back to the law, to my duty to do law, to do justice according to law and evidence. That's what our oath is, to do justice according to law and evidence. And so, when thinking about this first article, I first have to ask myself, what is the law? The law is that we can only impeach for drunkenness, crimes, corrupt conduct, or malfeasance, or misdemeanors in office. Now, there's been some debate about what crimes mean. There's been an argument made that it only applies to felonies. There was an argument made by the respondents' team that it only applies to crimes made in office. I submit to you both of those are wrong. Crimes means crimes. It's a plain word that all of us understand. And any crime you commit can potentially make you liable for impeachment. Now, whether any crime rises to the level of impeachment, I'll address a little bit later. But as the definition of crime in general means any crime you commit, because if you believe the respondent's argument that only applies to crimes in office, well then someone could commit murder, not related to their office, be convicted and sit in prison, and yet still be an official of this state, because we would have been powerless to remove them. That cannot be. That's an absurd reading of our Constitution. And so I look at this to say we can impeach for any crimes. And so then I now must look to what is the law the House gave to us. The House's duty is to impeach. They submit articles of impeachment. Our question that we are going to answer to today is to sustain that article of impeachment. And so I review what the House sent to us. The House said that they are impeaching Attorney General Jason Ravnsborg for crimes causing the death of Joseph Beaver. That is all they specified. Crimes causing the death of Joseph Beaver. Now, they did specify 3 paragraphs regarding the facts surrounding that, and they mentioned 2 Class 2 misdemeanors to which he pled no contest. But the impeachment article did not limit us to just those 2 crimes. The impeachment article applies to any crimes causing the death. So I exclude crimes involving lying to law enforcement, because those didn't result in his death. Those were afterwards. We'll deal with those in count 2. But in this case, I'm only looking at what caused his death. And so in this case, I now go to the evidence. The evidence in this case was presented to me by all of the investigators who were involved clearly that he was off the road. He was off the road by all 4 tires. Now, I won't get too much into a debate about the burden of proof, except to say I believe it's correct that one doesn't exist. We set our own standards individually. But I believe that the prosecution team has proven this case by a clear and convincing standard. It's clear to me his tires were off the road. All of the science proves that. They had 3 different ways they try and do the trajectory of where the car came from. Where was the area of impact? And he was so far to the right, to the north, that it was clear that his tires were All four were across the rumble strip. And it was clear that they had been there for more than just a few seconds. It wasn't a brief swerve, because there wasn't any tire marks indicating it was a jerking motion. And so he had been there for at least more than a few seconds. And if he had been doing that, then his driving was reckless. If he had been doing that, he had lost so much control of his driving that he went all four tires off the road. This is beyond distracted driving. This is beyond careless driving. It doesn't matter, and I completely agree, at the moment of impact, he was not on his phone. But it's clear that he was on it very much shortly before then. And the Attorney General did not provide to us an explanation of what he was doing. I specifically asked the question to them because this is what I wanted to know, is why was he so far off the road? How far was he off the road? And all they can say is, they don't know. They had the opportunity to present evidence to rebut this, and they did not. They didn't provide any debating or disputing scientific evidence that maybe there's only 2 lanes, maybe just 2 tires off the road. They didn't really even try and question it at all. So only left with the investigators' conclusions that to me remain unrebutted, that he was 4 tires off the road. And when you do that for so long that you are so distracted that you don't see the individual in front of you, then you have definitely, in my mind, committed reckless driving. And if you've committed reckless driving, recklessness is a standard for manslaughter. If you recklessly kill another human being, you've committed manslaughter. That's second-degree manslaughter in our code. That's a felony, and he would very likely, I wouldn't say that, I'm not going to say very likely, because I've seen manslaughter, second-degree manslaughter cases where people don't go to prison, because there's a lot of variation in recklessness and degree of culpability. But he would definitely be charged with a felony. Now, in this case, the prosecutors didn't do that. I'm not going to second-guess their particular prosecutorial decision, because they have a different standard. They're in criminal court. They had to explain what he was doing off the road, which they can't necessarily do, or how far, or why he was on there for so long, what he was doing at the moment of the impact that distracted him. Maybe they felt there was enough question that they couldn't present it to a jury and prove beyond a reasonable doubt. I'm not going to second-guess them on that question. But to me, the evidence presented here today is clear that he was. And he was there for so long that there could be no question that he was driving recklessly. And so to me, he committed manslaughter. That is a crime. Then that gets to my final question, is whatever he committed worthy of being impeached, worthy of being removed from office? If this was just a Class 2 misdemeanor, if it was just careless driving or just an illegal lane change, there was nothing more involved, I would not find that to be a removable offense. Speeding is a Class 2 misdemeanor. It's not a removable offense. That's not what he did here today. Or that's not what he did that we are judging today. We today have seen that careless driving actually rose to the level of recklessness, actually rose to the level of manslaughter. And so we must send the signal to everybody that if you drive recklessly on a road and kill somebody, you can no longer be an official in this state. And so I ask the members of this body to sustain the article of impeachment sent to us by the House, because it has been proven to us by the law and the evidence that a sustaining vote is the only vote that should result. Thank you.
Further remarks? Senator Duhamel.
Thank you, Mr. President. All 4 wheels across the rumble strips, so distracted he did not know what he hit. So reckless. Clear, convincing, direct evidence. This is a serious offense that killed a man. I will vote to sustain the articles of impeachment.
Further remarks? Senator Dietrich.
Thank you, Mr. President. I want to thank the fellow members of the bar for them sharing their expertise and information on this, and I'm not going to be redundant on it. I just simply want
Senator,
to say...
could you try and get a little closer to your microphone?
I just wanted to say that I agree with the good senators from Lawrence County and Beadle and Kingsbury and Clay and Turner County as to Article 1 and how they look at that and the information they've shared with us. And I think that topic has probably been well explained. We've had excellent information from the investigators today and the reports that we've all had access, the hours and hours and hours that I know everybody looked at, and we took this job very seriously. I think a really important thing to me is the fitness for office. And for our chief law enforcement officer in the state to conduct himself in the manner that occurred before and after, more importantly, after the accident, in his dealings with law enforcement, in his calls to 911, and to his referencing himself using the letterhead of the state and his office to make political statements, essentially. Those things have eroded and caused the loss of confidence in our chief law enforcement officer by law enforcement throughout the state, and probably a lot of the public that we don't know. We can't really quantify that. But I think that it is up to us, and it's appropriate for us to make a determination as to the qualifications and the performance of our constitutional officers when we have the opportunity based on tragedies that may occur from the way they conduct themselves. And so it's the matter of the driving and the distraction and leaving the road is just so well settled. The other part that's really important to keep the public trust in the state of South Dakota and our law enforcement in South Dakota is to ensure that we have the appropriate chief law enforcement. And I think that this is an opportunity to make that statement clear for future generations. And so I urge you to vote to sustain number 2.
Further remarks? Hearing no further remarks. The question before the Senate is, shall the Senate sustain the first article of impeachment, crimes causing the death of Joseph Beaver, against Attorney General Jason Ravnsborg, and remove him from the office of Attorney General? Members in favor will vote aye. Those opposed, nay. This is a 2/3 majority vote. Secretary will please call the roll.
Senator Bolin? Yes. Breitling? Yes. Kamak? Aye. Castleberry? Aye. Crabtree? Aye. Kurd? Aye. Diedrich? Aye. Duhamel? Aye. Duvall? Aye. Foster, excused. Freimuller, excused. Greenfield? No. Heinert? Aye. Hunoff? Aye. Johns? Nay. Johnson? Aye. Klum? No. Kolbeck? No. Maher? No. Neseba?
Aye.
Norstrup? No. Pardon? No. Otten? Aye. Roll? Aye. Rush? No. Schoenbeck? Aye. Shanefish? Aye. Smith? Aye. Stalzer? Aye. Steinhauer? No. Sutton?
Aye.
Simmons? No. Tobin? Aye. Wheeler? Aye. Wick? Aye. Zickman? Aye. Mr. President, there are 24 yeas, 9 nays, and 2 excused.
The question, having received a 2/3 majority vote of the members elect, the Attorney General of the State of South Dakota is convicted of the first article of impeachment and removed from the office of Attorney General. We will now take up Article 2. The question before the Senate is, shall the Senate sustain the second article of impeachment, malfeasance in office following the death of Joseph Beaver, against Attorney General Jason Ravnsborg, and remove him from the office of Attorney General? Are there any remarks?
Mr. President,
Senator Rush.
I'm not going to be repetitive on a lot of the things I said before. I voted no on count 1, but count 2 is a different issue on this case. And in respect to count 2, I'm concerned about whether the Attorney General misused his office as Attorney General. You know, obviously he's a poor driver. There have been numerous incidents where he's avoided responsibilities for his poor driving by identifying himself as Attorney General. In this case, he started out by identifying himself as Attorney General and got special treatment as a result. How many other cases have received the use of the sheriff's personal car? How many other cases have received such an inadequate investigation? How many other cases have had a committee of prosecutors to decide what charges to bring? What really concerns me, though, is the fact that he was consulting with staff at the Attorney General's office about this and how to handle this matter. The head of the DCI that was involved in it, his chief of staff in the Attorney General's office was involved in that. He consulted DCI experts about the cell phone and polygraph. He put out a press release on his AG's office stationery. Although there's the argument that this was not part of his Attorney General's office, he made this part of his Attorney General's office. He directly involved the Attorney General's office in this entire matter. He affected the credibility of the Attorney General's office by his conduct. And in that, I believe that in respect to count 2, the answer should be yes, and that he should be impeached in this matter. Thank you.
Further remarks? Senator Johns.
Thank you, Mr. President. Again, I want us to look at what the elements are in the articles of impeachment. And we're talking about malfeasance. And we're talking about malfeasance while in office. Now, I understand that law enforcement lost confidence in our Attorney General right after the event and the things that did follow. And that would have been appropriate at the time for him to resign from office, but he decided not to, and that was a decision he's entitled to. You know, when you lose confidence in your elected leaders in parliamentary countries, you have a no confidence vote. Or in South Dakota, if it's a municipal leader, you can have recall elections. In California, they have recall elections for state officials. We just don't have it here. But we respect the rights of the electors as to the decisions they made and put in office. There's a huge difference when it comes to impeachment. Why haven't we seen it since we've been a state? Because of the fact that we are extremely reluctant to remove someone for office unless they've really committed major faux pas or criminal offenses or things where it's truly a misuse of office, where you're using everything that's related to office. And I can understand the arguments just made by the senator from Clay County, where he's saying that they made too much of a use of it. But then I got to look at when it comes to malfeasance and what the South Dakota Supreme Court has said about malfeasance. It says that, first of all, it has to be done in the official capacity, but that's only one element. The next element is it must be done knowingly. A third element is it must be done willfully. And finally, and most importantly, it must be done with an evil or a corrupt motive or purpose. And if you really analyze the evidence, I don't think we have any evidence here that anything he did was done with an evil or an improper, corrupt purpose. I don't see it. You know, we're asked to draw inferences. And inferences can lead to a conclusion, but inferences must be based on evidence, evidence that you're satisfied with, and then it has to be reasoned that this is something that logically follows. We don't have it here, folks. I think we had a lot of speculation in some of the opinions, and the opinions rendered by one of the witnesses as to whether he thought he was lying or not would never come up in court. The only thing you're entitled to in court when it comes to a person's credibility is I can give an opinion as to whether or not they're deemed to be credible within the community, or I can, but it's reputation. It's a reputation for being a falsifier, and I just struck. And you know, do I approve of what happened? No. I like the senator from Vermillion. I truly think that things have happened that really have demeaned that office. But is it grounds for impeachment? And I have to say no. And I understand the majority are going to go the other way, and that's okay, because that's why you have your position and you get paid the big bucks. But my position is legally it's not sustained. So thank you.
Further remarks? Senator Duhamel.
Thank you, Mr. President. The standard is honesty. As much as anything, this is about an elected official not telling the truth. Law enforcement testified that the Attorney General lied about several things. He said he was not using his phone while driving until they proved that he was. He insisted he was driving in the middle of the road and that he had to wrestle the vehicle to the side. He initially didn't offer that he had asked law enforcement what investigators would find on his phone. An abundance of evidence that the Attorney General misled or lied to law enforcement. The Attorney General has a duty to hold himself to a higher standard of personal and professional conduct. As the chief law officer, the top cop, once you're caught in a lie, how do you ever overcome that? Ever. He lost the faith of law enforcement and the people of South Dakota because of his conduct.
Further remarks? Senator Wheeler.
Thank you, Mr. President. Members of the Senate, I'll try and go through a similar analysis as the last one. I believe this one will be a little more brief. To me, the question on the law is a little more close because of the murky definition of what in office means. I tried to do a lot of research on this, and whether it applies to simply exercising, only official exercising of his official duties, and he has to do something there that would apply, or can it mean more broadly to his conduct as an official of the state? And as the prosecution team pointed out, as the Attorney General, he has some higher duties than your average official. As an attorney, he has a duty to candor, and as a prosecutor, he has a duty to be a minister of justice. And when you lie to law enforcement, you're violating that duty. There's a lot of questions about what happened in terms of what he knew and when he knew it. I don't know all those questions. I don't know all those answers. But I do know that he lied about his cell phone use. That was clearly shown by the evidence. And he minimized that conduct at first and just continued to only admit to evidence as it was presented to him by law enforcement. And so the idea that our chief law enforcement officer could lie to law enforcement, even about a small matter, and still remain our chief law enforcement officer, to me, is untenable. To me, when you are the Attorney General, you have a higher duty in your relation, in all of your interactions with other law enforcement officers. You must always tell the truth. You could have chosen to not have an interview with them at all, and that might have come with other political implications but he chose to sit down with that interview and minimize his conduct to such an extent that he lied. And we cannot send the message that our chief law enforcement officer can lie to law enforcement and remain in office. Therefore, I believe that the law and the evidence, again, bring me to vote yes on sustaining this article. Thank you.
Further remarks? Any further remarks? Hearing none. The question before the Senate. Shall the Senate sustain the second article of impeachment, malfeasance in office following the death of Joseph Beaver, against Attorney General Jason Ravnsborg and remove him from office of Attorney General? Members in favor of that motion, that question will vote aye. Those opposed, nay. This is also a 2/3 majority vote. Secretary will please call the roll.
Senator Boland. Yes. Breitling. Yes. Kamak. Aye. Castleberry. Aye. Crabtree. Aye. Kurd. Aye. Diedrich. Aye. Duhamel. Aye. Duvall. Aye. Foster is excused. Freimuller is excused. Greenfield. Aye. Heinert. Aye. Hunoff. Aye. Johns. Nay. Pardon? Nay. No. Johnson. Aye. Klum. Aye. Colbeck. Aye. Maher. Aye. Nesseba. Aye. Norstrup. No. Otten. Aye. Roll. Aye. Rush. Aye. Schoenbeck. Aye. Shanefish. Aye. Smith. Aye. Stalzer. Aye. Steinhauer. Aye. Sutton. Aye. Simmons. Aye. Tobin. Aye. Wheeler. Aye. Wick. Aye. Sickman. Aye. Mr. President, there are 31 yeas, 2 nays, and 2 excused.
So the question having received a 2/3 majority vote of the members elect, the President declares the Attorney General of South Dakota is convicted of second article of impeachment and removed from the office of Attorney General. Now, as a reminder, members of the Senate, we have 2 votes on disqualification. We will have 1 vote for each of the 2 articles of impeachment that both passed, starting with Article 1. So the question before the Senate is, shall Jason Ravnsborg be disqualified from holding any office of trust or profit under the state as a result of being convicted on the first article of impeachment? Are there any remarks? Senator Schoenbeck.
I think we're all weary of the culmination of these events that have weighed on us, so I'll be brief. I think the result to impeach has to go hand in hand with the message you send about whether that person can ever hold public office again in our state, that yes is the appropriate vote. Thank you.
Further remarks? Any further remarks? Hearing no further remarks, the question before the Senate is, shall Senator Ravnsborg be disqualified from holding any office of trust or profit under the state? Members in favor vote aye. Those opposed, nay. This is also a 2/3 majority vote. Secretary will call the roll.
Senator Boland. Aye. Breitling. Aye. Kamak. Aye. Castleberry. Aye. Crabtree. Aye. Kurd. Aye. Diedrich. Aye. Duhamel. Aye. Duvall. Aye. Foster's excused. Freimuller's excused. Greenfield. Aye. Heinert. Aye. Hunoff. Aye. Johns. Aye. Johnson. Aye. Pardon? Aye. Klum. Aye. Colbeck. Aye. Maher. Aye. Nesseba. Aye. Norstrup. Aye. Otten. Roll. Rush. Schoenbeck. Shanefish. Smith. Stalzer. Steinhauer. Sutton. Simmons. Tobin. Wheeler. Wick. Zickman. Mr. President, there are 33 yeas and 2 excused.
So the question having received a 2/3 majority vote of the members elect, the President declares the Attorney General of the state of South Dakota is disqualified from holding any office of trust or profit under the state as a result of being convicted of the first article of impeachment. On the second article of impeachment, the question before the Senate is, shall Jason Ravnsborg be disqualified from holding any office of trust or profit under the state as a result of being convicted of the second article of impeachment? Are there any remarks? Senator Schoenbeck.
Mr. President, members of the body, especially since my seatmate asked me, I'll tell you that we had no guide or no prior impeachment to draw upon in drafting these. The constitutional provision is in the disjunctive because I thought some people might want to vote one way on the first question and differently on the second question. That's why you have 2 questions, and you have 2 questions on each article, so they stand independently. And I would encourage you to vote again yes on this one. Thank you.
Further remarks? Hearing no further remarks, the question before the Senate is, shall Jason Ravnsborg be disqualified from holding any office of trust or profit under the state as a result of being convicted of the second article of impeachment? Members in favor will vote aye. Those opposed, nay. Also a 2/3 majority vote. Secretary will please call the roll.
Senator Bolin. Breitling. Mack. Castleberry. Crabtree. Kurd. Diedrich. Duhamel. Duvall. Foster's excused. Frymuller is excused. Greenfield. Heinert. Hunoff. Johns. Johnson. Klum. Colbeck. Maher. Nesseba. Norstrup. Otten. Roll. Rush. Schoenbeck. Shanefish. Smith. Stalzer. Steinhauer. Sutton. Simmons. Tobin. Wheeler. Wick. Zickman. Mr. President, there are 33 yeas, 2 excused.
So the question having received a 2/3 majority vote of the members elect, the President declares the Attorney General of the state of South Dakota is disqualified from holding any office of trust or profit under the state as a result of being convicted of the second article of impeachment. We'll be at ease for a minute. Madam Secretary.
Senator Kamak moves that the Senate Court of Impeachment do now dissolve.
Comments on that motion? Hearing none, all in favor of that motion will say aye. Aye. Opposed, nay. Motion carries. Motions and resolutions.
Senate Resolution 703, memorializing the proceedings of the Senate Court of Impeachment. Senator Kamak moves that Senate Resolution 703 be placed on today's calendar for immediate consideration pursuant to Special Rule Number 5.
Comments on that motion? Hearing none, all in favor say aye. Aye. Opposed, nay. Motion carries.
Senate Resolution 703, a resolution memorializing the proceedings of the Senate Court of Impeachment. Senator Kamak moves that Senate Resolution 703 be adopted.
Is there a second? Comments on that motion? Senator Schoenbeck.
Mr. President, members of the body, the resolution memorializes the actions taken by the Court of Impeachment. Thank you.
Any other remarks? Hearing none, the question before the Senate is adoption of Senate Resolution 703. Members in favor will vote aye. Those opposed, nay. Secretary will please call the roll.
Senator Bolin. Breitling. Kamak. Castleberry. Crabtree. Kurd. Diedrich. Duhamel. Duvall. Foster's excused. Fry-Mueller excused. Greenfield. Heinert. Hunoff. Johns. Johnson. Klum. Kolbeck. Maher. Nesseba. Norstrup. Otten. Roll. Rush. Schoenbeck. Shanefish. Smith. Stalzer. Steinhauer. Sutton. Simmons. Tobin. Wheeler. Wick. Zickman. Mr. President, there are 33 yeas, 2 excused.
So the motion having received an affirmative vote of the majority of members elect, the President declares the motion carried and Senate Resolution 703 is adopted.
Mr. President,
Senator Kamak.
I would like to take a moment to congratulate you and thank you, everyone, whether it was staff or prosecution or the defense or the members of the body and the members that were in the gallery. I felt that today everyone was treated with respect and with civility, and that's no minor task to accomplish. Today, we did make history. Like I said earlier, there were no winners today, but we did our business, and thank you for your hard work.
Senator Schoenbeck.
Thank you, Mr. President, members of the body. I want to join in on a couple of points. First, the staff in this Reed and John and Hillary and Isaiah, they were jumping without a parachute. You know, they had to create a way to land on the way down, and I don't think we should underestimate. And Sue is probably busy working somewhere. All these people, the work they did and the hours they put in, you just really can't imagine how much. And then on a different level with the members of the body, I just want to say I was so impressed by I could tell in the days leading up, the readings that people were doing and the time they were putting in and the efforts they were making and the questions they had, that people took their job seriously. And I know that a number of people here had very close relationships with the Attorney General, and that's not an easy thing to set aside and do your job. And I don't think anybody that's not here on this floor can really appreciate what all of you did and the difficult decisions you weighed. Regardless of whatever decision you finally reached, I know that everybody worked so hard and so thoughtful, and I just want to say on behalf of the citizens of South Dakota, thank you.
I will take the opportunity to also pile on. You know, this has been a pretty incredible process, and for me it was quite an eye-opener to work as closely as I did, I think, for the first time since I was in the legislature with the LRC and with the staff, with Boots, you know, all of us working on a process that we were making it up as we went. And I also want to say a special shout out to Matt Michaels for coming alongside me through this process. I've had a pretty challenging time in my personal life and a lot of things going on, and don't know quite how I would have dealt with that all had it not been for Matt taking the pressure off and helping me make the decisions and pointing me in the right direction, and all of you. And I'm very proud to be part of this chamber. Any other remarks before we go back to the Secretary? Thank you all. Madam Secretary.
Senator Kamak moves that when we adjourn today, we adjourn to convene at 10 a.m. on Wednesday, June 22nd, the 4th legislative day.
As a matter of clarification, we tried to get it to 9 and the House is not going to come in until 10. So we would just be sitting here, so sorry.
It's 10
do I
o'clock.
get to announce
the motion is 10 o'clock tomorrow.
Do I get to order Schoenbeck to stand down? Motion has been made and seconded. Is that correct? Comments on the motion? Hearing none. All in favor say aye. Aye. Opposed, nay. Motion carries.
Senator
Hold on.
Kamak moves that the Senate do now adjourn.
All in favor of Senator Kamak's motion to adjourn will say aye. Aye. Opposed, nay. Motion carries. Senate is adjourned.